Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
You are listening to the Roberto Glass True Crime Report, putting the true back in true crime. From New York City, Roberto Glass is now on the record.
Okay, good morning. How is everybody? Guilty. I like that. I love the optimism. Hello, Betty Clark. Hello, Ruth Lang. Hello, Kay Sarah, Deb P, Vanessa Rich. Hello, everybody. Chris Robinson. Good morning. So hey, Taterbug. I think there's some confusion about last night's 6 o'clock show. So what we're doing is we're analyzing Karen Reed's innocence fraud campaign and the effect it's had, because we know that we're following just the evidence, not the propaganda in this case, just the evidence. So what is evidence? Anything testimony. So I'm not just talking about physical evidence. I'm talking about testimony, right? That's evidence. Anything presented to the jury in court. And what has been presented to the public is very different than what's been presented to the jury in court. So what is fed this innocence fraud propaganda campaign is a lot of falsehoods. And that's what I was talking about, why it's so important to counter it with just every detail matters in these stories. And what a good propaganda campaign does is obscure all the details. Right? Hey, Taterbug, Deb P. So that's what I was talking about. And, there is some spin. The closing argument is not evidence. It can't be used against the Commonwealth. I don't know if there were real mistakes or spin or what, or condensing the story, or I don't know. But certainly that didn't happen. Karen Reed did not hang up. I mean, it's the thing that everybody's talking about in closing argument. I never realized that she hung up when she said, "Oh, you were you were in front of my sister's house." No, it never happened. It just didn't happen. It's okay. It's not evidence. Jury wasn't taking notes. Can't be taken as evidence. But that's just not the testimony from Carrie or from Jen McCabe. She hung up on Carrie Roberts, probably because Catherine Camerano was calling her back. She just pivots. And I want to talk about her panic when she's coming to. Who says Carrie, Jen? I mean, she's faking panic. It's a hollow panic. I mean, that's not a real panic. Carrie. Jen. She's just trying to get them in a fear state. Get your attention, right? Why do you call someone's name? To get their attention, right? I need your attention. I need you in a fear state. Get in this frenzied panic state. See, I'm in a panic. I don't think she was in a panic. I think she started planning right away, or cover up, whether she fell asleep and woke up it may be that she may have been up all night and on her laptop thinking about how she was going to do this. But she sure involved a lot of people when all she needed to do was go back to the scene and call 911. That's quite a different story. How do you spin that? I left him here, my taillight pieces, no one else is involved then. And you can only put the finger on Karen Reed. So she involved a whole lot of people, so she had an option of who she was going to point the finger at. And who did she point the finger at? The person who was the biggest threat. Jenna McCabe, the person with the best memory, the person who was the least traumatized. I'm not saying she wasn't traumatized. I'm just saying that her memory, there's like a strength in Jen McCabe. She's not going to be pushed around. She's not going to be manipulated. So she had to be villainized. That's how I see it. Let me know how you see it. I can be persuaded. You know? But it was a brilliant closing. I'm not saying it wasn't. I'd say probably one of the best closings that I've ever seen in my life. That Hank Brennan did. Thanks, Deb P. But, you know, it's important for the innocence fraud campaign, not for the verdict, not for just to separate fact from fiction. Some people took very badly to it. That's okay. Not everyone has to like me. Okay, here we go. Like me or like this. Or like this podcast. Thanks, Tanya. Just drinking some coffee. I'm waking up slow this morning. This is, you know what I was looking at last night? Maybe you guys can help me out. I hope I bookmarked it because I was looking at it like a million times in a row. Yeah, here, I did bookmark it. Good. Just instead of looking at a fan. I know you all want to look at a fan. But this is the moment where Karen Reed realizes that her lying lawyers have betrayed her. And there's now this little charge on here that could be, if combined with basically vehicle manslaughter, they chose just those two things and didn't convict on murder too. Not that I'd want that. I want her guilty on all, everything. I want everything, of course, like everyone else. So, but look, anybody read lips? Check this out. Here's Karen Reed talking. This is rare time she didn't hide her mouth in court. Check this out. So she realized that last year, if they had kept that very small driving under the influence charge, like it's a very, very tiny charge, if they had that, they saved that for this trial. Adam Lally and Lori McLaughlin. If they had that, they could have just convicted on that. And maybe they wouldn't have retried her. That's Matt Topanic's thoughts. Maybe something else that she's upset about. We don't know. But check her out. What do you guys think? What is this about? What is she saying? I was watching this like a million times, and I love Peggy O'Keefe's face. It just it's like it's so satisfying to watch. Like Karen Reed being such finally, someone outsmarted her.
Because you weren't in the thing.
Yep, it's just like, too bad, Karen. You didn't think of that one. You didn't think of that one. Your lawyers didn't think to have that on the jury form last time. Whoops. What else can I show you? Let me see. Oh, this was D&E Pizza. Look at this sad scene. They're still protesting. These people, you know what I mean? This feels tremendously passé to me. Like, really, these people really are really still calling these people murderers? And really? Do they really believe it? Looking at this timeline from Friday, 7 unanswered calls from defendant, and then look at the temperature going down, how effective that was. And it really shows you how every second, every minute isn't so important, and every decision that she did. How much time do we have? Let me see. You can watch some of this closing. Let me know. I don't know. Is it getting monotonous? Are you tired of watching it? I don't get tired of watching it. Hank Brennan's closing. Let me know if you were tired of it.
Ever. Yeah. And Timothy Nettle remembers speaking to the defendant. I hit him. Remember, he's on his knees. What happened? I hit him. She is now coming to terms with the moment. Her fear is realized. She hit him. She clipped him. She didn't think he was mortally wounded. She panicked. She can't come to terms with this, so she has to bring people with her to face it. And now she's facing the reality of what she had done. And her emotion is overwhelming. I hit him. She speaks to Miss McLaughlin. I hit him. Not did I hit him? Could I hit him? Perhaps I hit him. That was earlier. Now she's wrecked.
Look at Ingrid. Ingrid's face. This is Karen Reed's good friend, the blonde in the white shirt. Look at her side-eyeing Hank Brennan during this.
Recognizing what she did. I hit him. And these people are making it up. Anybody that says anything adverse or inconsistent or inconvenient is a liar or a perjurer or in a conspiracy. Or is it that these good people who went there for a total stranger to do their duty to help happen to remember that she admitted what she had done? I know that doesn't reconcile with the boogeyman Proctor and the bad government. I know it doesn't reconcile with no DNA on this piece of that piece. I know it doesn't reconcile with everybody setting up the girl. I know that doesn't reconcile. But the reality is you have independent core people who hear her say, I hit him. And the attempt is to portray everybody as a liar. But you don't have to rely just on these good people, although you should. You should. You don't have to, because we have a guide, and it's Karen Reed. Slide 17.
Say this. Today, I always say, you know what?
Did I really say this many times as law enforcement's Quint has said it?
Thank you.
I know I said I hit him, and it just seems like Ingrid, who was called that morning, Karen Reed, started her cover-up, knows it's the truth. It's like she's trying to fake disdain and resentment. Here's a compilation of, wait, hold on, let me see. This has music. Oh, it has music. Oh, darn. Let's see. Are they going to shut the stream down if I play this? David Unetti saying Karen Reed's guilty very early on. Check this out.
Is devastated at what happened, and my client has no criminal intent. She loved this man. She is devastated at what happened, and my client has no criminal intent. She loved this man. She is.
It goes by so fast, right? You almost would miss it. Oddly, did anybody else see this? I wonder if I bookmarked it. I know I sent it to my friend. Why was Karen Reed wearing no shoes? I know she was complaining about her outfit being arrested the second time. But here she is getting arrested. Let me see if I... Oh, here, I can play this now. Have you seen this clip of John O'Keefe that Jackie Dugal put out? Her husband's the one who goes, she did admit it. How come you admitted it? Yeah, like 3 or 4 times she admitted it. No, I'm making a like New York accent, not quite. Still haven't perfected my Massachusetts accent. She did. She admitted it. Like 3 or 4 times she admitted it.
No, too many chins. Too close, too close.
John O'Keefe. She wrote "Justice is Coming for You." I hope so. I put that picture on the thumbnail. Let's see what else. What else do I have for you this morning? Oh, this is so good. Let's see. Let me see if I can show you this. Weird. She's like, she has no shoes on when she's... There's like video of her being arrested and she's walking without shoes. Why? So odd. I'm going to throw up if I have to listen to Daddy Reed and his tales one more time. Let me see. Yeah. Wait, hold on. Yeah, I think Grant put it up, reposted it. Hold on one second. Yeah, here we go. Whoop, 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 whoop. Why was she without shoes here?
She's so cool. All right. Oh dear. Oh, there she is. She's so cool. All right.
Yeah, upstairs. How much you got?
I mean, if Karen Reed weren't good looking or photogenic, would we even be here? Would she have been convicted last time? That's my question for this morning. Hey, Debbie Martin. Me too. Me too. Hey, Jebby James. Thanks for giving out 5 memberships. They'll be handed out at random amongst the chat. I really am hoping. I'm not trying to be a downer. I've been on the losing side of a lot of innocence fraud campaigns. I assume they're coming in, Manny, at 9. Assume they're just getting in from the weekend. They asked to go home early if you haven't been up on what's all been going on. Judge Cannoni asked them to come in early. Then she started late, and they were exhausted. By the end of the day, by 4:30, they wanted to go home for the weekend. So they said, we want to go home, and we'll come back Monday. And she said, okay. So we're waiting for them to come in. I'm waiting for, I don't know what they're going to do with the Zoom feed. Signed in. I don't know if they're going to show the inside of the courtroom from Zoom now that the trial is over during this phase. But I will be here with you all until we get a verdict. Oh, that's so sweet, Andrea. Hi, smart beauties. I appreciate any bit of positivity, guys. This is like, this has been years and years and years. I've been talking about the same case. I'm waiting for justice. The first trial was very a letdown. The more time goes on, the more I appreciate Adam Lally, I have to say. I've grown to really have a deep love and respect for him. An appreciation for his lawyering, his great lawyering skills, and Laura McLaughlin. And I feel like there was maybe a missed opportunity that this Commonwealth team didn't work as a team. We wouldn't have had that, what I feel is pretty much a mistake with it's a small thing, but, with the jacket, the defense is going to blow it up with this, not jacket, I'm sorry, a sweatshirt, excuse my language, sweatshirt. I'm still waking up here. It's just another thing they can exploit and point to, that the Commonwealth is corrupt, et cetera, et cetera. But so that was a letdown to have to do this all over again. And then we geared up for the next trial, and it started. And we had a whole new prosecutor. It was a very different trial. We saw a lot less testimony. Oh, here we go. Sounds like they're coming into the court here. Right. Sooner or later, yeah. I'm hoping she'll get convicted. And even if she gets, not acquitted, I hope they don't fall for the...
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Cannoni, the Justice of the Superior Court, holding in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Good morning, counsel. Good morning, Ms. Reed. Good morning, jurors. Good morning, alternates. So I have to ask you those same questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left here on Friday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here on Friday? Everyone said no or shook their head. So, Mr. Foreman, with that, we're going to send you back out to deliberate. Okay.
All rise to the court, please. Please follow me.
Hey, your latex spouse says, while I worked last night, 3 a.m. came around and I wondered if Karen Reed was losing any sleep. Haha, I damn well bet she was, y'all. She left the courtroom without saying anything. She didn't want to talk to the press, which may tell you she's not so optimistic.
Jury's exit the courtroom. Please be seated.
All right, so Mr. McDermott handed me something that I'm going to go read. All right, and we'll see you. Court officers will give you instructions on where to be and no more than 10 minutes away, okay?
Your Honor, with regard to the version that was sent to the court.
I don't, the version of whatever I have not yet read?
Correct.
Okay.
No, I want to flag for the court. We'd like to replace that. We noticed some errors. There were different versions that were circulating amongst our team, and we believe the incorrect version got filed. So we would, if we have 10 minutes, we can file the correct version.
Okay. Has the Commonwealth seen whatever it is that Mr. Iannetti's talking about?
I just received it in the courtroom. They may have sent it earlier. I just looked at it a couple minutes ago, so I need some time.
Okay.
We'll make sure he has the updated version as well.
Okay. All right. Thank you.
All right.
Oh no, are they asking for another mistrial? Are they asking for another mistrial? They seem desperate for a mistrial. Do you know what that was about? Does anybody know what this is about? The defense gave something to the court, and I'm wondering what it's about. Let me see. Let me catch up with my messages. Maybe someone said it to me. Two competing documentary films. Apparently they're both interviewing Aiden, I guess. I think he's with Sandpaper. Here's Aiden talking about it. Let me go back. Hold on.
The fuck out of here.
Oh, sorry. His
filming
language.
a documentary during the second trial. So there's
language warning. He's got a potty mouth.
two documentaries going on right now. There's mine. You see my guy Ray, the cameraman, follow me around sometimes. He's great. He's awesome. You'll also see Zora. Zora from, do we have a picture of her? From Sandpaper. Zora cut, what's her name? Kuetner. See if we can, I want to give you a warning about her. Okay. Yeah, this chick. So I saw her the other day outside the courthouse. I just want to warn people about her, who she is. And I want to like say something to her when I see her next. So this woman, I think she's got like red hair on. She had jeans on the other day. She's the producer of the Pro McAlbert documentary that's going on Netflix. Okay. She works with Krusty, Jen McCabe. Fuck her. If she asks you to.
So Kate from Masshole Mafia is somehow profiting from a documentary. I don't know if Jen McCabe is. I don't know. I don't know what they're getting paid, if they're getting paid.
Do an interview, tell her to fuck off. That's what you should do. Fuck off, because she's creating McAlbert propaganda and she can get fucked for that. Seriously, get the fuck out of here. Get the fuck out of here with your cop killing bullshit propaganda, Zora. Nobody wants you here.
Nobody wants your. We're for the original cop killer. We're trying to get the original cop killer off.
Go back to fucking England. Nobody wants you here in the States. We don't fucking like you. Okay, get the fuck out of here with your bullshit. Your bullshit, right? Compelling Pictures gave them an opportunity to work with us, and they turned it down. And they want our people. We have David Yannetti. We got the Reed family. We got me. We got Microdots. They have our rights. They have exclusive rights to us. They can't interview any of us, right? And
oh wow, who would want to watch a documentary without Microdots or Turtle Boy or David Yannetti or David Yannetti? They have exclusive rights to David Yannetti and Microdots and Turtle Boy. Oh, this stinks of loserdom.
And she's there the other day, and she's like asking, "Hey, can we film? Can we film you guys?" No, you can get fucked. That's what she can do. If she comes up to you and asks you for an interview, oh, you want to be in the Netflix documentary? No, I don't. I don't want to be in your shitty bullshit, fake ass documentary. And where are all the blue people? Where are all the?
Let's just try to mock the actual truth of the real facts of this case. Call it propaganda. Turn everything on its head. This is what innocence fraud campaigns do. Accuse the other side of everything they're doing.
Where are these bitch ass motherfuckers who claim to like John O'Keefe so much? Where they at? Where's the Smurfs? Is Judd Welcher the only Smurf in this town?
This may be too early in the day for this. For me. Just for me. I can't take much more of it. I can only take so much of that. How do I know she didn't hang? Here's some comments from last night. I'm confused why you're certain that she didn't hang up on Jen. Do people listen? Do people listen to the show? Am I gonna have to go over this again? I guess maybe I'll play Jen McCabe's 2 testimonies this morning. We can listen to them. Didn't Jen say it was hectic and there was more than one phone? Yes, but she didn't hang up on Jen McCabe. She hung up on Carrie Roberts. How do you know she didn't hang up on Jen? I thought Jen said Karen did hang up. Carrie Roberts, she rang and said, either Carrie, John's dead, or John's dead, Carrie. It depends on which version. Our memories are not a tape recorder. They're elastic. But, here, Cat loves Dreaming Peaches. Listen to the episode again. I'm not sure. I feel like people are coming in in the middle of my episodes. And I'm obviously not repeating things enough for people who are coming in the middle. Someone said here, there's another thing. I don't think it really matters much. Jackson lied for an hour and a half. So no, it doesn't matter for the verdict. Obviously, it's not any of its evidence. It matters for the propaganda campaign, for the story in the public domain in people's heads. So yeah, I really don't think it matters much. Karen hooked up on Carrie after Karen said he got hooked with the snow pile and then hung up. Don't think it matters much. Doesn't matter for the verdict. They can't use it. It's just now we have so many people convinced that, it's changed the narrative in the public domain. And this is what we're competing with. This isn't just unfortunately, I would be totally convinced that we're going to get a guilty verdict if we only had the narrative. We didn't have the press behind this innocence fraud campaign, this false narrative going out that she's somehow an innocent woman being framed, put out. We wouldn't really have much to worry about. But I thought it was wild. She was like, I want to pick the alternate jurors myself. Oh my law. That was wild. Wild, wild, wild. Some wild stuff. Here's Karen Reed, an AI picture of Karen Reed, or someone who looks a little like Karen Reed with a rock. So I like that people are getting behind murder too on this side of the fence. I appreciate that. For a while we had, I don't think she meant to do it. Doesn't matter if she meant to do it. Although I think she did. I think it's more of a first-degree murder crime, but okay. I think there's no way that she didn't intend to, the way she moved the wheel into him. Just the anger that can be inferred, as Hank Brennan said. Just her personality. It's the way she is. I think she wanted to teach John a lesson. I don't think, she didn't like the power dynamic of John leaving her. Should we listen to Matt Typanek is live? Why not? Why not? Let's see what he has to say. Shall we? I'm going to go back to the beginning. Okay, so since I appreciate that he's doing this, we're going to be about 10 minutes behind.
Today is day 2 of the deliberations in the Karen Reed case. And I got a lot of questions about the verdict form, so I wanted to discuss, as well as deliberations. All right. Count 1, second-degree murder. The choices are, number 1, not guilty, or number 2, guilty. Very straightforward. There's no issue. It's either yes or no. It's either guilty or not guilty. Page 2 is where it gets complicated because there's a lot of lesser included offenses. So, because Judge Cannoni, and this is a personal preference, Judge Cannoni is a defense attorney, a former public defender, so she always puts not guilty first when it really shouldn't be at the top of the page because it kind of confuses the jury. But as you know, the second charge is motor vehicle manslaughter. That's the most serious offense. If the jury finds that...
What? Not guilty is at the top of the page? Talk about, she's done everything to get Karen Reed off. I love that the free Karen Readers hate her and think she's so biased towards the Commonwealth. When there's just like anything that there's anything, like even the most ridiculous, barely applicable case law to support some defense motion, she'll grant it. She's a former public defender. You hear that? I just want to hear that again. I'm sorry. Sorry, guys. I'm going to stop interrupting.
As well as deliberations. All right. Count 1, second-degree murder. The choices are, number 1, not guilty, or number 2, guilty. Very straightforward. There's no issue. It's either yes or no. It's either guilty or not guilty. Page 2 is where it gets complicated because there's a lot of lesser included offenses. So, because Judge Cannoni, and this is a personal preference, Judge Cannoni is a defense attorney, former public defender, so she always puts not guilty first when it really shouldn't be at the top of the page because it kind of confuses the jury. But as you know, the second charge is motor vehicle manslaughter. That's the most serious offense. If the jury finds that charge has been proven beyond a reasonable doubt, you check that box. But that's not the only charge on that page. There are also what's called lesser included offenses. Lesser included offenses have very similar elements. So if you can only convict for one of those offenses on the second page, you can, since motor vehicle manslaughter or murder 2 have different elements, you can both convict the same, you can acquit the same, or you can convict one and acquit on the other. That's important to understand because people are thinking, well, motor vehicle manslaughter, it's also a death. It's like, no, there are different elements, 2 separate charges. What happens on one doesn't necessarily need to happen on the other. So what you can only do on page 2, you can only check one charge. So one number. So it's 1 through 5, not guilty, guilty of motor vehicle manslaughter, guilty of involuntary manslaughter, guilty of motor vehicle homicide, felony OUI, liquor and negligence, and misdemeanor OUI. So of those 5 numbers, only one box can be checked. Only one. Because it's the 3 lesser includeds are lesser includeds of motor vehicle manslaughter. You can't be convicted of motor vehicle manslaughter and also misdemeanor OUI. There's only one thing you can check. So this is where a lot of the people, so I posted about this on Saturday, right before my daughter woke up. I actually thought about bringing her onto the show, but I think she wanted to get her diaper changed or go see mommy or something like that.
Yeah, it's not a good idea to bring your kid on the show. Matt, I know babies are really cute, and I know parents get really proud and want to show off your kid, but you don't want to show off your kid in front of these dangerous people. It's not a good idea. I'm glad you didn't do that. Kitties, 1993. Roberta, I can't believe we are here again. I think she will get charged with something unless another hung jury due to free Karen Reed, right? Unless there's a stealth juror. That's the scary thing, right? These stealth jurors. Jury asking to go home felt ominous due to first trial, didn't it? My friend said, oh, don't worry about it. They're just exhausted. You know, had Judge Cannoni had the lawyers come in early and just say, you know, get here 10 minutes early, everybody, they might not have felt like they were entitled to go home early. And they could have done what they needed to get done early and bring the jury in late. But, you know, to make them wait, you know, she makes them wait. Jury's asking to go home felt ominous due to first trial. That starts daily. I just remember when I was a jury, I hated waiting. You know, you don't like waiting out. It's not fun waiting. For us, we had no jury deliberation room. We had to wait out in the hallway. And I mean, we'd watch the defendant walk in every day, right past us, as we sat there waiting to go in. And sometimes they'd keep us out there. Not a lot. She was pretty good. The judge was pretty good about it. Wasn't a Cannoni. But sometimes she'd have us waiting out there an hour and a half. And you're like, why did I come in? You know, all this effort to get in, you know. Anyway, back to Mad to Panic.
Or just be held by me without a camera. So when you are, so there's a lot of discussion online. It's like, oh, wow, what about this? Like, yeah, misdemeanor OUI is a possibility. So this is where it gets interesting. So the jury could find her guilty of motor vehicle manslaughter. That's it. End of, they could check box 2, over. They could check not guilty, over. Or they could check box 3, involuntary manslaughter. There's only one. There's 5 options, 5 numbers. You only get to check one, and then like was 0.08 or higher. So that's a possibility, or it's just impairment to be able to prove whether the individual was under the influence of alcohol. So that's where it gets interesting, because in the first trial, as far as I could see, I was shown the verdict form, there is no misdemeanor OUI in the first trial. So that's where it got interesting, and people picked up on this over the weekend. Because content creators and supporters of the defendant wanted to get to have that moment on the courthouse steps, vindication, I'm a victim of a cover-up, thank you for the jury, this, that, and the other thing. So now, that could have happened in the first trial. If they had put that misdemeanor OUI in there, it's possible that the parties, not knowing what it actually truly meant, the juror members, might have been like, well, she was drunk. I don't know if she hit him, but she was certainly drunk. We could all agree to that. They could have been like, yep. And if they were actually truly decided 12-0 on charges 1 and 3, they could have been not guilty, not guilty. The case would have been done. So you would have got misdemeanor OUI, and there would have been no retrial. And a lot of people are now, a lot of these content creators looked it up. It's like, oh my God, Massachusetts OUI laws are tough. Like, yeah, it's not a slap on the wrist. It would be certainly a lot less than getting convicted of second-degree murder, which is mandatory life, or motor vehicle manslaughter. That's punishable by a minimum mandatory of 5 years. So let's just go through page 2 real quickly. If she is convicted of motor vehicle manslaughter as charged, it's a minimum mandatory 5 years in prison, punished by up to 20 years in prison. My guess is if she were convicted of that, Judge Canoni would give 10 to 15. So it's not like you do 3 years on that. No, Massachusetts doesn't work that way. If it's 10 to 15, you serve a minimum of 10 and a maximum of 15. So 10 years is when you're eligible for parole. Same with murder 2. You are, there's life with the possibility of parole. And the way Massachusetts sees it is they see a life sentence as 30 years, and you're eligible for parole in half that time. So after 15 years, the defendant would be eligible for parole if she were to be convicted of second-degree murder. And now, as to involuntary manslaughter, that's where the jury might kind of have issues, because involuntary manslaughter is more of a lesser included of murder 2. Motor vehicle manslaughter technically fits, but it might have been better on page 1. But I don't know if they would go involuntary manslaughter, just simply because if you either believe that she did it or there's no collision, I think you'd have to, by sheer common sense, convict of something more serious. So then it comes to what I think is the charge that the jury is going to be looking at. I believe it's number 4, motor vehicle homicide, felony OUI, liquor and negligence. So this is the final charge, the lowest offense the defendant could be convicted of, with them determining that there is a collision and that Karen Reed's vehicle collided with Officer O'Keefe and caused his death. Not saying she intended to do it, not saying she created a reckless environment, none of that. Her car hit him, he died. She was drunk. That's it. That's all that's needed for motor vehicle manslaughter. Motor vehicle homicide, felony OUI, liquor and negligence. But that charge has teeth. That's a minimum mandatory of 2.5 years to up to 15. And again, Judge Canoni is well within her rights to give the same sentence she'd give on a motor vehicle manslaughter, 10 to 15. So that's kind of that second page. The jury is going to have a real hard time getting past. And then, of course, the final charge is just misdemeanor OUI. And I remember David Yannetti seeking the lesser included offenses. And this one is one that wasn't there last time. So now it's part of this case, because I think the Commonwealth is like, if we can't get anything better than misdemeanor OUI with as perfect of a case as Hank Brennan could have tried, given all the facts, especially all the bad facts in this case, that's all you're ever going to get. It's not going to get better. The jury pool has been too tainted to the point that we're just wasting money, and we're just banging our head up against the wall, and it's just not going to get any better. But misdemeanor OUI has teeth. It's not like it would be a slap on the wrist. It would certainly be a lot less if the message it was sending that officer that it wasn't proven that Karen Reed was responsible for the death of Officer O'Keefe. That said, is they still have the civil case, and that's a much lower threshold, one that they should easily be able to overcome with pretty much the same case. But a conviction here, essentially a motor vehicle homicide or higher, guarantees that they can prove the other case, the civil case, against the defendant. but it's still misdemeanor OUI is still is punishable by up to 2.5 years in jail. It's not nothing. The defendant would, since it's a misdemeanor, it's not we'll remand you or you can stay out of jail. No, your sentence is done on the spot. So it's either remanded pending sentencing, or you're going to be sentenced on the spot. And Judge Cannoni, given all the facts, she's not going to be like, well, I think I'll give you a continue without a finding or just probation. No. She has watched the defendant in court for 2.5, 3 years. I don't see a situation where she doesn't get incarceration, even if that. So when you see people, because if you've seen over the weekend since about Saturday, after I posted this, the narrative online has changed. Now it's talking about misdemeanor. Oh, she wasn't drunk. I was like, whoa. I thought this was a conspiracy. Now there's no collision. Now you're saying she wasn't drunk. It feels like it keeps changing. And it's like, it's been well established.
Sorry, it doesn't feel like it. It has kept changing. It's been Brian Albert, then Brian Higgins, then I don't know. Jen McCabe somehow is still, I don't know. We still have people. This is what happened with West Memphis 3. They went from one grieving father to the next grieving stepfather. I still have people that haven't seen like the second documentary. So in the first documentary, they went to one. Second documentary, they went to one grieving stepfather. The third documentary, they went to another. So they went from totally, they used to just ridicule you. I don't know how many people know the West Memphis 3 case, but they used to ridicule you for saying that Damien Echols was into the occult. No, he's a Buddhist. What do you think that he's also a werewolf too, blah, blah, blah. And now that he's gotten out and he's done nothing but dedicate his whole life to the occult, filmed out, it's not, you just can't deny it. There's just, they got all his books from prison. Almost every single one of them was about the occult. He didn't pay. See, what happened is he didn't pay his, this is a great interview Ed Opperman did. He didn't pay his storage fees for all the things they put in storage. So when he got out of prison, they just put all his things in storage and they didn't pay the fees. So, there was like really explicit pictures of his wife and, very disturbing things were found, drawings and stuff. The way that they got to portray Damien Echols as like, Mr. Everyman was something else. That guy is setting fires, killing animals, torturing animals, that kind of stuff, getting into fights, in mental hospitals, filling out forms to the government that he was a sociopath or psychopath. But they made him as like Mr. Everyman, and everyone else was just like satanic panic. So it's still the narrative that we made a dent in it. When I first started talking about the West Memphis 3, I think that was my most downvoted thing I've ever done in my life. Got a lot of attention for a tiny channel that I had at the time. There were no pictures. You can go back to my I think it's my first video, West Memphis 3 Solved. And you can look at the comments on there. And the worst ones that are just pure insults, I removed. You're going to just like swear at me and insult me. Your comments can be removed. I'm not keeping up those comments. Sorry, guys. I'm not going to take abuse. But yeah, so they just move. This is what innocence fraud campaigns do. They move when one narrative doesn't work, they move to a next. And there isn't a narrative that uses all the evidence in this case that even fits an alternative narrative. And I hope that jurors figure that out.
The defendant's
Anyway, I just got a call from Tom Murtati, he's one of the great civil trial lawyers. I've had him on before. I'll tell you what he said about Brennan's closing argument and how he does closing arguments. It was fascinating short little conversation.
Own words, as well as the retrograde extrapolation, are strong circumstantial evidence she wasn't intoxicated. Weak pours, like how they watched all the drinks being poured. It's like any rational person would know that that individual was impaired. And with the retrograde, so she can't be convicted of more than one charge. That's incorrect. There are 3 charges. She can be convicted of the first charge, the second charge, or the third charge. First charge being murder 2, second charge being motor vehicle manslaughter, third charge leaving the scene of an accident involving death. So that's what. So it's wholly independent. That's only if she gets acquitted or they of second degree murder. If they acquit on that, they can still think of it as 3 separate cases that were tried together. 3 charges. Just because you're acquitted of second degree murder doesn't mean you're acquitted of motor vehicle manslaughter. But as we saw from the first jury in the first trial, they kind of put the 1 and 3 together because leaving the scene of an accident involving death includes a knowing element. So if she's not convicted of one of the offenses that involve the collision, she's not going to be convicted of leaving the scene of an accident involving death. They never talked about the 227 Google search. That was a joke. He said it during Alan Jackson said it in opening, and then he just kind of like, well, we're just going to pretend it didn't happen. We're not going to talk about it. Jury picked up on it. He said it. They introduced it. They tried like hard to discredit them, and then they didn't try to disprove it. So that Google search did not occur at 2:27 a.m. And that's their biggest. That was arguably their biggest piece of evidence.
Right. That was the thing. That was the thing. They had T-shirts. 227 Google search. I had my own T-shirts. You know, I say it again, but I had to get rid of my entire. I have to start again from scratch. Buy whole T-shirts. Because people just weren't getting them in a timely fashion. So I'm going to have to create a whole nother store. Ay. But if I decide to do it, I'm not sure. I'm not sure what I'm going to do with T-shirts, if I'm even going to do that again. But you know, I had like a competing T-shirt. How long till Karen Reed, 623, 624? How long till Karen Reed gets convicted? How long? But I mean, that was the thing they hung their whole conspiracy on. And that fell apart, and they're still going. So it's not based on any kind of real evidence. It's just a bunch of why come no bruises? Well, was brain is bruised? Well, body bruises. It's only, move the goalpost. First it's bruises, then it's body bruises. It's an odd way he was clipped. Most vehicle accidents don't happen in reverse. Aren't clippings, clippings on the side, and he spun out. Their own. I was shocked that they did that the ARCA experts reenactment looked so much like the Commonwealth's case. I was shocked because they went to such an effort to make sure that nothing really replicated that by using dummies that were not as big or not as heavy or suspended or boy. These accidents are chaotic. I mean, has anybody ever tripped or fallen and you realize that like odd things are hurt? I told you I broke my pinky finger falling during COVID. You don't think, because I just all my body weight landed, I guess, on my pinky. I was not going to the hospital to get that checked out. So I was just like, old school style, it's COVID. I'm not going to the hospital risking COVID. There's not much you can do for it. I just did it myself. And it's fine. Doctor said it looked great. I did a great job. So, I just put a little splint on it. and it healed, but it was gnarly looking. So yeah, you don't know. Why is her pinky broken when she fell? Why not her knee? Because sometimes you fall in an odd way. I mean, things are chaotic.
For this so-called conspiracy. Why do you think so many YouTubers and lawyers are on the conspiracy money? Why risk your reputation? So this is, I think your question is kind of rhetorical, Andrea. So what has happened, and I've said this a bunch, people who rely on this for their business, for their like income. I have a law firm. I have my own clients.
Right. It's been hurtful. It's been hurtful to take this position. A lot of people unsubscribe. You just don't have as big an audience base. So you're not getting the views. The truth doesn't get the views. And then if you take the opposite side and then you move on to something else, people don't remember that you took this position. Some people will, but most people don't. Most people don't look in your back catalog. I'm always shocked at the people who said, well, why aren't you on the Free Karen Reed side? I'm unsubscribing. I was like, you obviously didn't look at any of the other work I've ever done. You're never going to see me back. I mean, back a killer on this side of the aisle. You're not. I'm not made that way. I mean, it's got to be, I don't know. I've never seen a case like that. Some accused, wrongfully accused killer that has a huge innocence fraud campaign. I've never, or not even innocence fraud, a huge campaign. That's a real case of wrongful accusation. I just haven't seen that yet. We're talking about Wendy Adelson. Why isn't the government, why isn't the state charging her? There's a lot of good evidence against Wendy. But the bar is very high to prove. I hope that they get the confidence if Donna gets convicted. I'm talking about Donna Adelson. I had a dream about her last night. That they'll try for Wendy. It would be a shame that the person that really was the catalyst for this murder with her children, it's all about control, as most murders are. It'd be a shame if Wendy just walked free and everyone else went down. And I know, who's not going down is Harvey. There's just not enough evidence against Harvey. You could not prove that to a juror. That would be such an easy not guilty verdict. Not because he's not guilty, just because that does not meet the bar. It does not meet the bar. One conversation taped and that phone call to him that I really do think was a real phone call to him is not enough. That's not enough. But his punishment is that his family is going to prison. The rest of his family. I hear he's very dependent on Donna. That's my sources. Sources say. Though I hear he was out and about the other day at a party.
I make that money that way. This I do on the side to kind of help, promote myself, but also talk about justice. And
I hope we all have a party. This comes out the way we want. So thank you, Mira, best group around. And of course, our Roberta's the most amazing. I hope we all get together for the Adelson trial. I hope so. Hope so. Back to Matt to Panic explaining the jury forms. I think this is like really important. He really picked up on a really important issue here.
and like making sure that people aren't lying and stuff like that, so they'd be held to accountability. A lot of these YouTubers, they are too afraid to lose subscribers, because these people who are believing this conspiracy, if they don't hear what they want to from the person they're listening to, they're just going to go to somebody else who's saying what it is. And there are YouTubers who know it's not true. They know they are lying. But they are doing so because they don't want to get turtled. They don't want to be attacked by the Free Karen Reed mob. I, on the other hand, don't give a shit. I've had my account hacked. I've had people crank phone call me, leave fake Google reviews, send fake emails, the whole 9 yards. And I just don't care, because this is about truth and justice in this case. It isn't about cash and clicks. So when you think about why they're doing that, it's very simple. Follow the money. Like some of these people, they're not saying this conspiracy, people are going to turn it off, and they're not going to get 30,000 people watching their stream. They're not going to have 500,000 subscribers. Those people are just going to go to somebody else who knows that it's either I say what they want, or they're going to go to somebody who can. Thank you for the sane, rational analysis. I believe that Hank Brennan does not get just. I does. No one will ever. He was broke. Yes, very simple. And that's the thinking with the misdemeanor OUI charge, is that you have the top trial lawyer in the state prosecuting this case, and he did it brilliantly. And if he can't get a conviction, nobody's going to. It doesn't matter. It's just the facts are just too. It's just going to breed too much dispute among jurors, no matter who they are, no matter where they are, and you're never going to be able to find.
It's not the facts, it's the confusion over the facts. Do you get what I'm saying? Do you hear what I'm saying? You hear what I'm saying? This is why the facts matter so much.
Find 12 people to agree on anything. So why keep going for years upon years upon years? You don't want to, and I think it's a dangerous precedent that all you have to do is have a lot of money, and then you could just take the jury pool and turn it into a conspiracy, and you could just keep getting hung juries until they just give up. Yes, they trade in integrity for clicks, and that's the truth. And they think that that's going to stay with them. The people who left them and went to somebody else who are talking about truth, they're going to remember that. And those same people. So I was on the prosecutor's podcast, Legal Briefs, last week, and I think I posted it on Twitter, but you can listen to it when you get a chance. The next step is the Brian Koppenberger case, the quadruple homicide out of Idaho. What are those content creators going to do? That evidence is 10 times more concrete than even this case was. And
I love that he calls him Cottonburger. Coburger, but I don't care if you get the killer's name wrong. It's the victim's names, right, that I care about. Cottonburger. I love that he calls him the wrong name. Cottonburger. Good. The more people that don't know his name, the better.
This is very strong. Are you going to also have to argue conspiracy? And it's like, that's probably what they have to. Like the people who were telling me about how Richard Delphi was framed are the same people telling me Karen Reed's framed, and the same Cottonburger was framed, and that Luigi Mangione was justified in murdering the guy in cold blood. You got hit very hard for killing someone via vehicle. I agree. I wish after the second hung jury, the judge would just step in and rule a verdict. That unfortunately, it's not how it works. You're entitled to a jury trial in this case, and as long as double jeopardy, it doesn't attach, the case goes forward. So double jeopardy, just so you know, it's not just. So I think this is. Well, I'll wrap it into the verdict form. Double jeopardy just doesn't mean if you've been tried and acquitted. That's not the only case double jeopardy attaches. It also attaches when you've been tried and convicted of a crime. So if you've been, like I said last week, Ashley Judd, double jeopardy. You've been convicted of murder, and you can't be tried and convicted of it again. That's not how. Doesn't work that way. But also the one thing that most people don't know, and a lot of these YouTubers who don't practice criminal law and just pander don't know, it also applies to a situation where you're convicted of a lesser. So let's go back to motor vehicle manslaughter. you saw that it has not guilty as number one, and then there's 4 charges underneath. Those 4 charges, number 2 is the most serious, motor vehicle manslaughter, and the 3 beneath them are lesser included offenses. If you get convicted of a lesser included offense on that charge, so if the jury checks box 4, motor vehicle homicide, that precludes a retrial of involuntary manslaughter and motor vehicle manslaughter, because those, by not acquitting, by not convicting them of those charges, you are by that fact also acquitting them. So acquitting her, I should say. So if you click motor vehicle homicide, you are essentially saying not guilty of involuntary manslaughter, not guilty of motor vehicle manslaughter. That's important. And most people.
He's a defense attorney, just so you know. Just so you know. Your latex spouse, I believe he's a civil attorney. No, he's a criminal attorney. He may do civil cases too, I'm not sure. Your latex spouse says, for Roberta's popsicle stick, hospital quality homemade bandage. You know what worked the best? So if you break your pinky or some other finger, is I used I think it was like a half of a glass nail file that had broken, and they have these like very elastic little, I don't know, covers for your finger. They're like, I don't know exactly what it was. It was like it's like an elastic you can put on, and it just to hold it in place, and that works great. That worked great, because a bandage and a popsicle stick can fall off and stuff. It kind of falls apart. But yeah, it worked great. Doctor said, oh, it's really straight. Sometimes it hurts if it's going to rain or whatever, but otherwise it's pretty good. Thank you. Your latex spouse? Okay, back to Matt to panic. Is he still alive?
People, you don't hear that. So that's why people are like, what is this verdict form? And people talk about misdemeanor OUI. It's like, David Yenny asked for the lessers, and you get all the lessers in that case. You don't get to pick and choose which ones. And the Commonwealth is smart enough, Hank Brennan's smart enough to know that there's more than enough evidence to get a conviction. And the image of being able to rob the defendant of that vindication interview on the courthouse is a real strong image. I mean, like, she may not be held in this courtroom for this crime, but she is certainly going to go to jail. And she's certainly going to be on probation and the whole 9 yards. And I think the victim's family knows if Hank Brennan can't get it, nobody's getting that conviction. And that's really unfortunate that the defendant, with using a blogger and this army of social media trolls, created this jury pool that's completely infected. Because think about it, you turn on the news anywhere. You can't go anywhere without that case. What about this conspiracy to harass witnesses? I thought they brought it to a grand jury and they declined. I think, if my memory serves me. I fear the ramifications of a hung jury in this community, continued harassment. Yeah. That's if they come back hung across the board, it's tough not to retry again. Because then you're not just going to allow these witnesses to, you can't incentivize a defendant to do what they're doing and essentially enable them. And you think about what happened with the blogger, where his case was tried and he was acquitted by the judge, which was a smart move on his part, simply because the jury would have convicted him in 20 seconds. But if they're no longer witnesses in the case, then it creates a gray area for potential harassment. I hope there's no more harassment when this case is over, but I'm not naive enough to believe it's not going to happen. If they notify the verdict is in, she's guilty of something, there's no way she's getting acquitted. It depends on the timing. I can't see. So this is important, actually doing deliberations. There were people who said we were going to have a verdict on Friday. One of which I had to privately message and be like, you said the same thing last year. And they responded with the fire emoji because they did. And I called them out for it. And a lot of people are like, oh, it's going to take 10 seconds. It's like, do you practice criminal law? This is a 31-day trial. This isn't a, this wasn't a 2-day, this wasn't a 2-hour DUI trial. This was a murder case. So what I know about this is probably if we don't have a verdict today. So if they spend a good 7-8 hours deliberating, and there's a verdict, my window, knowing criminal cases like I do in high profile ones, I think the window for a guilty verdict is either later today or early tomorrow. Meaning that if they come in and say 10 a.m. tomorrow, so June 17th, 10 a.m. to 12 p.m., that's when I would feel that would be kind of a guilty verdict situation, because a jury, what juries like to do is that at the end of a day of deliberations where they think they're close to it, they go home, they sleep on it, and then they come back and they're like, how do you feel now? And usually they're like, I'm still in the same place I was yesterday. Guilty, 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 or not guilty. But after that, if we go into past day 3, then again, we're in hung jury territory. And then at best, it's a compromise verdict. But after Tuesday, it's unlikely you're going to get an acquittal. So if an acquittal is to happen, most likely, probably 70, 75% chance, it needs to happen before lunch or early afternoon at the latest. After that, I just think people are not going to, the jury is like, well, there's too much evidence. And the first time, yes, the understanding is they didn't have her phone evidence the first time with the jury, grand jury for witness intimidation, but we go back and get it. The problem with the grand jury is that if you go and you don't have everything for the same charges, double jeopardy actually attaches in a grand jury. It ends. So if you've ever seen the show Defending Jacob, where they're doing like it's like an overarching grand jury. Grand jury is if they decide no bill, case is over with. You can't charge it. So let's take a look. Most YouTubers are not practicing attorneys. No, they're not. And the ones that are, I saw one spent Father's Day talking about how no jurisdiction in Florida would have brought this case, no state attorney. I was like, no, I have other things to do with my life than to be like, this guy is an idiot. And now he's just beyond pandering to say that because a cop is dead. So if I had a Sarasota sheriff's deputy was hit by someone and all the evidence pointing towards her, including the digital evidence, the forensic evidence, the physical evidence, they would never be able, that relationship between the state attorney's office and that sheriff's office would never be the same. I look for the jurors to be quicker because how long this trial, people want to go back to the lives is long. So that is the people on this. That's an interesting point. The people on this jury know what the ramifications are of this. They know that before they even were on this jury, they probably saw facts about this case. They saw it being posted. They didn't form an opinion, so they said, but they definitely saw about it. So they know what's going to happen with this case. If they were to convict, they know that of murder. They probably know the defendant's doing life. But I feel that, so this is something I thought of during Hank Brennan's closing. I don't even know if he realized what he was arguing. Is he talked about they broke up in the car. They had a fight. They got out. And her in anger backed up and blasted him. And then went home and made those angry phone calls. That was what the attorneys say isn't evidence. But if you accept that, an argument could be made to the jury that it was a heat of passion, which it wasn't, but a jury couldn't understand as much. So the evidence of second-degree murder actually lends more towards a motor vehicle manslaughter charge because it's a heat of passion. So it's possible that I picked up on that. I don't know if the jury will. They might, hearing that, get their that might be enough for them to kind of eliminate the second-degree murder, even though they don't need intent to kill. That's murder one, and people are trying to screw up intent, and it's like, that's not required. Just creating a situation that she knew could lead to serious bodily injury or death. Backing up your car, hitting them with it, that's creating that injury. What happens if there's one holdout came to the jury to review? So this is interesting. So usually when they do deliberations, the alternate is excused. Like here in Florida, we pick 6 jurors for a felony, 12 for a death penalty case, and then there's 1 or 2 alternates, depending on the charge. And when deliberations start, that alternate juror is excused. But here, they're hanging out in the courtroom, because if they come back and one of the jury's like, hey, we need to talk to the judge. This juror very clearly was not truthful and is secretly an FKR person, and they're not refusing to deliberate. An argument can be made that individual could be bounced from the jury pool. So I don't know if they will. That would definitely create like a humongous appealable issue, but it's also very possible. That the cousin is on the jury. Yeah, I know. To vote. Yeah, I pray there isn't a plan. Somebody on X says their cousin on the jury and they said it a month ago to vote no. God. Oh, you gotta love Twitter. Do you think the jury is looking at social media or no? No, they can't, because the judge asks them every time. And if the answer is yes, they're gone, because they're seeing things they're not supposed to, and they're seeing opinions. And anytime a juror says that it doesn't affect their ability to be fair and impartial, the truth is it always does. So when you're actually trying a case, and a lot of these YouTubers who are like directed verdict or talking over testimony, they don't actually try cases anymore. And they don't know that when somebody says, I think I can be fair and impartial, the answer is, I want to believe I can be fair and impartial, but I'm not going to be. So I believe it was forwarded to the court, so don't worry, yes. If she gets convicted, no, she's not going. The judge is not going to allow her to stay out pending appeal. That she gets treated like any other defendant. This is not a white collar case in federal court. This is, if she's convicted of motor vehicle manslaughter, she's treated like any other defendant. She doesn't get special treatment because she's Karen Reed. It's very simple. She'd be remanding pending sentencing if she were convicted of that. The only situation where she would get convicted and walk out is if the judge didn't give her any jail time on the misdemeanor, if she got convicted misdemeanor OUI and got no jail time. Other than that, it's remanded pending sentencing. Anything else would be ridiculous and completely against precedent. What else? So deliberations. I'll discuss deliberations real quickly. If I'm the foreperson, this is what I do. I start the case with, was she intoxicated? That's the most fundamental thing, because it deals. You can start with the charge 2 and go from there. Was she intoxicated? Yes. Going around. Yes. All right. So now she's intoxicated. So that's misdemeanor OUI. All right. Now here's where it gets dicey. Was there a collision? Did Officer O'Keefe's vehicle? What did Karen Reed's vehicle strike Officer O'Keefe, leading to his death? Because we know it leads to his death. So did the vehicle strike it? And if the jury is the foreperson is like, my notes say they had shards of the taillight embedded in his clothing. My note says that the hair found on the taillight is Officer O'Keefe's. And the people were like, oh, it could be the nephew's. Oh my God, don't be ridiculous. How did they get that? That's ridiculous. What, did they go to the kid in the middle of the night, take it off his head? No, it's Officer O'Keefe's head. The problem is you think, what I've realized is almost people watching this case who don't believe the conspiracy almost gaslight themselves. Like, if these people can believe it, are these 12 jurors also not going to? Do you think AJ gave a reasonable death? AJ's argument started good, and then it just looked like it was written by the defendant. Once it went off on the conspiracy rant and this, that, and the other thing, I was like, okay, this is stupid.
I had the same reaction. Same. I thought it started out good and then it just fell apart.
If she gets convicted on the lesser, she'll get 2 to 5, 2.5 to 5. So if she gets misdemeanor OUI, so let's just recap because not everybody was here when I stated it earlier, and I think I'll do a few more questions. I do need to get to a court soon, federal court. If she gets convicted of misdemeanor OUI, it's punishable by up to 2.5 years in jail, county time, whatever you want to consider it. House of Corrections. That's misdemeanor OUI. Motor vehicle homicide, felony OUI and liquor and negligence is a 2.5-year minimum mandatory. So she gets convicted of that, she has to do 2.5 years, and that's punished by up to 15. And I think that the judge would give her probably around 10 years. I said 10 to 15, but probably 10 years for that. Motor vehicle manslaughter is a 5-year minimum mandatory, punished by up to 20 years. And she get convicted of that, I'm pretty safely assuming she'd get double digits. And of course, murder 2 is life with the possibility of parole. Her and Yannetti arguing over the form is a possibility. Well, maybe David Yannetti was watching the stream on Saturday and they just realized, but what do they want to put? Not guilty? No, that's not how it works. You don't get to have not guilty on 20 pages. Are you not guilty of this charge and every charge on the page? It's very simple. And if she's not, because that's what they is, because then they can argue, oh, they don't know what they're doing. Because you know what David Yannetti and the defense is thinking. If they acquit on one of the charges, that they could say that they acquitted for all of them and create an appellate issue. It's bullshit. Excuse my language. Yes, John O'Keefe's life is worth more than 2 to 5 years. Absolutely. And that's the unfortunate reality is no matter what sentence is imposed, it's never going to bring Officer O'Keefe back. It's never going to fill that void in Peggy O'Keefe's life, no matter what. It's just, that's how the law is created. And that's the unfortunate reality. Argument that he was in the house. Oh my God. When Alan Jackson tried to argue the glass was from the house, I was like, you had a relatively strong closing argument. And then you go full, he went into the house, even though there's no evidence of it. So, and the glass that the defendant herself stated was hers in the video, you try to say it was inside the house? If the jury's paying attention to that, that was the biggest mistake Alan Jackson made. Because if he's saying that tells them that they have no idea. Didn't say she was buzzed. Yes. Yeah, and she wouldn't take that at highway. Again, misdemeanor OU, unless there is some person, some FKR who will never convict of anything, not even jaywalking, she will get convicted of something. I think the hair is from the arm, just in my opinion. Yeah. Whatever the hair is, the DNA matches John O'Keefe. And it was like 1 in 80 octillion or something. It's his. It's not the nephew's. It's his. What happened to the defense witness who saw? There was no defense witness who saw John O'Keefe enter the residence. That was promised an opening to try to keep the jury's attention, and it never happened. And the jury picked up on it. So if he doesn't go into the house, his phone doesn't go into the house. His Apple Watch data, there's not one witness. So how does he get beat in the basement? How does he get beat in the garage now? He doesn't. He was hit by the car. The jury needs to focus on the data and evidence is pretty conclusive. Exactly. And that's what, when I said last week during closing, when I talked about closings in a stream, is data, the forensic data, the physical evidence, and the the digital evidence. That's what needed to be focused on. That's what Hank Brennan did. And it's like evidence, evidence, evidence. If she walks, I'm going to... And this is what I say with any kind of verdict. The verdict, she should be convicted of something based on the evidence. But what I know is juries are unpredictable. Every trial attorney, real trial attorney, will lose cases they thought they were going to win and win case they thought they were going to lose. Always. You don't know. You don't know what they found persuasive. You don't know what they're going to focus on. They're doing what they think is right. And based on the evidence, I think she has to be convicted of something. I don't know if they get to murder 2, I think that Hank Brennan still made a very strong argument for murder too, but I think a part of me thinks that it was to soften the jury up to finding her guilty of a lesser. Like, all right, who thinks murder too? And it's like, yeah, 4 or 5 of us, and 4 or 5, and the rest of us are like, motor vehicle manslaughter. They go back and forth, and then it's like, let's just do motor vehicle manslaughter. I'm good with that. Let's move on. If that happens, the Commonwealth will take that. So if you're the Commonwealth, you'll take anything motor vehicle homicide or greater. Even if they hung on 1 and 3, they're not going to retry. If they get her for motor vehicle homicide, that's going to be more than enough for them. And it's just not going to be worth the nonsense that goes along with this case. The timeline and data is just too tight for any possibility. Exactly. And that's what the jury's going to be looking at. It's like, how do you frame somebody with a black box that they didn't even have in the first trial? We give Shannon Burgess about his LinkedIn profile and this, that, and the other thing. But he was the one who found it. He gave the data. He's the one who tracked it. Ways. It's just, there's too much. And yeah, so what you're going to be hearing is if she does convicted, free Karen Reed, people are going to lose it. YouTube people are immediately going to be appeal, Bev, blah, blah, blah. And it's like, shut up. This is due process. The evidence, this should have been the verdict.
This YouTube person is not gonna be like appeal.
In the first trial, but unfortunately, there were people on the jury who were just never going to convict, no matter what. So I think I'm going to do a couple more. I could see them splitting the baby too. If we're into the end of the day, if we get to lunch tomorrow without a verdict, I have to think we're in compromise verdict or hung jury territory. So if you're the defense, you want a verdict before 2 p.m. because if you believe that it was just this conspiracy, you don't need to talk about it. It was Karen's choice to not drive. Yeah. And that was a devastating piece of evidence. Not once does she call 911. She tries to find him on his own. Not, my boyfriend didn't come home. It's a blizzard. He could have got into a car accident on his way home. Why didn't she? She knew where she was. And that the jury is just going to be like, so when they're trying to rip Kerry Robinson and Jen McCabe, they're the ones that actually called 911. Karen Reed didn't. She's like, oh, she was giving him CPR. What about before then? I'm still upset over the Casey Anthony. All right, I can tell you this. I knew she was going to be acquitted before the verdict came down. The reason is this: and people are like, oh, the medical examiner. All right, in the Casey Anthony case, the medical examiner could not determine cause of death. In that case, it was important because they were arguing an intentional murder. So it had to be homicide. If they couldn't determine homicide, that's reasonable doubt. So it's either homicide or accidental. That's why she was acquitted. This case is not the same because homicide and accident are interchangeable because he was hit by a car. That medical examiner doesn't know if it was on purpose, doesn't know it's on accident. That's important. The state didn't have a strong case with Kingston, but they have strong evidence in this case. Yeah. That's what the defense wants you to do. They want to say so much, suspend your logic. Exactly. That was the whole theme. I think we're going to end here. Leave your common sense at the door. I will say I did love when Hank Brennan, I literally almost, I think I spit out my drink when he said, look the other way. I was like, oh my God, this is just ruthless. And it is. It's like, look the other way from your common sense and logic. Look the other way from, yeah. And that's okay. We'll get to this Casey Anthony thing will be the last one because Jose Baez can help answer that. Look the other way with the digital forensic. Look the other way for the physical evidence. And that was just devastating. Yeah, so in the Casey Anthony trial, the other thing was the state did not introduce the phone data, which had Casey Anthony's phone pinging in the exact same area. Jose Baez in his book, when he says, we're waiting the whole time to be hammered with that because that's what's going to sink our case. And they never introduce it. So that prosecutor who tried that case had to resign, because if you're a prosecutor and you can't win the big case, you probably aren't going to be trusted to be a prosecutor in the future. But I got to get to federal court. We are in jury deliberations waiting. I will be intermittently on Twitter throughout the day. I may do a show at 5 or tomorrow, depending on what's going on, but I'll let you guys know. Thank you very much. Have a wonderful day.
All right, Matt to panic. Pretty interesting.
First one, let me zoom in on it so you can actually see.
So let's see. What else? We're just waiting for verdict. So the great Tom Murtati called me. He's a civil lawyer, one of the best civil lawyers in the country. Had him on, talked about Karen Reed, talked about the civil case before. Go back. And I asked him, I said, have you been watching the Karen Reed? I had a question for him. And then by the time, it wasn't, by the time I had gotten an answer. So we just kind of chit chatted. And I said, have you ever seen, I said, have you been watching the Karen Reed case? And he said, I have been watching the Karen Reed case, bits and pieces here and there. I said, what did you think of that closing argument? And he was like, pretty strong. And I said, have you ever done a closing argument like that where he goes, I do all my closing arguments like that. I just write notes. And that's what I think Hank Brennan did. He just wrote notes, because when I was taking notes from his closing argument, you can follow it where he's going, the logical steps. So let me just go down my notes and his closing argument. I'll tell you how it goes exactly. So he starts with humanizing John O'Keefe. He was a good man who needed help, and Karen Reed was drunk, hit him and left him to die. He had a chance of survival. Karen Reed took away that chance. Karen and John were in a toxic relationship. So Kaylee says after Aruba, it was crumbling. Karen reached out to Higgins. Kaylee's story about John going behind a closed bedroom door like the last night. He combines the image of Karen always having to have the last word. So John O'Keefe would try to move away from arguments, and Karen Reed would go towards them. She had to have, so if there was, and you can see this in the text messages too. I hope they're looking at those now. That when there was issues between them, Karen Reed she would never leave him alone for a minute. He's like, those text messages, Karen Reed's going through it like, are you over this? Just tell me you're over it and you'll never hear from me ever again. I mean, how manipulative is that? Who believes that? No one. No one. Are you just not that into it? Are you seeing someone else? Are you this? Are you that? He's like, look, I'm at the kid's doctor. My dad's over. I can't interact with you. Call me. And she's calling him and she's texting him and calling him and he's hanging up. Stop calling me. He's like, stop calling me. Karen reached out to Higgins. Kayla, okay, so she had to have the last word. So Karen's reversal that night, she went forward, then she came back for the last word. So I thought that was very effective in his closing. Text messages tell us the relationship was unstable and at its end. They both drank a lot that night. Karen Reed had over half a dozen of mixed drinks in an hour. She had 9 drinks in an hour. No discord between John O'Keefe and Brian Higgins. Here's John O'Keefe barely greeting Brian Higgins, and he played it. The reality is sometimes different than argument. So he's just saying Karen Reed was almost 2 to 3 times the legal limit for blood alcohol. Karen Reed in clips will dispute her own legal team's claim. She shouldn't be driving clip. And then you think she drank when she got home? Really? Like, do you really believe the defense argument? 12:12, they leave the Waterfall bar. But she didn't go home. She went to John O'Keefe's house. There's another falsehood. She didn't go home. She went to John O'Keefe's house. The data is the historian that tells us what happened, you know, and he goes to the data. He explains the charges. And then he goes back to telling the story. So, I mean, you know, he goes forward and back and forward and back. They were weak reports. Yeah, right. I thought maybe we'd watch. I mean, now that we're just waiting for a verdict, I go to my channel. Let's see. Let's try to watch opening arguments. I thought that might be fun. Anybody else think that might be fun? I hope so. Or we can go over the text messages. I don't know. But we're just all waiting for a verdict. Hopefully we'll get one by the end of the day. I find that there's a lot of evidence to go through and talk about. It's really, you know, when I was a juror, I really thought I would be thrown out in 15 seconds or less, but I wasn't. I was the only one picked. It was very helpful because I used to think, like, what are they talking about? What do they need to talk about? But you need to get out a lot of your thoughts about the trial, and you haven't been able to talk about it with anybody. And let's see, this is all I've gone back too far. I really need to organize my whole Karen Reed section and put the trial into one day, one playlist. Okay, here we go. Opening arguments. I'm just fast forwarding through Judge Cannoni so we can get to Hank Brennan. I assume nobody wants to listen to Alan Jackson's opening, but if you do, let me know. But here's Hank Brennan's opening from this trial.
Take testimony at the conclusion. According to the oath, truly, then you will arrive.
At 6:04 a.m. on January 29, 2022, the alarm bell sounded at the fire department. Firefighter paramedic Timothy Nuttall knew what that meant. His heart skipped a beat. He raced to his equipment and he picked up his bag, which was meticulous. There was a sign and a signal, and then there was a voice commanding that there was cardiac arrest. The most serious of calls for a firefighter and paramedic, that means that a person's heart has stopped. He didn't know who it was. He didn't know where it was. He took his bag. He had just gotten to the station, and he rushed to the ambulance. He was one of the most senior paramedics that morning. Another paramedic, Anthony Flamati, would be running this mission. He jumped in the back of the ambulance, the door shut, and they headed off to 34th Fairview Road. As they drove, firefighter Nuttall could not see anything. He couldn't hear anything other than the engine of the ambulance. He could feel it sliding across the road. It was near blizzard conditions. He calmed himself, he steadied himself. This is what the firefighters and paramedics are trained to do, to focus. And he focused on his task. He looked around the back of the ambulance to make sure that all the tools were in place. The ambulance was meticulous as well. This was Anthony Flamatti's ambulance, and it was well stocked. He calmed himself and he thought about what was going to happen. What should he be looking for? What is his next steps? He played the scenarios through his mind, and every calm was above him. As the car pulled up to 34 Fairview, the ambulance, he stood at the back door, the doors open, and he stepped out into bedlam. He could hear a woman screaming and shrieking, the cold, hard air slapping on his face, and the wind, blizzard conditions swirling around him. You will hear him tell you how he trudged towards those screams in the darkness to snow. And when he got there, he saw 3 women surrounding a man lying, not moving on the ground. He walked up to the man and he reached down and he tried to find any signs of life, pulse, anything. And he found nothing. And he got up and he walked over to the woman, and he walked over to that defendant, Erin Reed, and he told her that he thinks that that man is gone. And then he heard the yell from Anthony Flamatti, the chief, and he said, "Come back, let's go." Because you'll learn that in the cold, even if somebody's heart stops, even if they're presumed to have passed, sometimes you can still save a life. So you'll see on a dash cam video, you'll hear through testimony, he went back to that man who's John O'Keefe. He went back to him, and that crew, coordinated effort, they did everything they could to save his life. They got on their knees, they began CPR, and firefighter Nuttall will explain as he kneeled over John O'Keefe. He looked up, and the defendant approached him, and you'll see it on the video. Now, he wanted any information, because when you're trying to save someone, you want to know, are they on drugs, medication, do they have a heart condition? And he looked up at Miss Reed, and he said, "What happened?" And you'll hear her words to firefighter Nuttall. She said, "I hit him, I hit him, I hit him." And it was at that time, with the words of the defendant, that she admitted what she had done that night, that she hit John O'Keefe. Now, those words didn't mean anything to firefighter Nuttall. They weren't in context. They didn't reconcile with the injuries. It didn't help him in his treatment, so he ignored it. Now, firefighter Nuttall is not a police officer. He is not an investigator. He is not a detective. He's a first responder. And so he takes that information. It was useless to him. He continues to work on John O'Keefe, trying to save his life. You'll see the team put him on a stretcher. And when they lift him from the ground, even though there is snow accumulating, underneath John O'Keefe is simply grass, hard, brown, frozen. And beneath his body lay his cell phone. They bring him to the ambulance, and while they're bringing him to the ambulance, you'll see on the videos that other first responders speak to the defendant. One first responder, Flamatti, she will say, "I hit him, oh my God, I hit him." And then she was interviewed or asked questions for background information, not a criminal investigation, just background to try to help John. And she was asked questions about his background. And during that conversation, you won't hear see the defendant was a person by the name of Jen McCabe and a firefighter McLaughlin. And she tells Fire McLaughlin, the third first responder, "I hit him." They bring Mr. O'Keefe to Good Samaritan Hospital, and his body is cold. The doctors work feverishly. They treat him, trying to save him. They try to warm his course. And unfortunately, firefighter Nuttall's first instinct is accurate. John O'Keefe passed. So why are we here today? We are here today because John O'Keefe was killed by the actions and conduct of that defendant, Karen Reed. You will learn through this case, through facts, science, and data, you will learn that on January 29th,
Has anybody been following the mushroom cap killer in Australia? Has anybody else been following that woman who fed her entire family? I'm so glad Amy has a good feeling about this. I need the positivity, guys. You can't blame me for I've been on the losing end of so many of these innocence fraud campaigns. Getting out Adnan Syed, the fraudulent way they did. Total fraud. Right? She fed them, and one survived. That guy, she told them she was dying of cancer, and she went out foraging for mushrooms. You listen to it daily. Maestro says he thinks it's going to be a guilty verdict today. I hope you're right. I have no read on this jury. I don't know who they are. I don't know what they've been looking at. Certainly, you always think, even if they were looking at social media. I wish I could play. It was Julie Grant's show I was watching. These two lawyers, they were laughing. They were like, these people have been looking at social media. They've been looking at what's been said about the case. They say they don't, but they do. So, and it's like a full push by the stupid press in Massachusetts. You're usually wrong. Yeah, I don't know. I don't know which way. I never know. I thought that Robert Durst would be convicted. His defense was a disaster. I mean, that was just a massacre. But you don't know. You don't know who's on that jury. You don't know what they're thinking. A lot of people, I have to say that the court TV crowd is a very pro-innocence crowd. Every chat I've ever been in, whether it's the Robert Durst trial or any other trial, at least half of the people in there are rooting for the defendant. I think they're nuts too. I'm not rooting for any accused murderer with a lot of evidence against them. No thanks. I just haven't seen anybody been brought up on trial with no evidence. And they're like, and when Robert Durst got up, they thought he was charming and they loved it. And, the John Lewin is a bully. And I thought it was pretty overwhelming. I thought they did terribly. But, you just don't know who's on the jury and who's right. So I thought this was pretty much a massacre. I think that it is a good sign that Karen Reed said nothing to the press, that she didn't feel like waxing poetic again to the, about herself and her innocence to the press. Thought that was a good sign. I thought her distress in the courtroom is always a good sign. She said it. She said that the Commonwealth is, going all out, or whatever the word she used. What was the word she used? What was the word she used? Does anyone know? Oh, wait till you catch up with me. What did she say? Playing hardball, I think. That's what I think she said. PK. Ask Maestro about her. I don't have such a good experience with her. She was not very. She just went up and I can't even remember. It's like a long thing. Telling tales about what I did on my show, and then saying that she said that I accused her of ripping me off. I've never accused any other creator of ripping me off ever that I remember right now. Okay. I mostly don't watch other people's stuff. You don't know how you're going to be influenced. If it's something like, if I'm trying to understand some kind of ruling, I'll watch something, to try to understand like maybe the jury forms or something, but I tend not to watch too much true crime media because I want to have my own opinions and I don't want to be influenced. But, she told her crew that I was doing this and that. And then I confronted her with the clip, and she denied it, and a whole bunch of nonsense. So I'm not thrilled with her. I think she's very manipulative and not very honest person. So I don't, I'm just going to be honest. I'm going to be honest. That's what happened. I have the proof. If you want to see the proof, if you want to see how it went down between us. So I think that, and I don't think she does, I don't know, she just said like over and over again, you accuse me of ripping you off. My audience is constantly accusing me of ripping you off. She doesn't seem to do the hard work of, she's putting out so many videos that she's not really, makes me think that, if she is she's probably ripping off other creators to make shortcuts. You can't do that many videos and do a deep dive search yourself. You just can't. That's my honest. I don't know if I'm being too honest. I don't know. That's it. I'm just not crazy about her from that. Yeah, it was a really bad experience. I really thought, I said, please take it down. She never did. It's just untrue. One video, please. I just don't like untruths that I'm like going off. I don't watch her. I wasn't watching her at the time. But it gets back. When people talk about you, people tell you, it gets back to you. Even though I've been a fan since 11/22, I came into this case a free Karen reader. Did you? What did you find convincing, Charles? Curious. My first moments of doubt came from actually listening to her. Then you turned me with your relentlessness. I am relentless. My boyfriend calls it the saleswoman. He's like, can you put the saleswoman away? Yeah, I press and I can't let go. Thank you. God bless you. Thanks, Charles. Let me know what you found convincing about her innocence fraud campaign. It is kind of like, I mean, yeah. Yeah. So I had an unpleasant experience with her. I really thought she would just take it down, but she wouldn't. And she just like rambled. Yeah. Yeah. She's really dishonest. You just can't make that many. I mean, look at all the different videos she's made about different cases. I mean, to really do your due diligence, you just can't do that many. I mean, I would love to do a different case every day. I just can't. I'm only me. Everything you see on this platform, except my logo, which my friend did for me. She made for me. I traded a cat, said her cat, so she would make it. We traded. But, everything else besides my logo, I've done myself on this channel. So I cannot do research, every day in a way that, I come with I'm certain and I have a really good hold on the facts, and I'm not going to make, mistakes. And I still make mistakes. So, I try to correct them, try to keep everything as factual as I can on this channel. I hate it. It's a horrible feeling, that I really related to Brennan it's just a horrible feeling. It's a kind of humiliating, horrible feeling when you've made a mistake with the evidence in a case. With the whole sweatshirt, whole business. It's, at least for me, I don't know how Brennan experiences it. I'm obviously projecting my own feelings, but it's a horrible feeling. You want to get things, right. It's a lot easier when it wasn't live streaming, when I was editing my shows, and you had a lot more time to make sure that everything out of your mouth was true that went out. And I think I do a pretty good job.
22. When the defendant and Mr. O'Keefe were in front of 34 Fairview Road, all the way to the left side in that dark corner near a flagpole, you will learn that Mr. O'Keefe got out of the car. He got out and she stood by the side of the road after an argument with the defendant. That argument, that anger fueled by heavy intoxication, you will learn from the science and data as she stood by the side of the road. The defendant in her SUV drove away. She drove at least 35 feet away. The argument.
So did I go over the owl? Yes. Yes. I've talked about the staircase from the beginning of my channel. That was a case I was very interested in, so much so that I visited the house. And I mean, I don't know if that's something I should brag about, but I was in Durham and I wanted to see it. So we went by it. It's very set back. The pool is in the front of the house. And Kathleen Peterson was such an extraordinary woman. What a loss that was such a horrible, horrible, mediocre man. What a liar that guy was. Is still around. Yeah, I related to that documentary. The way, I'm a writer's daughter. And when you have that dynamic, the family dynamic was something I was very interested in. He was just storytelling. We were watching America's Sweethearts. And that they leave out the red neurons, which shows that she died over. It was a really horrifying death. She was beaten and, died over a long period of time. They left that out. You didn't hear much about her throat or her cartilage being broken. So it makes it seem like maybe an owl could do it, with a feather, with an odd feather. It's amazing to me that I just know how much hair my cats create. That John O'Keefe didn't have some stray dog hair that got on him from someone else that had a dog hugging someone or something that night, and see, a dog did it. Here's the dog hair, I mean, it was obvious he cleaned up the scene. It's something that certainly Karen Reed didn't do. She did get rid of, I believe this is my belief. I don't know what you guys believe about this, but I believe she deleted those. I mean, this is what tells you that we don't know when she deleted it, the Ring camera evidence, but it tells you she wasn't in such a panic, that she's making her own evidence that morning, that she's so aware of her own survival, that she's making her own evidence by love tapping John O'Keefe's car. And that most people would be too upset to do that. But being a psychopath, she doesn't have any of those feelings. She doesn't have, you can see her. She was smirking. The Free Karen readers got really mad about that article in the New York Post about Karen Reed smirking when John O'Keefe's autopsy pictures were shown. But she doesn't have any of those feelings. She can smirk through autopsy pictures. She doesn't get sick to her stomach like some of the jurors. And, she's going to make her own evidence. Right. So she deleted those. I believe she deleted those on an app. She had the app and she deleted the most damning. She knew what the most damning Ring camera videos were and she deleted them. I mean, that's, this is why we're at the second trial. Most people, this is so unusual. Most people but this is what innocence fraud campaigns do. They blame it on animals. They blame it on an owl. They blame it on turtles. They blame it on dogs and turtles in the West Memphis 3 case. There's not a good person. Then they blame it on a whole group of people. Then they blame it on a stepfather. Yeah, that's something I got wrong. Yeah, so she didn't talk to her dad before She made that love tap. That she did all herself. She hadn't talked to him at 5:07 yet. She's a psycho. She doesn't have, I mean, she can waltz through this. She's worried for herself, but she's just gambling all the time. Taking risks, throwing the dice, mixing it all up.
It had ended. But then she stopped. She put the Lexus into neutral, and she waited. And the facts and the science and data will tell you that despite the fact the argument was over, she then put the Lexus into reverse, put her foot on the gas pedal, and began to press, not 25%, not 50%, up to 75% acceleration. There was a light dusting of snow. The Lexus tire spun backwards. She went backwards at least 70 feet. She clipped John O'Keefe. He fell backwards, hit his head, broke his skull. And there he lay at the corner of Fairview Road, on the ground, lying on top of his cell phone, alone. And then the defendant will later tell that when she left, he didn't look mortally wounded. Yet he was. And she simply drove away. Now, before I tell you about the data and the facts and the science, and I walk you through that, I'd like to tell you a little bit about John O'Keefe. John O'Keefe was a young man, a local kid, very well liked, loved. John O'Keefe is the son of Peggy O'Keefe, John O'Keefe Sr., and the brother of Paul O'Keefe. Grew up in Canton, worked hard, he became a police officer. But what you're going to learn, the fact that he worked for the Boston police officer, as a Boston police officer, was just a fraction of his life. It was a small, really unimportant part, because the biggest part of John O'Keefe is he was a family man. Not in the traditional sense. You see, John O'Keefe never had biological children. John O'Keefe was never married. But John O'Keefe had a sister, and she had 2 children. And when the children were 6 and 3 years old, his sister unfortunately died. And shortly after, his sister's husband died. John O'Keefe was a help. He didn't sit by. He saw these 2 recently orphaned children, and he stepped in and he said he was going to raise them. So he put aside his career, he put aside his job, and he moved in with the children and raised them up. They were his home. They were his passions, his love. He was a new parent, successes, failures, like all parents. And he raised the children with the help of people in the community, with the help of his brother, with the help of his family. And they led a good life. Enter Karen Reed. Around COVID, the defendant and Mr. O'Keefe reacquainted, and they started a relationship. And you'll hear that even though the defendant had her own home, she was staying with Mr. O'Keefe a lot, 4, 5, 6 times a week. And to most of the world, it was a pretty good relationship. They spent time together. They did activities with the children together. She helped with providing the children, feeding the children. It was a steady relationship until about the beginning of 2022. And then things began to unravel. There was tension. There was argument.
Okay, so I had a fantasy that they had a verdict in their mind. They were going to just come back with it this morning, like guilty. Manny, $4.99. Thank you. Hey, Roberta Glass fam. Hello, Roberta Glass family. How's everybody feeling? Everybody feeling good? I'm feeling good. I'm well rested. You should be bigger than any law tuber. Thank you. But you don't sell out or compromise your values. Yeah, I don't know how they live with themselves, but okay. Okay. Verdict is guilty of drunken manslaughter. That's what you think? I don't know. I don't know which way I would be surprised with an acquittal, but it could happen. Anything is on the table, certainly. It's almost 3 hours. You know what I should do? I should put up a banner so people know what's going on this channel. Hold on one second. Let me do that. Hold on. Is this day 34? I think so. Okay. Okay. Save. Okay. How is everybody feeling? Let me check in with everybody. I'm calm and I have zero doubts today. I love this. I love the positivity. I do. The free cam don't even look on Polymarket. Don't even look. Unless you want to make a lot of money. If you really think it's a guilty verdict and you're a gambler, go on. I'm not a gambler. Go on Polymarket. Oh my law. You can make some money. Like 70%, 5% an acquittal. You're worried, Lou Colfax? Okay. We're here for you. We're here for you. You're so sure? My kids ask me, what will you do if she isn't found guilty? She will, I'm sure. We could also have a hung verdict, too. Could be another. I don't know who these jurors are. I know that there are 7 women, 5 men. Jury 4-person is a black man. That's what I know. That's been the descriptions. Everyone's under 45. And I don't know anything else. Mrs. Karen Reed is guilty. Thank you. She is. So, I mean, if they don't convict on DUI, I mean, come on. What are we doing here? But maybe they'll go on a technicality that it wasn't done at the time. That's where I can see that. But she admitted to being drunk. So, I don't know. I don't know how seriously they're going to take those interviews. I would be paying attention if I were a juror to everything Karen Reed said. Certainly. Here's the great Adam Lally. Laura McLaughlin was not in the courtroom for the early part of the trial.
In fact, just a few days before this incident, you'll hear that Mr. O'Keefe asked her to leave. But she wouldn't. You're going to be able to read text messages of their conversations on January 28, 2022, and you will see the tension and the unraveling of the relationship. You will read about the discord between the defendant and Mr. O'Keefe. You will see that when he would ignore her calls, they would become incessant. When he would try to push away, she would come closer. You will read those text messages and you will realize that this was the beginning of the end of this relationship. That night, they decided they would go out together. I want to tell you something about data and science before we get to that night. I mentioned that underneath John's body was a cell phone. A cell phone is an amazing piece of technology. It is like a computer. It carries extraordinary data. And when they found the cell phone, the only container on O'Keefe that night, they studied the cell phone, and there'll be some remarkable data that you will use in this case to find the truth. I want to mention 3 different things you will find in a cell phone that are critical to this case. The first is called location data. Waze we've all heard of, Google Maps. Well, at some point that night, John put his Waze on, and Waze is like a breadcrumb that will show exactly where the phone goes second by second. It is the strongest, most accurate location data that you can have. And that night, John was using Waze. It also will have healthcare data. Healthcare data will show when somebody is moving. Sometimes it's qualified as steps, but it doesn't necessarily mean somebody's stepping, moving their arms, walking, turning. It doesn't show what direction or how far, but it shows movement of a person. Okay. And the third thing, remarkably, will be an expert in this case, who found a data file on the phone, and it tracks the temperature of the cell phone battery. That will be critical to your analysis in this case, the temperature of the cell phone battery. And so with that, I want to take you back to the timeline of that night. After the discord, both the defendant and Mr. O'Keefe decided they would meet at a bar called McCarthy's. Now, McCarthy's is a local bar of visitors pending, and people are getting together in a celebratory mood. They go to McCarthy's and you see a video of McCarthy's, and you will watch both Mr. O'Keefe, friends, and the defendant drinking alcohol. And you will count 8 vodka drinks that the defendant drank. They arrive at 8:50, they stay till 9:45. She consumed at least 7 of those drinks in less than 2. The last drink, you'll see when they leave the bar, she puts it under her jacket, and they walk out and they go to another bar to meet other friends called the Waterfall. They reach the Waterfall sometime around 10 p.m. And when they go into the Waterfall, you'll see a video. And when I said celebratory mood, you will see a group of friends of John O'Keefe, many who are friends with Karen through John.
I don't know. What did you think was stronger, his opening or his closing? I think it's closing, but I think he's better at arguing than opening, but that's just me. So here is, looks like this man, Aiden Carney, speaks for you. So because this woman, Zora, didn't agree to your negotiations, she deserves to be targeted. So Aiden is kind of targeting this woman on this opposite side of the Karen Reed case. Working for Compelling Pictures. Or is it Compelling Pictures? Is the other one Sandpaper, the one that's against? Okay, so he's on Compelling Pictures. She's Sora's from Sandpaper. I got it confused. Okay, she's doing the Netflix doc with Gretchen Voss, who started out on the really putting out this conspiracy. And she went to the rolling rally where they and she fought to get her unedited tapes out of this thing, and those became the basis for some of the pretty damning clips of Karen Reed. Thank God she lost that. She fought like hell to get her unedited tape. I mean, she edited so much out of her interviews. There was more edited than she handed over. It's like covering for Karen Reed or herself, or I don't know what. Karen Reed made some pretty... She admitted that her taillight was broken that morning. Oh no, Vinnie Politan is there. Oh, what a grifter. Oh God, he's into Karen Reed. Oh, Lord.
And you'll see them clapping and happy and joyous that they're there. You'll see many hugs between John O'Keefe and his friend and the defendant and many of the people there. And they spend some time together, they're drinking, and they all do a shot. And that will be at least 8 drinks within 3 hours. You will see from the data, not just the cell phone data, but there's some other very important data. And the other piece of data that goes hand in glove with the cell phone is information on the defendant's Lexus vehicle chips. You might have heard of black box in an airplane, or there's some type of event that captures a small amount of time. Well, that was captured in the defendant's Lexus. That black box information with the cell phone data will tell you everything.
Don't get it twisted. Vinny hasn't drunk the Kool-Aid. He knows. He said that she thinks Karen Reed's guilty. He said it in interviews. He's just pushing it out, this doubt out, because that's where the money is and that's where the audience is. He knows. There's a reason why he's on at prime time. Okay, defense has filed a formal request to amend the verdict slip. Thanks, Jennifer. On the manslaughter OUI charge to include a not guilty box. They had previously argued it in court. Jurors in the first trial had expressed confusion about that. Karen Reed told me and other reporters the request was denied and won't be heard. Okay. They have a question they can ask, you know? I mean, they're so confused. I don't believe this, that jurors were confused. Ted Daniels, this is what I'm reading. He's pushing this nonsense out about confused jurors. Jurors should have asked the judge if they had a question about the juror slips. I'm not a believer. So back to the opening. Here we go.
It will bring us step by step to the entire night to that Donald. And so they leave the waterfall bar at 12:12, and you'll see that the ignition goes on to the defendant's Lexus. And both John O'Keefe and the defendant in the car, and they decide that they're going to go back to 34th Fairview Road, where we talked about earlier. They're going to go there for a get together for one of the homeowner's sons who's having a birthday party. And so as they drive back, you will be able to follow them to this location data. When they go back to Fairview, they don't know exactly where it is, and they get lost. And so John O'Keefe makes a phone call with one of his friends, Jen McCabe. And during that phone call, which the defendant listens to because she recounts it, and trying to get directions, Jen McCabe tells John O'Keefe, get near Bella's mom's house. You'll learn that Bella, or her mom, is somebody that John had dated before. And so as they make their way to Fairview, you will see there's a road that comes down like a loop and that leads to Fairview. They take a wrong turn on the loop, and then they do a 3-point turn in the driveway. You see that precise driveway they turn into because some type of acceleration movement triggered that black box in the Lexus. And that's important because 7 minutes before the collision. And you'll see from the waves exactly where the car was. You'll see from the black box the event of the 3-point turn in the driveway, and then a return down to Fairview. Before they get there, at 12:23, a truck is coming the other way. And the witnesses in that truck will say they blinked the lights. One of them saw a man and woman in the car, John and the defendant, and then they followed the Lexus because they were going to the same house. The truck stopped at the driveway, and the Lexus, the defendant's car, will appear because of the waves and be counted second to second, never stops. It rolls very slowly all the way to the end of the yard in the corner where there's a tree line and a flagpole. And they reach that location at 12:34:33. And they're in the car and they stay there. The truck waits, they speak to somebody in the house who comes out, the person goes back in the house and they're there for about 5 minutes. We're now down to 2 minutes before the collision. The truck leaves, and now it's just the defendant and John. And while they're waiting outside, 12:27, John gets a text from Jen McCabe. Park behind us in the driveway. 12:29, text again. Are you coming in? You'll hear that Jen McCabe and others look out the window and see the defendant's Lexus in front of the flagpole at the far end. It's snowy, it's dark, it's windy, they're waiting. You will know that John O'Keefe was in that car, that Lexus, and didn't move because his healthcare data is not moving. It's not moving until 12:31:56. At 12:31:56, he begins to move. You will have 20 seconds before he falls. 20 seconds. He gets out of the car, the Lexus. And in that 20 seconds, you'll hear that user initiated. He looks at the phone, at the text message he then McCabe. It's now 12:32:09. He closes the phone the last time. It will be the last time waterfall bar, you see that. And at that time, 12:32:09, last user, he has 7 more seconds to move before he lies dormant the rest of the night. We'll also have the information from the defendant's Lexus black box. The clocks run differently. There's a 30-second variance, but it's right in the heart of that time. And you will see in the data at that time, when he makes his last movements with the phone, is when her car leaves 34 feet at least, stops, neutral, and then shoots into reverse with the tire spinning right towards him. Right where he went out. You'll know they're arguing because the next morning she tells the firefighter, I'm sad because our last moments were fighting. She drives away. They said she's made later statements that when she left, he didn't look mortally wounded. He lied on the ground on top of his phone, light dusting of snow now picking up. And he's just there. It's 12:37. Now, when he's in the car, before he gets to Fairview, the battery temperature of that phone is 77 degrees. 77 degrees in the one car. Now that he's been outside the car for 5 minutes, it drops to 70 degrees. She drives to his house. She makes a phone call at 12:33 after she's left Fairview. She calls again at 12:33 and leaves a message. You'll hear it. And you will hear the anger and rage in her voice. She leaves a message. John, I fucking hate you. Pardon my language. You will hear the simmering. And she leaves that message. He lies on the side of the road. He gets another text message that's unanswered. Where are you? 12:45.
So you can tell the difference between the opening and the closing. Like the jury was so tired, their attention was so bad. You know, he's like banging on things, he's pointing, he's banging on desks. Like he's just trying to keep everybody awake and attentive. They're all techniques. Here, this is a much more reserved opening than his closing. No? What does everybody else think? Right? Isn't it, Amy? It's hard to understand. You know, there really is, as my girlfriend was pointing out, really is no, we like to think that, we can use our, how logic and what's logical and reasonable when understanding Karen Reed's personality. And I don't know if you can follow it's reasonable, but it doesn't, it's she's doing a lot of two things at once. She's getting out her anger. She's covering up her crime. It's a lot of emotions, not deep emotions, anger, self-preservation, competing there. But I just think it's so interesting that when she was asked if she did it, she couldn't say she didn't do it. I mean, that's the first thing you'd say. Not me. I didn't do this. But she didn't. She said, we all know who did it. She knows she did it. She's just trying to play the system.
Battery temperature, 61 degrees. So he gets almost 40 calls from the defendant that night. His phone rings, but it never rings. You'll hear from an expert that the light never initiates the healthcare data never holds. He's gone alone with his only companion, his phone. At 12:53, cell phone drops to almost 60 degrees. 12:59, the defendant leaves another message on John's phone. Now, she hasn't spoken to anybody. Nobody has spoken to her, but her message is out. you'll learn the message says, John, nobody knows where you are. And this is where the plot in the cover-up begins. The evidence will make clear that she knew he was there. She did not call 911. She did not go back to him. She did not leave an anonymous note. She left.
Really important part that she never called 911. Never, ever, ever. She didn't want to leave that. She didn't want to leave that. This wasn't to get help. She didn't get help. She never got help. She brought in more characters so that they could witness her discovering John. She brought in an audience and she brought in other suspects. Because otherwise, it's just Karen and John. That's it. There's no one else. He never went in the house. There's no one else to blame it on. She brings in a lot of other people. She tried to bring in Catherine Camerano. Thankfully, she wasn't working. She did not testify in this trial. She wasn't a great witness last time. I think she knows a lot more than, and I believe Michael Camerano knows a lot more than he says. So, John was complaining about Karen that night. He barely got it out, almost apologetically, that John was complaining that Karen didn't ask him to fix her plumbing. Karen knew exactly how to make him mad. Oh, I have a plumber over. Plumber? I could do that. What? Do that for free. Papa and I could do that for free. What?
How will Michael Proctor play in the retrial?
Oh, he's going to play large in the retrial. They can't. Look, the prosecution.
He's going to play large in the retrial, but we won't call him. We're too wimpy to call him. So they by the way, so they did not ask for the jury, an instruction for the jury to think about uncalled witnesses, because obviously the obvious reason to me is that they could apply to the defense. The reason that they didn't call Proctor is because they had a weak case against him.
Prosecution, I think, probably wants very badly to take some magic eraser, some pixie dust, and erase Michael Proctor from the minds of the public, and certainly not from the minds of the new jury who's going to come in and assess this case. They're not going to be able to do it, not as long as we're breathing. Michael Proctor is going to be a part of this case, whether he likes it or not.
Because they don't necessarily have to call him, but obviously you have a right to call him as a witness.
Correct. And we will. If they don't call him, we will. We're not going to allow the Commonwealth to hide the truth from the last jury or this upcoming jury.
And the free Karen readers don't get that. Don't get these false promises. We ain't got no quit. We're blah. You know. Mistrial. They don't see it when they're like, we're going to call Proctor. Then they don't think anything odd. They don't think, if Proctor is so guilty of planning everything, why wouldn't the defense even call him in?
The night wears on. It's now 1:07. Battery temperature 55 degrees. 1:14, she calls her mother. No answer. 1:14:53. Battery temperature 50 degrees. The defendant had healthcare data on her phone as well. You'll hear that it stops around that time. You later learn that if it's too long, she's passing out. But then she wakes. 5 o'clock, she is frantic. She wakes up John's niece and she is unintelligible. She is yelling, she's screaming, she asks for the niece to call Jen McCabe. She calls Jen McCabe, and you'll hear Jen McCabe recount. Out of deep sleep, she wakes up and she hears, Jen, 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 screaming Jen's name. John's dead. Hangs up the phone. Jen McCabe calls down. And then she, what's going on? And she told, well, I left him at the waterfall at the beginning of the cover. She tells Jen McCabe, I left him at the waterfall. Jen calls back and says, sidewalk front. You did leave a lot of fault. She hangs up. He then minutes later calls another person, Terry Roberts, a friend of John O'Keefe. Someone who's not friends with the defendant, but they know because they helped raise the kids when they interacted. She had nothing to do with the night before, wasn't at the bars, was home with her family. She calls her and says, I think John might be by a fly. I think he's dead. Now, Terry, with that information, calls 911. She calls hospitals. You can hear her voice. She's concerned. Okay. And then she gets another call from the defendant. And she tells the defendant, come to my house. I will help you look for him. And the defendant says, I was so drunk last night, I don't remember anything. Waiting for her to arrive, she learns she doesn't arrive. Instead, the defendant goes to Jen McCabe's house. Terry Roberts, the other friend, then goes to Jen McCabe's house, pulls behind the car. When she does, she's on Bluetooth, but she can hear the defendant say, my taillight's broken, my taillight's broken. And she looks, and the snow packed in the right taillight, she can see a piece of the taillight missing. The defendant desperately wants to go to 34th Fairview Road. Terry Roberts takes over and says, we're going to go back to John's house. Maybe he's in the house when you didn't see him. So both cars, driven by Terry Roberts and then Jen McCabe, with the defendant, go back to John O'Keefe's house. You'll see a ring video where you see them go into the house and they look around, and you'll hear about the woman, Jen and Terry, enlisted into this task. Look for John O'Keefe. They cannot find him. And then when Terry Roberts comes into a room, she sees, rather than looking, the defendant simply standing there, staring at the wall. At that point, the defendant insists they got to go back to Fairview Road. They decide to take one car. Terry Roberts is taking charge. She's going to drive. They leave Mr. Lexus and John O'Keefe's driveway, and they drive back towards 34th Fairview Road. There it is blizzard-like conditions. It is dark. They can barely see a thing. And when they get close to the edge of 34th Fairview, you hear the defendant start to scream, there he is. Both women look and they can't see anything. She starts kicking the door. The defendant's kicking the door, let me out. Terry Roberts stops the car and lets her out, and she sees the defendant run exactly to where John O'Keefe is in the darkness. That's where she left him. Terry gets out of the car, starts to walk towards where the defendant is, and she sees the defendant lying on a body. She can't tell who it is because the face is still covered with snow. And she comes over and looks, and she wipes off the snow from John O'Keefe's face. She realizes it's one of her best friends in the world is John O'Keefe. And she starts to try to do first aid. They start to move him, and coincidentally at 6:06, when they start to move him, the cold air hits that cell phone battery. It drops from 50 to 43 degrees. And they try, Jen McCabe calls 911. And that's when a police officer arrives, firefighter Nuttall and his crew. And when they lift him, that cell phone battery that is shut down to 37 degrees, Terry Roberts picks it up and puts it in her pocket, and it immediately starts to warm. As she moves to help get a data, showing movement starts again. At that point, nobody knows what happened. The Canton Police Department come. You can see their police cars and cruisers. They're not sure, so they look in the area where John's body is and find a glass from the bar. His body. They find blood spots. They try to put the blood spots in plastic containers. They don't know what they're looking for at this point. There's no information. They don't believe or know that there's a crime. They just know that John O'Keefe somehow ended up here with the broken glass and the blood. And so that morning, you can see the work of the Canton Police Department try to uncover a little bit around his body to see what they could find, which was very little. And then Terry Roberts goes and picks up Ed O'Keefe, tells them the news, and they go to the hospital. They go to the Good Samaritan Hospital, and Terry Roberts is walking, and O'Keefe is going to go see her son, her husband. And as she walks down the hall, Karen Reed is also in the hospital. See, there was some reports of maybe she was upset or suicidal, so they sectioned her. They put her into evaluation to make sure she was safe. You'll hear Peg O'Keefe tell her she walked down the hall to go see her son. The defendant was screaming, "Is he dead? Is he dead?" As she walked by Karen Reed, she stopped and she said, "Karen, what happened?" And you hear that Erin was excited and yelling, "He's dead, stops her excitement, becomes stoic, doesn't say a word. Peggy pays respects to her son, and then she has to go back home because she has to tell the children. Now, while she's out, the Canton Police Department send an officer to the house to make sure the children are safe because they're alone, they're home. And when the officer pulls in, he doesn't notice anything. But you'll see on the dash cam video notices something. That tail light has a big missing piece to it. They can't find the children. Ultimately, Peggy comes home, a friend has taken them, and they bring the nephew home, and he is distraught. And then Peggy hears a knock on the door. It is the defendant and her father. They want to come in. They come in, open doors, and they ask, "Can we go upstairs to John's room?" And she's busy consoling her grandson. They go upstairs, they're upstairs for about 15 minutes. They come down, quickly they leave. Now they got there from the defendant's father, drove his wife and the father to that house. But when they leave, they take two cars. They take the Lexus with the broken tail light with them back to the defendant's father's house. And you will learn that when police start getting some of the information, they learn about the broken tail light, they learn information that she had told people that she had hit him. They went down to see her. And on their way down, they decided they would get a warrant to take the Lexus. When they get down to Dighton, where the car is, you'll hear from Trooper Buchanan. He took a look and see the missing tail light. They went in and spoke briefly to the defendant. They took the car, they brought it back to Canton. And so what you'll learn from the forensic evidence that will help with the science and data is that not only was the cell phone left behind, but also around that area, broken tail light was littered around John O'Keefe's body. Littered around that area. When they got to the hospital, they noticed there was a shoe missing. As time went by, snow melted, they done the excavations, they found the shoe on a little berm on the border between the street and the grass. We learned days later when they did a plant excavation, they found his cat frozen to the ground. Ultimately, they would find over the course of 10 days that the snow melted almost all every piece of that broken tail light in that area. His hat, the sneaker, the glass. When the defendant left Mr. O'Keefe behind, he took with her something of Mr. O'Keefe called trace evidence. You'll learn on the back of her Lexus, around the taillight area, is John's DNA, and stuck to the side, grasping one last piece of John O'Keefe's hair. Now, John O'Keefe fell backwards and hit his head after he was clipped by a car. And you're going to hear from a very renowned doctor and neurosurgeon who has treated thousands and thousands of head injuries. And the wound on the back of the head, when he fell backwards, not only cracked the skull, it's called a basal fracture. It created an injury called counter-coup. After he was put by a car and fell backwards and hit his head on that hard rock ground. Remember, there's no snow, it's just a dusting at this point. The back of his brain hits the back of his skull and bounces up. When it bounces up, it leaves marks showing that impact. And this neurosurgeon will tell you, treated thousands of patients, that this injury, with reasonable degree of medical certainty, is counter-coup caused by falling backwards in the head. When the medical examiner for the state looked at it, they generally said one force trauma, they had it undetermined. So we brought it to the renowned neurosurgeon who does exactly this. You're also going to hear from an active reconstruction. His name is Doug Welcher. Does not work for the state police or local police. He was hired to take a look at this case and the data. He will come in and explain to you exactly what I talked about, how the data from that black box coincides with the cell phone in the movements of the car, the moments before, during, and after the defendant struck John O'Keefe with her car. Now, just a few more things I want to share with you. There are 3 charges against the defendant in this case. The first one, second-degree murder. When most people hear murder, they instantly think shooting somebody, stabbing somebody, putting no deliberate premeditation. I will instruct you on the law. I'm not going to trample in that area, but I can tell you clearly, we are not going to try to prove that Karen Reed tried to kill John O'Keefe. We're not going to try to prove that she intended or wanted him dead. That's not second-degree murder. What we will prove to you is she engaged in an intentional act, driving back at him at that speed in the storm, in the darkness, knowing that he had just gotten out of her Lexus. She intended that act, which could cause a plain, strong likelihood of death. That's what we will prove to you second-degree murder. Also, operating under the influence of alcohol, manslaughter will prove to you that she drove her Lexus recklessly. She hit John O'Keefe, and because she hit him and he fell back, she caused his death. The third charge is leaving the scene after knowingly causing death. Again, she hit Mr. O'Keefe with a car. She knew he was injured. She left him behind. He died. This case will come down to the science and the data. The science and the data that a cell phone is the best of historians. It doesn't suffer.
And Karen Reed's own words. Karen Reed's own makeup. I mean, you know, how many times has the defense lied to their supporters? How many times? We're going to call Michael Proctor, the feds are coming, the blah, 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 and there's still, you know, and they just wait for the next lie, you know? So I will tell you, though, that when they shut that door, you're a juror, it is a weird feeling. Like, it is a weird 12 angry men kind of feeling. They lock you in there. You feel locked in. I don't know if you're actually locked in, but with like a coffee maker, pod coffee maker, some creamer, some dried creamer. I remember we had a smoker on our juror. I don't know how he made it through days. I don't know how they did that. I was like, dude, bad idea. Why don't you wear a patch? Why don't you bring some nicotine gum into here? Because we had one. So the first vote was 11-1. I know you've heard this before. Some of you have heard this before. But it is an odd, like, lonely kind of feeling, like, you know, will I ever get out of this room? I know we went out just for a walk at one point because of the smoker. He wanted to smoke. So I went with him. I just went out, you know. It's very kind of claustrophobic. You're trapped with 12 strangers, you know, 11 other strangers. You know, I became friendly with the woman next to me. She was a nice artist woman. But I didn't know. You don't know how these people feel. Here's Hester Prynne on, she might walk, but she will always be guilty. True. She could walk. Where are we? I mean, you know, it's looking less likely the more this goes on. We're down to a 70 chance of acquittal now on Poly Market. You could win $40 for your $10 if you think she'll be guilty in the officer's death. Prison time, no prison time, 57%. So this is like up from the way high 70s. So kind of interesting. I don't know. You want to see the Poly Market where we're at now? I guess the longer this goes on. So Karen Reed, prison time, 57%. No prison time, 28. Guilty. Yes, you win $40. I mean, like most people are saying, 24% chance of finding guilty. Acquitted on all charges, 70% chance. That was down from 75 this morning. That's how Polymarket's going. I don't know who's betting on this, betting on a murder trial. I'm not a gambler. I'm just kind of following it to remind myself of, the massive propaganda campaign we've had in this. We're looking at the same. We haven't had any questions from the jury yet. They don't seem confused about, I don't know if they're obviously not confused about the verdict slips or anything else yet. They haven't asked to specifically, I guess they have all the exhibits back there they need, I hope. But yeah, not one communication from the jury. But they're certainly not, if this is such a easy case with no evidence, like the Karen readers say, they should be back by now. They should be back with a full acquittal. So we're going into lunch soon. I mean, they haven't even come back for the mid-morning break. When is that? 11:30 or 12? I didn't even get the pace of this. I just hyper-focused out. I guess they don't get that mid-morning break. They just deliberate through. Yeah, they should be freaking. I mean, I think they expected them to come back right away. I mean, you just don't know what they're talking about, what's going on. I mean, it would be a lot easier if we could see the jurors' faces and we could kind of read them. I was covering Nexium trial. I mean, it was obvious to me, not in the beginning, but by the end, that they were ready to convict Keith Raniere. It was like a bad smell every time the defense came up. And, I mean, if this is any indication, let me try to show you this. This is, this may be my ever hopefulness. I don't know. It's going to be very bad if they're really consuming a lot of social media. It will be very bad. And then, of course, we have this. Like, look at this nonsense. Like, look at all the free Karen readers are all on the sidewalk. But I wanted to show you this again. I mean, they're doing everything they can to taint the jury pool, for sure. Look at this. Look at how ridiculous this is. I had to. Let me see if I can go back. Look at Alan Jackson. Look at the drama of this.
Because it was a dog. Because it was a dog.
Because it was a dog. Let me try to keep you awake. Boy, so many of these. Just like that Australian mushroom cap murder she poisoned her whole family, but she strangely didn't get sick. It's really hard to say it's a mistake when everybody dies almost or gets very ill but you. It's hard to say it's a mistake, but here's how she left the courthouse after closing arguments. Take a look. She's in florals. I guess she finally decided to soften herself up. Take a look here. No comments. So that's Ingrid Curtis. It's her friend who has the home. She lives in Atlanta, but she has a home in Sarasota, Florida. This is it doesn't look so bad when she puts her hair up, but Elizabeth Little, regrettable, I think. The bangs, regrettable. I think she, was much more flattering before she cut her hair. She's a good-looking woman. I'm not, nothing, I'm not saying anything about anyone's looks. I just thought the bangs were regrettable. We've all had those regrettable haircuts. I remember my friend gave me a card for my birthday once. He thought it was funnier than the birthday cards. My condolences on your haircut. We've all had those really regret. Once I had my whole head was so bad, I just told her to cut it all off. I had and I started from almost no hair, and I grew it all out again. It was that bad a haircut.
Yeah, you only get 3. Guys, we have no time for minutes. No. How do you feel about the close? I got a gag order, so I can't talk. All right. And for you, how did you feel your turn?
So he doesn't want Karen Reed to talk. We have no time. They always have time to talk to the press. Karen Reed loves this. She loves the attention. I am keeping an eye. We still have a fan, guys. I am keeping an eye on the jury.
Keep it going, guys. Hey, get right on. How are you feeling about your chances? Thanks, Mike. Where's Karen? Oh, there she goes. Come with me. Come with me. Mike's got us. Mike's got us. Tell your lead. Got it. Got it. You got it.
Karen, how are you going to spend verdict watch?
When?
So not a word. Not a word. Or maybe she feels like she doesn't need to propagandize the public anymore. They always seem to want to propagandize the public. If Karen Reed is not acquitted on all charges, I'm not going to be okay, says Emily on Twitter. That's Oh, they're all complaining about the verdict form. Oh boy. They just take their cues from the Karen Reed defense team. The verdict now, this is the latest injustice. Here's a greatest of Karen Reed's family. Daddy Reed. You can hit the Daddy Reed emoji, all you channel subscribers. Daddy Reed and their mom, they're the same age. And then there's Nathan, who wasn't there for the closing. Does anybody know why not? I mean, yeah, I agree. Daddy Reed, such a criminal. Look at the data, no collision. I know the justice for John O'Keefe, but maybe that'll come later. It's not coming. Nobody else did this. There's no evidence that goes to anyone else. There's no evidence that goes to anyone else but Karen Reed. If we don't get justice for John O'Keefe in this trial or the next trial, I see justice, but this is the closest we come to. There is no justice, really. This is the closest our system can get to justice. Some people would say justice would be the death penalty for Karen Reed. Some people would say that. So, I mean, this is as close as we can give to the O'Keefe family. But nothing's bringing him back. They have been sentenced to a life sentence of grief. Look at this. Here's this nutto. Look at this. Look at the scene that Judge Cannone has created. She's created a madhouse. Madhouse. This is just so wrong. So wrong. I would love to be there with just a big sign. She hit him. She hit him. She was drunk. She hit him and she left him to die, Justice for John O'Keefe. Boy, would I love to be there for that. She's terrible. Terrible. I mean, there's just no need. I mean, the at minimum, what you want to do is they're being very quiet, as you could hear, because she says she's not going to let the defense team out if they make noise. We need you alive. You think I would get killed? I'm pretty tough. Just me. I'm crazy like that. I would totally go. It is a danger to society. I wish I could go. I wish I could go there for the O'Keefe family and represent, you know. Unfortunately, it's a big, long trip for me from New York to Boston. I do have friends in that area, though. Yeah, I mean, really. I mean, this is really... There's good people. Don't dehumanize them. There's good people, cinnamon buns, who've just gotten fooled. There's a lot of disturbed people with criminal pasts and very vicious and very nasty. But there's good people who are just gotten fooled in there. Let's try to remember not to dehumanize the other side. It's easy. It's easy to do. And I've definitely done it in my head too. You just get so much abuse. They don't listen to my show, but they do come on and they do leave, nasty comments. Very personal, nasty comments. Because what they want to do is they want to shut you up. They want to make it so difficult for you to report on this side of the fence. And they want no one else. And also, I haven't really been helped a lot by anyone on this side of the fence either. On the Karen Reed is guilty side has often gone after me. So I don't have a lot of support. For just asking questions like, why manslaughter? Why this? Why that? Why are you saying this story? Why are you putting out these false narratives? Even if you think she might be guilty of something. I just don't. Roberta with a big signboard. She hit him. I would love it. I would love it. I grew up with especially my mother was a protest. She was just protesting this weekend. But she always had us at protests. Our car, we'd come out and our tires would be slashed. I grew up with that kind of... People would call in the middle of the night and call my parents communists. Yeah. So I'm used to the pushback. I grew up with this. So yeah. So I don't know. I think I would do okay. I think the thing to do when you're in that is try to be kind to those people if you can, or not communicate with them. Either or. That's what I've found with pushback if you're protesting. Try to represent yourself well and don't sink to their level. But I would not suggest that anyone bring their children to protests. I think that's a real mistake. Not a good idea. Let them develop their own ideas and their own identity. And it's stressful on children to put these big issues, even if it's Karen Reed, on them. They don't need any more stress. It's stressful enough just being a human being. What else can I show you, guys? I don't know. This is stressful. This is stressful waiting for a verdict now. I hope we have a verdict today. It would be nice to have a verdict today or tomorrow, wouldn't it? But Karen Reed, if Karen Reed gets off, she's going to go around like she's, let's not forget, everybody knew Jesse Smollett was guilty. I mean, first they dropped the charges, then Martin Pryde was a friend of the show. He was really instrumental in getting those charges brought back on Jesse Smollett. Then they have this farce kind of trial where he's allowed to start screaming in the court. I mean, what is up with these judges that let these defendants carry on like that? Like the victims' families are not allowed to have a reaction with the verdict. They're not allowed to scream or cry, but the defendant's allowed to raise his fist and start screaming in the court. I'm not guilty, blah, blah, blah. That guy is so guilty. And that's Chicago. That is Innocence Fraud Central. They invented a lot of these tactics, disrupt the court. I'm surprised Karen Reed wasn't more disruptive. Thank God she wasn't. But what would Judge Cannoni do if she did something like that, I mean, she did give the middle finger. She did roll her eyes. Was rude. I heard her family was really rude to the O'Keefe family. Here is what the scene is like outside Norfolk Superior Court. This is from Boston 25, basically the free Karen Reed channel. I'll give you an idea just while we're waiting.
Breslin is live outside of Norfolk Superior Court, and Ryan, the jury, shortly met before being excused for the weekend.
That's right, Catherine, and they are now back to deliberating this morning. We are waiting outside of Norfolk Superior Court right now with a number of media members for Karen Reed and her defense team to leave. I want to show you across the street. You can see all of her supporters, many of them wearing pink. They have been standing here all morning.
What a farce. What a farce, Judge Cannoni. What a joke of a judge you are, allowing this to go on. Nonsense. I mean, the reason you don't allow something like this to go on is because you want these decisions to be made in our court system, not the court of public opinion. You do not want to have the jury feel the weight of the pressure of the public. This is what they're trying to do. It's the only reason they're there. They're not there to see Karen Reed. They could have seen Karen Reed a number of other times, places, etc. They want to put pressure on the jury to vote the way they want. And when I say I want to be there with a sign, the only reason I would do that is to try to combat some of this. But it shouldn't have to be up to who shows up at court, and it should be all about the evidence and the facts. And that is why you start an innocence fraud campaign when you can't win in court and the facts don't support an acquittal, or you start an innocence fraud campaign, because you can go all sorts of directions in the court of public opinion. You don't have to have good evidence. You can have rumors, fantasies. You can lie to the documentary crew. You can lie to the press. There's no consequences for that.
Some pulling up the live stream of Inside of Court. Now, one of the things that I do want to talk about is a motion from the defense. We don't exactly have a filing of it yet, but it has to do with the jury slip and about the verdict. So we know the defense wants a not guilty box added on the lesser charge included for manslaughter while operating under the influence. The jury only deliberated for under 2 hours before they went home on Friday. Remember, these are the 3 charges that Karen Reed faces: second-degree murder, manslaughter while operating under the influence, and leaving the scene of a fatal crash. Now, Friday morning, jurors heard closing arguments. Alan Jackson for the defense and Hank Brennan for the Commonwealth giving those 1 hour, 15-minute speeches. The jury heard opposing versions of what happened to John O'Keefe in Canton. Defense attorney Alan Jackson said that there was no collision. Prosecutor Hank Brennan.
Was Alan Jackson's an hour and 15 minutes? He seemed to go over. His was like 2 hours, I thought. Hank Brennan's was like a little over an hour. Did anyone time them?
Played Reed's TV interviews and said that Reed was drunk, that she hit him, and that she left him to die. Outside of court, Karen Reed says that she was anxious and planned to get sleep this weekend.
We've done everything we can, the instructions, the verdict slip. You've seen us fighting in court.
So once again, a live look outside of Norfolk Superior Court this morning as we wait for Karen Reed and her defense team to walk through those doors. It looks like that should be happening any minute, or it's happening right now. So let's stay on this for right now. Karen Reed is about to leave the steps. She is heading to the top of them right now, and her and Alan Jackson, her defense attorney, are walking down those steps at this moment. We're going to see if she has anything to say about what they are talking about with the jury slips. I'm going to put my microphone in there.
Wrote a motion to reconsider the verdict slip that was just denied without a hearing.
You want more boxes added to that verdict
Yes.
slip, the lesser included.
Yes.
Can you explain why that's important to you?
I think what happened last year with the same verdict form explains that the jurors themselves found it confusing, and have said as much. So we just wanted to avoid that again, and apparently the court is not concerned. So we'll just move forward and wait on the jury.
Overall feelings heading into today, Karen?
I feel well, I feel strong, and the jury will do the right thing. We chose them.
What are you going to do right now?
Eat something.
Do you feel more confident with 7 women on the jury?
I don't even know what the breakdown is. Is that what it is?
7 women, 5 men. Yeah, I'd love to find it the time. I'm going to look for that at lunch. Exactly how long Alan Jackson's closing was. Did anybody say and I missed it? People were guessing like an hour and a half, but 90 minutes, wasn't it? Okay, Debbie, are you guessing or did you go back and look? Did you calculate? I need someone who calculated. Give me hard facts. Give me hard facts, guys. I don't need I don't need a roundabout. I need hard facts. Was it Gypsy? Is that a hard fact? Tell me it's a hard fact, not a guess. Thank you. Is that a hard fact? It's very convincing with the 4 minutes. Cos. Are you joking with me? Are you pulling my leg? 1 minute, 24 minutes. Felt long. What happened to Adam Lally when he went over 1 minute? 1 hour, 24 minutes. Okay, thank you. What happened to Adam Lally when he went over 1 minute? Judge Cannoni just started to say, time's up. Why didn't Alan Jackson get that? The minute Adam Lally went over, she yelled at him to close it down. Why didn't Alan Jackson get the same treatment?
Okay.
Oh, that's not. Somebody lost their shoe. You chose not to play extended clips. Those media clips, you had said you might play more to put them in context. Can you give us some insight into that decision?
I can't. Sorry.
You can't because because there is no context that makes it any less incriminating. That's why you can't. I love that. I can't. You can't. Is it because it's so incriminating? Why don't they ask no tough questions? If you look at their faces, someone shot their face. They're all smiling. And I know you want Karen Reed to answer your questions, but ask tough questions. Just ask. Carl Dougal is the only one who's ever asked tough questions of Karen Reed. That's why I play it over and over again. It was so informative to the public. Well, why'd you admit it? She did 3 or 4 times. Let me see if I can find that. Do I have my old opening up somewhere? Hold on. Let me play the rest of this, but while I look.
Sorry.
And so that was a live look of Karen Reed exiting the courthouse right now. She is still on her way to her SUV. You can see her with a number of media around her. She will be heading to that SUV right now. We did get in some questions to her. She did stop and answer some questions this morning about those jury slips and wanting to get those jury slips changed. We will, of course, stay on top of this story up until we get a verdict from those jurors who are now deliberating. For now, live in Dedham, Ryan Breslin for your local station, Boston 25 News.
Now we've gone up to a 77% chance of an acquittal. Polymarket's all over the place. It's a great chance if you think she's going to get, if you're a gambler and you think she's going to get convicted. I'm just not a gambler. What would it be if you more than double your money? So if you put down $10, you get $26.70. All right, hold on. Wow, it's really like I'm just looking for. I thought it would be so easy for me to pull up this interview. To me, it's such a notorious interview of Karen Reed on the courthouse steps, but the press is really, I mean, first of all, YouTube always shows you like the most recent things. So when you're looking for old things, it's harder to find. But let me see if I can pull it up as a video and show you. This used to be my, I mean, people have been following my channel for a while. They're familiar with it, but for those who are new,
No, you didn't do it.
We know who did it, Steve. We
no,
know.
that's the
And we
old
know who
one.
spearheaded this cover up. You
Yeah, that's the old one. Hold on. Hold on. No. Ay, ay, ay. Oh. Okay, I know what I can do instead. Go to my own channel. Go to my own channel. Go to an old show. That's what I can do. How is everybody doing? Feeling as this goes on? Are we going into another hung jury? Is there a stealth juror on there? Is there a stealth free Karen reader on there? Okay, I think that's too early to tell. We chose them. No, you didn't choose them, Karen. You didn't choose them. The Commonwealth chose them and your team. That's it. Oh, okay. Here's the old opening. Here, this is where you can get a view. CBS News Boston, WBZ has. So did everybody get that? She can't even deny it. Alan Jackson has to rescue her from that. That doesn't matter that you tried to save his life. And she didn't. She didn't do CPR. But listen to this. The end of this is so great. I love that feral look. Do you see that feral? She's like almost about to bite him. Look, she's like biting the air. Right there. Right there. She didn't admit to it. Watch it. Watch it again. Keep your eye on Karen. Right there. Right there. Yeah. Like, really, that is an aggressive face right there. Feral. Feral, feral. Oh, whoa, whoa, whoa. Am I not sharing? What am I doing? Did you not see that? Was I not sharing? Holy cow. Holy cow. Go back. Okay. Sorry. It says I'm sharing. Hold on. I think I just messed up. Hold on. Share screen. Here we go. We'll start it again. All right. Sorry. We'll start it. Here's the whole thing again.
Today, for the first time, Karen Reed herself doubling down, of course, saying she did not do this. She wants to know who did.
Said it feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do. And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life.
Yeah.
I tried to save his life at 6 a.m. I was covered in only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that.
So that's Carl Dougal, John O'Keefe's friend. Because you can't count on the Massachusetts press to ask a decent question. It's the only time Karen Reed's ever been asked a tough question, right here.
Nothing close to that. And you should know that.
That was like 3 or 4 times.
No, she didn't.
That's not true.
She asked a question.
I love it. No, it's not true. It's not true. What? You're not part of the Massachusetts media that's going to keep putting out our innocence fraud campaign, Carl? You're not a snake in the grass like Karina Kolakith is? Unreal. No, it's not true. Look, and so she can't say that she didn't do it. We all know who did it. Yeah, you, Karen. That doesn't leave you out of it. So telling. That's why I used to play this clip all the time.
Question. She asked a question which is very different. She didn't admit to anything.
Okay, right here. Keep your eye on Karen.
No, she didn't.
Keep your eye on Karen.
That's not true.
She asked a question. She asked a question which is very different. She didn't admit to anything.
See that? See it? It's like, it's very feral. Feral Karen.
She asked a question which is very different. She didn't admit to anything.
Yeah. Like, almost, like very, very aggressive with her mouth. Okay. Yeah, so obvious, right? So obvious. Everyone who's lived on planet Earth and understands the evidence in this case, and not just the propaganda. I think she's. Oh, yeah. It's so gay. Oh, it's like a. Thank you, Carl Dougal, for that great interview. Thank God. Thank God you were there for that hearing. It's the most telling Karen Reed interview. It's not why I think she's guilty. It's obviously the totality of the evidence, but it's very telling if you lived on planet Earth a little while. Also, let me see if I still have it. Let me see if I still have it. I wanted to show you. Hold on. I don't know if I was smart enough to put it into my watch later. John O'Keefe's cousin gave a touching interview. I wanted to play it.
No court in the Karen Reed murder retrial today, but our coverage continues. Only on Boston 25, we are speaking with a member of John O'Keefe's family. Boston 25 News reporter Daniel Coates spoke to John's cousin, a former employee here at Boston 25 News, in an emotional one-on-one interview.
Well, John O'Keefe's family says that the last 3 years, frankly, have been a nightmare, and they haven't been able to grieve or mourn the loss of their loved one. That cousin told me that John O'Keefe wasn't just an extended family member, but was more like a brother to her.
I literally beat myself up about that every day because it's the last time I would have seen my cousin alive.
Vanessa Rizzitano's final texts to John O'Keefe have echoed in her head for 3 years. In late 2021, she made a trip back home to Massachusetts while working in upstate New York, looking to reconnect with her cousin back home.
I was like, oh, let's get together. With the kids, let's do something, let's get together. And then life got in the way, we got busy, and it never happened.
Months later, he was found dead on the front lawn of 34 Fairview Road in Canton.
I'm like, how do my aunt and my uncle and my little cousins and his brother and his wife, how do they even get through each day?
Rizzitano sat with O'Keefe's direct family inside court over the last 2 months. 6 years ago, though, she graduated college and didn't know where she lived next. Her parents told her to call her cousin Johnny.
He's like, absolutely, kiddo.
For 6 months, she lived with the Boston police officer and his niece and nephew in Canton.
He would make time for everybody, really just put everyone before himself.
That huge family says they've been living through a nightmare, unable to grieve and bombarded with hate in public and online.
Johnny deserved a better family. He should be ashamed of his family. He's looking down, all of this nasty stuff.
What do you think Johnny
I made a video about that. That turtle boy went after her when she said, "Why are you?" When he first started covering this case, knowing nothing about it, didn't even know where John O'Keefe's body was found. He's like, "I think he was found in the driveway." He went after her, and that's the episode that David Yannetti said was great turtle reporting. Liz B, thanks so much. I heard a paddy wagon was there Friday. Is it there again? Will she be remanded? I hear she will be if she's found guilty on serious charges. I think anything but driving under the influence. She's manslaughter or manslaughter and driving under the influence. These people need to find a hobby. No, strawberry, thank you. Sorry, I'm really behind. I'm sorry, guys. LA woman in Vegas. Love to hear about your dream last night. I don't remember it well enough. I just know that Donna Adelson was in there somehow in her full prisonness. Dean Walker. Thanks so much for the super sticker. But back to Vanessa Rizziano, John O'Keefe's cousin.
You would have thought of all of this.
I know that Johnny would be really ashamed and hurt.
For Rizziano's family, the Karen Reed case isn't entertainment. They're still grieving the loss of a loved one. Rizziano and some of O'Keefe's relatives, though, carry his memory with this tattoo, asking everyone to remember their guardian angel as the trial nears its end.
It's nerves, it's anxiety. All you have to do is just hope.
Day 28 of testimony in the Karen Reed murder retrial will once again pick up on Friday morning. We'll be inside the courthouse, bringing you the latest on air and online. On scene in Dedham, I'm Daniel Coates for local station, Boston 25 News.
I wish they did
A
more
murder
of
case
those.
that we couldn't take our eyes off of in 2024.
Oh, this is like the murder apologist channel, News Nation. They're really some of the worst. Some of the worst. Mark Garagos. Karen Reed's retrial not good for the prosecution. I don't even know. I can't hear that today. I'm gonna put my head in the sand like an ostrich for that one. It's too tense. Too tense today, waiting for a verdict to hear Mark Garagos, who came in and represented Claire Bronfman. I got to see him in the courtroom. And he came in, he made a major faux pas. So Claire Bronfman was asked how she found Mark Garagos, and she said she Googled him. And then he came into the courtroom and said, I've known Claire Bronfman since she was a little girl. And his daughter, Teeny, was on Keith Ranieri's defense team. She's representing someone like Diddy now or someone like that, but she wanted to join the Brooklyn federal prosecutors, and she didn't make it. They didn't hire her. I don't know why not, but they didn't. But he was there with Michael Avenatti, and it's a little known fact or about Michael Avenatti. He's thought to have made that deal with Nike, or basically he was caught convicted of entrapping Nike or accused of it. I don't know if he ever got convicted of it. He was at least accused of it. Forgive me if I'm wrong on that. I haven't gone over this in a while. But to try to get Claire a better deal, to negotiate a better deal for Claire Bronfman. She's out already, Claire Bronfman. She's given 7.5 years, and she got out way early. I just heard Allison Mack, also another NXIVM member, just got married out of prison She did 2.5 years or something like that. 2 years, 2.5 years. Pretty little time for all the hurt she caused. But she pled out. Unlike Keith Raniere wanted a trial. Apparently was obsessed with the O.J. Simpson case himself. Thought he could game the system. He rolled the dice, and it was he got 120 years. But Mark Aragos came in and tried to do his best for Claire Barfin with Michael Avenatti. She had so many different legal teams. The judge Judge Garifas was always. I hear the Blake Lively case, that case in New York, I don't know a whole lot about it, but that Judge Lyman, who was the judge in another case that I covered from the courtroom, Larry Ray, he was the judge in Larry Ray, great judge, but he threw out most of the stuff for Justin that he wanted. Hold on. I'm just going to put on another emoji for John O'Keefe into for the members. Just going to do that. Hold on one second, guys. Okay, so that's up. You can, if you put in Justice JJ, you can, it says badge number and some wings. Jamie, super sticker. Okay, thank you so much. Hold on one second. Let me let out my cat. I'll be right back. I hope that something exciting happens. Let me know. Hold on. I'm just gonna open the door for my cat. Okay, I'm back. That was a little bit longer than I thought. My boyfriend said, he said, what's going on? I said, no verdict. He goes, that's not good. I'm like, that is good. That is good. They didn't come back with an acquittal. Wouldn't it be curious if we get the same result, we get another hung jury? I mean, I don't even want to put that out in the ether, but wouldn't that be funny? I mean, all about how brilliant Hank Brennan was and how much better he was than Lally or blah, blah, blah. They'll continue to beat a drum even if she gets a conviction. Then it will really be free Karen Reed. Karen Reed will finally be in prison. Little kitty, dude. Okay, so just a cat update on this guy. Hold on. I'm gonna have to get up again. So I let him out, and then he comes back in again. Follows me back in. Dude. I need that cat door. Hold on. Yeah, I can't keep it open because my boyfriend's working. He's on a Zoom call, so he's got to pick one side of the door. So yeah, we have no verdict yet. I mean, it's not good for Karen Reed acquittal. You'd think they'd come back. It was so obvious, no evidence, but they could come back anytime with an acquittal. There's no time frame for that. It's just certainly we've gone beyond. There's a lot more evidence, though. This is a long trial. They have a lot of evidence to go through. I mean, do you think anyone's going to pick up on the jury on Richie the plumber, the missing witness for Karen Reed? We never heard. I don't know why Hank Brennan didn't ask that one question. Were there any text messages, officer, on Karen Reed's phone to a plumber? Show her as a liar. Why is the prosecution in both the struggled so hard to present Karen Reed well, you know? It's almost like they're apologizing as they're prosecuting her. Everyone liked her, you know. Didn't seem like John's mother liked her too much. Anyway, here's a song about Richie the plumber.
Everyone is waiting for me to arrive at the bar. At home in Mansfield, I'm making up a new co-star. His name is Richie the plumber. No hot water, it's a bummer. It's all a figment of my imagination. Call it a lie, I feign rightful indignation. Call the plumber, I got a rusty pipe. Hot water is not working, I'm starting a fight. Sure it's a lie, but it's a little one. Gotta get my boyfriend under my thumb. John says he and his papa would have fixed it if only this broken pipe in real life existed. Causing pain and suffering is what I do best. Putting my boyfriend's patience through test after test. Richie, my imaginary plumber, is at Home Depot, hoping that story will get a rise out of my pulling up late, make him angry right out of the gate. He's slow at feeling lovey-dovey. I'm downright twisted and scummy. I'll down many drinks and run him over after it gets late. Scream and cry, it's you, John, who I hate. Leave him to die in a blizzard, inflicting pain. I'm a wizard. Get Jen to call 911. Have the whole town pointing fingers when it's over and done.
Does anyone else want to see? I'm just thinking maybe we could, for a little rare humor, we could watch The Cross of Marie Russell. Let me see. I mean, remember this? Doesn't this look like a Tyrannosaurus? I mean, I thought you was going to say this is Tyrannosaurus. Let's see. Let's see.
No commentary, Mr. Brennan.
You
Done more episodes on Karen Reed. So they're back at 2. So I think this is when they start here. None. Every ordained kitty.
over a period of 27 years, yes?
Yes.
Which is 1,000 weeks in your estimation.
Yes.
You worked for some of the most busiest ERs. Was there a lot of patients every day that you treated?
Yes.
On average, how many patients would you treat in the ER over those 27 years on a daily basis?
Daily, I would think about 30.
So if you're treating 30 patients a day over the course of a week, and you consider that in the context of 1,000 weeks, the amount of dog bite cases that you treated in the ER is about half of 1%. Wouldn't that be fair to say?
No, you lost me on that.
Okay.
Sorry.
Well, if you had one dog bite case a week, let's say you had 20 cases a day, 100, that would be 1% of your patients.
Oh, it could, yes, yes, but it's the number of cases, not the percentage that was asked of me. Okay.
So she was supposed to report all her dog bite cases. There's a law in California that you're supposed to report them anytime you treat a dog bite. So there should be some records of this. Someone sent me that yesterday. You did. I don't know if you want to be called out. Let me know. Said, look, this woman should be sent. Right. So he's saying that anybody good with math, you're seeing 30 patients a day. And I don't know how many years did she work in the ER? I think he's calling BS. I don't know if he's calling BS on the number of patients. He's saying it's 1% of her, probably 1% of the patients she saw were for dog bites. But 1,000 patients? 1,000? I find that hard to believe.
Just want to clarify that.
Well, now it's gone down to 500 at this trial. Did everybody get that? It's gone down from thousands patients to 500.
So you said how many? 25, 30?
Maybe they watch this video. Maybe they took in our skepticism.
Patients, yes.
So that's less than 1% of the cases that you treated in the ER relative to dog bites.
Okay, that's reasonable, and that's average, actually.
Now, when you treated cases of dog bites in the ER, you said that you would sometimes have the reporter, the person injured or somebody with them, tell you it was a dog bite.
Yes.
Yes? And sometimes with communication difficulties, there was a reason why they couldn't share it with you.
Yes.
And then you suggested that's how you came to this pattern recognition skill, is that you would have to determine the injury with no help from the reporter.
I was always interested in dog bites, and yes, there were a few occasions when I had to use those skills in order to determine what kind of an animal it was.
But she can't remember any of them. I thought that was one of the more damning things of her testimony.
Let's talk about those few.
So here he's probably me saying the same thing, calling BS on her story that people couldn't tell her, and she had to count on her pattern recognition to determine what kind of animal it was that this person was bitten by. Just like John O'Keefe, she had to do from the pictures. The fact that she didn't examine John O'Keefe herself. Yeah, right. She was dealing with deaf mutes who couldn't tell her that they got bit, or somehow there wasn't they weren't able to translate in a busy California, Los Angeles hospital. They weren't able to translate. This is what I found most unbelievable about her testimony. All of it. I hate these experts. I hate these attention-seeking experts. I don't even warm too much to some of these experts for hire on the prosecution side. Give me nervous Trooper Paul again. Self is a big negative here.
Occasions. Why don't you share with us a story where you met a patient, if you can recall, where you had no idea what the injury may have been because there was no ability to communicate, and tell us about how you determined it wasn't dog.
Well,
her expertise isn't dog bites. It isn't interesting. It's dog and hold. So it's like police dogs when they. This is her area of interest. It's bite and hold, dog and hold. What am I saying? It is so much harder to talk than you think. Than you think off the cuff. Bite, dog and hold, bite and hold, bite and hold. So when police dogs hold on, so like when a suspect runs and they have to send a police dog after them, that's her expertise, is that. Not specifically, I mean, she just made this whole thing up about pattern recognition with Alessi. They just straight from whole cloth. By the way, I'm going to be on, tomorrow morning, I will be on Court TV talking about this with Julie Grant. So on opening statements with Julie Grant, watch it live. Be on from 8 to 8:15 tomorrow morning. Hold
on. Thinking about a specific case, I can think of cases where I determined it wasn't a dog bite, and it was something else based on the pattern of the bite. And am I not answering your question?
I'm not looking for cases where you couldn't determine the dog bite. I want you to share some of this wealth of experience you have in dog bites.
Hank Brennan walks away from the mic, and I tried to lift it up his audio as much as I could, but it really gets tough. My apologies at some parts.
Share with us, if you will, one of the cases where there was no information that was a dog bite for whatever reason, and then you, based on your pattern recognition skills, determined it was a dog bite. I want you to walk through an actual case that you can recall you had with this scenario you presented.
I can't give you a specific case because, again, in the overall scheme.
Really, that wouldn't stick out in your mind? the time when you had to determine it was dog bites. She is such a BSer. That's what I'm going to say. Sorry. Sorry, Mom. Sorry, Bob. A fabulist. I mean, I don't know. She knows she's lying. She doesn't care. She just wants she's desperate for recognition and to be seen as special. The narcissism to attach yourself to a murder trial just for your own self-aggrandizement. Ditto Robert Alessi and money motivations. Can you imagine walking by the grieving O'Keefe family and helping out their killer, their son's killer, get free for your own self-interest? Disgusting. No?
Of emergency medicine and the frequency that dog bites are to other cases, it's just not a.
She can't remember one specific case that she treated where she had to suss out that it was a dog bite. Everybody hear that? This is a BS narrative, I think. This is my opinion, that Alessi gave her. This is all new. This is really not in the first testimony. And I won't torture you with her first testimony and trial, but it's quite new.
Case that I would remember that kind of the specifics of the case.
Interesting in supporting your past experience you shared with us, you decide for these past experiences and presenting yourself as an expert in pattern recognition. And it's interesting.
Right. He's saying it's interesting you don't remember. You don't say, I don't remember exactly who they were, but there was the Spanish woman who came in. She was a deaf mute, and we couldn't that wouldn't that stick out in your mind? You're the one who says you can do this. You can miraculously see dog bites and know they're dog bites without someone telling you. You can't remember one time that happened? Does everybody hear what nonsense this is?
When I'm asking you to support this general
Objection, Your Honor. Argument.
Yeah, so, counsel,
Yeah.
that's okay. In Massachusetts, typically, we don't give the reason for objections.
Alessi practices in New York City. He's saying that's argumentative, but he's saying it's interesting that you fancy yourself a pattern recognition expert and you can't remember one time where you used this great technique of pattern recognition. That's not the phrase not used by any other dog bite expert. I'm going to move through. I just want to see her actual testimony. I know they're at, oh, here we go. I just want to see her cross.
Blood follows the laws of gravity, and the blood will settle to the dependent parts of the body. In this case, the body the body of Mr. O'Keefe is horizontal, and so the blood is going to settle from the top of the chest, which would probably be up here somewhere, down towards the back, which would be the inferior portion.
It's amazing she hasn't lived in New York in so long, and she still has that heavy, heavy New York accent. It sounds like we're still on direct here. Are we still on direct? Who's asking her these questions?
Of a pattern.
Oh, yeah, I think I can't handle Leslie. Sorry, let's move forward. You have a break? Okay, here we go. Maybe this is cross.
Or more than one dog bite.
Oh, my Lord, this went on forever. With Alessi.
Like that.
Oh, Lord. Did it go on all day? Does anyone know? Here. I can't remember now.
There was litigation.
Oh, no, it didn't. Okay, here we go.
In a courtroom.
Let's try to get to the beginning of it. Sorry, guys. So this must be the end of it.
Recognize those as the articles that you were referencing before.
Yes.
Now let's start out with the Munich study. Is that exhibit PPP that you is for your conclusions?
Asked you questions before?
Yes.
And you've testified before where I've had a chance to ask you about some of your statements and opinions, haven't I?
Yes.
Before this case, had you ever testified as an expert in dog bites in any federal court in the United States?
No.
Before this case, had you ever testified in any state court in anywhere in the country as an expert in dog bites?
No.
Other than this case, have you ever testified in a courtroom as an expert about dog bites?
No.
Last year, you learned that there was litigation regarding this case, Commonwealth versus Karen Reed, correct?
Yes.
You learned a little bit of information about it, and it piqued your interest, didn't it?
Yes.
Did you know that the case was receiving a lot of attention?
No.
Did you know that it was on television?
I had no idea until I got here.
You spoke to a colleague in Los Angeles, correct?
I'm sorry, I spoke to who?
A colleague.
I spoke to a district attorney in Los Angeles.
And did you just bring up the subject, or did that person bring it up to you?
I brought it up.
When you brought that up, is it because you knew of the relationship between that district attorney and somebody on the defense team?
Yes.
You wanted to get involved in this high-profile case, didn't you?
No.
Well, you weren't called by anybody on the defense and retained as an expert in the traditional sense, were you?
That's correct.
It was after you reached out yourself and interjected yourself into this case, true?
I did so for a reason. And the reason being that I knew I was one of the only people in the United States board certified and residency trained in emergency.
She's one of the only people. Someone just pointed out there's a whole team, a medical team that just does reconstruction for people who have dog bites in New York. Or it looked like New York. It was a 646 area code. Questions for y'all. Can Karen Reed appeal on ineffective assistance of counsel? She's been warned by Adam Lally and I believe Judge Canoni twice. She was asked if she wanted to get rid of her counsel after the ARCA, after her counsel got caught lying to the court. So what the court surmises when you're lying to the court and you're doing fraudulent tactics to represent your client is that you're not a very good lawyer, that you're trying to get her off with fraud, defrauding the court. And she's been warned by Adam Lally in a filing, and she's been warned by Judge Canoni. Doesn't mean that if she gets convicted of something that she won't. As for a possible, I agree with you, it does look like they had an affair or having an affair, etc., between her and Alan Jackson. Alan Jackson, that's a violation of his. He doesn't seem to take it. He seems to think he's too big to ever get brought down by the bar or doesn't mind getting fined or whatever. I don't know. Or he was not going to get caught. Sexual relationship. I don't think she can. I don't think she can say, I was a victim. I don't think so. I think that would be hard. I mean, they play that video of her. Do I have it? Let me see. Do I have it? Let's see. Yeah, I don't know. But of her being canoodled, they're canoodling, and she doesn't look like he preyed on her, but maybe she can say so. It would be hard to say she was a victim of Alan Jackson, but she's portraying herself as a victim in this, and people are buying it, so you never know.
Medicine and also residency trained in forensic pathology, and therefore I had a unique skill or knowledge set, and I was one of the very few people that had the knowledge of dog bites, as well as those other trainings.
And because of the fact that you held this opinion about yourself, you wanted to get involved in this very high-profile case, didn't you?
I thought I could help clarify the issues as to whether or not this could be a dog bite, and maybe they could move on to something else if it wasn't.
Did you want to get involved?
No, not really.
Inevitably, you got hired by the defense, didn't you?
Yes, I reluctantly agreed.
And they paid for your time?
They are paying for the time.
Did you know that there was a relationship between the district attorney you spoke to in California and somebody on this defense table?
I know, yes.
So when you spoke to the district attorney, did you have the hope that they would reach out on your behalf to get you involved in this case?
As I said, I hoped that they could reach out to the team and I could help clarify.
She could help clarify. If it wasn't dog bites, I don't get paid. If I say they're dog bites, I get paid. There's no incentive for me to to say they aren't dog bites. There's no incentive for me to say they're dog bites. Excuse me. Chuck says, I don't think they'll reach an agreement today. Let's ask the magic 8-ball, shall we? Will Karen Reed get convicted today? I'm just being very positive. Let's be very positive. Outlook good. See, magic 8-ball knows. Wait, did you see that? Did you see this? Let me see. Outlook good. Outlook was good. Okay. All right. All right. Let me go back to
clarify issues so that they can move on. If it wasn't, if these weren't dog bites, then no sense spending a whole bunch of time on it.
After you testified in this case last year, you then began to advertise yourself as a dog bite expert, didn't you?
I had advertised myself many years ago as a dog bite expert. I think I'm not sure, but yes, I did advertise myself as a emergency medicine and forensic pathology expert.
Did you take
with other sub interests?
Sure. Did you take a photograph of you testifying at trial and put it on a website to promote your accomplishments?
It's a listing service for physicians. And yes, there is a photograph.
So you took a photograph from your participation in this event?
Yes, that's there.
And you used that photograph in your participation at this event to try to procure future work, didn't you?
I wouldn't say that was the reason, no.
When you listed a number of things that you have experience in after this case, you then added that you were an expert in dog bites, didn't you?
I believe I am an expert in dog bites, yes.
But after this case and after you took the photograph from this case and after you created this advertising, you then added the fact that you were an expert in dog bites, didn't you?
It was all at the same time. And it was submitted at the same time.
Right. After this case, after you participated or volunteered to involve yourself in this case, you then used it as a marketing opportunity, didn't you?
Well, I had retired from my full-time job, and I had time, and I wanted to get more involved in some forensic legal cases, and not specifically dog bite cases. I have much more experience with other cases.
Undoubtedly, I respect that, but simply after you testified in this case, you did use your participation as a way to try to garner future interest in cases and income, didn't you?
I did, but I did not mention this case.
Have you testified in any other court since this case as a dog bite expert?
No.
You had written a few articles that were peer reviewed on dog bites back in, is it the 1990s?
Yes.
And they involved law enforcement canines?
Yes.
And you describe in those articles how a law enforcement canine grabs and holds. Is that the technique they call it?
Yes.
Where they lock their jaw and then they pull and hold on to the subject that they're attacking or holding?
Yes, that's what they were trained to do back then.
And you would agree that there's a difference between generally the way a domestic dog bites and a law enforcement dog bites?
Generally, yes.
Since those two articles in 1990, have you authored anything else regarding dog bites?
No.
You had mentioned that you had gone to seminars regarding identification. Now, I had a chance to ask you a number of months ago about some details about training and education you have on pattern recognition analysis as it specifically relates to dog bites. Remember, I asked you those questions a number of months ago?
I believe you did.
And I'd asked you if you could give us any specific listed trainings that you had regarding pattern recognition analysis of dog bites. And at that time, you did not have any names of any classes or seminars or certificates that you have. You mentioned again today that you have attended seminars regarding dog identification analysis. Do you now know some of those trainings and seminars? And are any of those listed on your CV?
The trainings that I went to on bite marks in general, they were bite marks in general, and included things like how to determine what was a human bite, how to differentiate a human bite from a dog bite. But no, I did not specifically attend seminars limited to dog bites only. However, actually, there was one this past February that I did attend at the American Academy of Forensic Science.
Over your many, many decades, you did not attend any seminars on pattern recognition analysis of dog bites, did you?
Of specifically dog bites? No.
I only want to talk about dog bites. I know you're well trained and educated. I respect that, but I want to talk about dog bites. You didn't attain any certificates in pattern recognition analysis of dog bites, did you?
I don't think there are any that exist, any training programs like that.
In fact, forensically, have you ever been presented with a wound and been asked to determine whether or not the source of it was a dog bite, other than right here in this very case? Have you ever been asked to do that in your entire history?
In my clinical career, perhaps once or twice, but not, not that I can give you a specific name.
Well, the couple times, tell us what stands out. When were you asked ever over your entire career to do a forensic evaluation of a wound and identify whether it was a dog bite? When did that happen?
A forensic evaluation? No, never.
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 Okay.
It just doesn't come up.
Okay.
A forensic. Oh, but she said that she had patience. I want to hear about the patience. That this is some lines Alessi wrote for her. She had patience that couldn't communicate with her that they got bit by a dog.
And so this is the first shot, the first crack you've had at looking at a photograph and trying to make a determination based just on a photograph whether or not the wound is generated from a particular mechanism, and in this case, your opinion, a dog bite.
No, actually, I disagree. I've been taking photographs of dog bites since the 1990s.
And when you took the photographs, you knew they were dog bites.
I did know that there were dog bites.
Have you-
Yes, I have a collection.
I'm sorry. I didn't mean to interrupt you. I'm sorry.
That was it.
Okay.
She keeps a collection of dog bites? What's wrong with this woman? I do not believe this. Does anybody believe that she does this? Let's see. Bring in your dog bite folder. Is it on your computer, or how do you keep it? In a scrapbook? Psycho.
So not when you knew it was a dog bite and you took a photo. I know you have an interest. I'm asking, other than this case, there was never, ever a time in your career where you were presented with a photo and asked to give an opinion whether the mechanism of injury was a dog bite, other than this case.
That's correct.
So this is not a pattern recognition analysis engagement that you have any experience in before this effort.
I've recognized that pattern many times.
I appreciate your opinion, but I want to ask my question. You do not have experience over your long, accomplished career in the effort of pattern recognition analysis of dog bite wounds. Isn't that fair to say?
Okay.
You mentioned before, and you just mentioned again, so I want to ask you some more questions. You believe that you are uniquely qualified to look at a photograph and give an opinion about the source of the injury.
I'm not uniquely qualified. That's done all the time in forensic pathology. Many forensic pathologists do that.
Did you just say you're one of the very few physicians in the United States who has both the forensic and the clinical experience to look at a photograph and make a determination, the mechanism of injury?
No, I said, if I said that, then that was incorrect. I meant dog bites. But your question just now was not specific to dog bites.
Right.
Postmortem photographs are used all the time in forensic pathology for second opinions.
You're right. My apologies. Did you say today and before, have you said that you believe you're one of only few physicians in the United States who could authoritatively distinguish between causes of wounds when it relates to dog bites?
I did say that, and that's because of my unique training. I don't know of another doctor in the whole United States that did 2 residencies, one in emergency medicine and one in forensic pathology, and has a lifelong interest in dog bites.
So, Dr. Russell, from your perspective, as far as you know, you were the only person in the entire United States of America who was qualified to look at a photograph and make a determination whether the wound was derived from a dog bite.
No, I am one of I'm the only physician that I know of that can do that. There may be, a few others out there. There may be, but I don't know of any other physicians that can do that.
Do you recognize anybody other than yourself who has this very particular expertise to be able to do this kind of work?
I'm not aware of anyone.
You were a medical examiner, a forensic pathologist.
Yes.
And you know there's about, or would you agree there's probably about 900 to 1,000 medical examiners around the country at the same time over a period of time?
I believe that there might be, there's probably, I think there's around 500 or 600 practicing forensic pathologists.
And do you think because they are forensic pathologists, those 500 or 600 people have the unique qualifications as you do to be able to give an opinion about the genesis of a wound?
Wounds in general, perhaps. Dog bite wounds, I doubt that very many of them have a specific interest in dog bite wounds.
And so you think that of all those forensic pathologists, medical examiners, you think that qualification and experience itself is not enough to qualify somebody to give an opinion on a photograph about the genesis of a wound related to dog bites?
Well, if a forensic pathologist has autopsied 1 or 2 cases of dog bite wounds versus my experience with over 500 to 1,000 cases of dog bite wounds, I'm not so sure that that person would be a very good expert in that kind of a case.
Have you ever heard of a doctor named Dr. La Posada?
I've heard of Dr. La Posada.
Have you ever read any reports by Dr. La Posada?
No.
Has anybody ever shared with you any information or opinions of Dr. La Posada?
I believe she has a very good reputation.
Have you ever? Well, how do you believe that? Who told you
Because
that?
I've heard of her name at the national organizations. I believe she's given presentations nationally. I've seen her name, over a dozen years or so.
Do you know whether or not she has any participation in this case?
I believe she does.
Well, so when you're providing accolades that she has maybe some involvement in this case. You know that?
I would provide those same accolades if she didn't have involvement in this case.
Do you know that she has involvement in this case?
I believe she does. The attorneys have not shared everything with me in terms of who the witnesses are.
Somebody must have shared her name. Who shared her name with you?
I'm very.
Those kind of things in the negative are always, they shared everything with her. The defense attorney shared everything with her.
Familiar with her name outside this case.
Who shared her name that she may be a participant in this case?
I don't remember. I don't remember.
Well, somebody might.
I think I got a file or something, but yeah.
So when you were reviewing this case, did you get materials from any of the attorneys authored by Dr. La Posada?
I don't think I read a report. I was very interested in reading a report by Dr. La Posada. I was very interested, but I didn't see one.
So when you received materials in this case, you didn't read all the materials the defense gave you?
I don't believe they gave me the report.
What report?
Any report that Dr. La Posada might have written.
Do you know whether or not you've received the report or not?
I received something that had her name on it. I don't remember what it was, but I was looking for a medical examiner's or a report, an actual report, and I did not see one.
Dr. Russell, you are meticulous when you look and examine things.
Right.
So you would know what you've received and what you've read and what you haven't. So the fact that you're telling us that you saw something with her name on it, can you give us a little more information and share with us what it is you actually received about this Dr. La Posada? What did you get from the defense?
I saw something. I think it was the name of a file folder, but I looked for a report and there was no report in it.
Did you ever ask for one?
I didn't ask because I didn't ask. I really wanted to read it, but I didn't. It wasn't given to me, so I didn't ask.
Were you ever told what other people's opinions might be regarding those photographs?
I'm aware that there was a Dr. Sheridan involved in a previous proceeding, and he believed that those were consistent with dog bites.
Did you ever receive any reports from the defense about what other person's opinions would be in this trial about dog bites?
Oh, yes, I received a report authored by a non-physician. Yes.
So when you say non-physician, you're trying to make the point because you think that person might be your opponent in this case?
I don't have any opponents.
Okay, so why did you qualify him as a non-physician?
Because I believe that in order to really understand wounds on a human being, one needs to have treated wounds, seen lots of wounds, and I think that the person that is best qualified for that is a physician.
So a medical examiner wouldn't cut it, in your opinion?
Medical examiner is a physician.
So you think a medical examiner has enough experience to come in and give an opinion on dog bites?
Some, but in their case, I would hope that they have had actual clinical experience with autopsying some cases where there were dog bite wounds, because I don't think they worked in the emergency room or any other clinical setting where they treated people. So I'd want to see if they had experience with dog bites.
Doctor as a disqualification. How about a dog trainer? Would a dog trainer who's not a doctor have the experience in your mind to come in and give an opinion about photographs and the genesis of the wounds?
Objection, Your Honor.
I'm going to allow it.
How about a non-doctor, as you said, you made a distinction.
Uh-huh.
They're simply a dog trainer, maybe even an uncertified dog trainer. Would that person have the qualifications in your mind to be able to look at photographs and determine whether or not the cause of the injury is a dog bite?
There may be a certain small subset of people who have, very much experience with dog bites that could qualify as suggesting that these are consistent with dog bites, but I don't think that they could definitively. I think that someone could, who dealt with many dog bites in the past on humans, could possibly say that they were consistent with.
Even if they didn't have the clinical experience?
Well, I prefer that to hear that information from a physician, but I wouldn't rule out that only doctors, only a physician, MD, could say that something was a dog bite.
It seems like the standard is now kind of changing a little bit. Because when I asked
Objection, Your Honor.
you mentioned the other person, you disqualified the person because they weren't a doctor. It seems now in some instances, you're willing to accept a non-doctor into your very select group of experts.
If someone, well, I can explain. If someone had looked at perhaps hundreds and hundreds of wounds inflicted by a dog that they know was inflicted by a dog, and they saw the resulting photographs on a person, I think that particular person may be able to make some comment as to whether or not some wounds are consistent. However, if in terms of a medical examiner, if they've autopsied one case or two cases of dog bites and they're trying to testify based on some pictures, I would be a little concerned about that.
Does qualification for this type of business, in your mind, depend on who hires you?
Absolutely not.
Suffice to say, you've never taken a class in the forensic analysis of dog bites.
I don't think any class exists.
But I'm asking about your experience.
Well, that's correct.
You haven't, have you?
That's correct. I can't take a course that doesn't exist.
You've never engaged in any type of opinion looking at photographs and then had that opinion peer reviewed by other dog bite experts, have you?
No.
Do you have any experience in veterinarian medicine?
I'm aware of it. That's my experience.
Do you have any accomplishments like degrees?
No.
Now, you've testified a number of times in this case, haven't you?
Yes.
And when you testify, you know there's a court reporter and there are transcripts, correct?
Yes.
You originally testified when you first came out and volunteered to testify last year, and there was a hearing before trial, wasn't there?
Excuse me? Say again, please.
When you volunteered to come out last year, there was a hearing before you testified at trial, wasn't there?
Yes.
Do you remember that was on June 18, 2022?
Sounds right.
And then you testified at trial on June 21st, 2022.
Yes.
I didn't have the privilege of meeting you on either of those events, did I?
No.
But since then, we have met.
Yes.
And we had a chance to speak at a subsequent hearing on December 12, 2024.
Yes.
And then after that, we again had an opportunity to discuss this on January 7, 2025.
Yes.
When you reviewed the case, when you first reviewed it before you testified last year, you had very limited information, didn't you?
Yes.
You had just an autopsy report, photographs from the coroner, photographs from the hospital, an emergency room report, Yes?
Yes, I had more than that.
The medical examiner file had a toxicology report?
Yes, and there was more.
Okay.
I believe there was a dog bite, a town of Canton report.
Okay, so when you had an opportunity to look at the medical examiner's report, you yourself had been a medical examiner, correct?
Yes.
And there's a unique advantage of actually conducting an autopsy as opposed to just looking at photographs, isn't there?
Yes, there is.
And if you are actually conducting the autopsy, you firsthand can make observations about injuries, make measurements, and see things that don't always appear in photographs.
That's correct.
And when you would do medical exams, you had a distinct advantage over people who would later see your work, a written report, or photographs, because you were there actually conducting the investigation.
Yes.
And it's for that reason that when you testified before, you have acknowledged that you relied on Dr. Scotti-Bello's report for information.
Yes.
Because you didn't have the benefit of doing measurements or looking at depths or anything else firsthand.
Yes. Correct.
And when you looked at that photograph that you discussed with the jury, you also had a chance to see Dr. Scotti-Bello's report regarding the abrasions on Mr. O'Keefe's arm.
Yes.
She described those abrasions as superficial, didn't she?
Yes.
She actually gave measurements, 3 centimeter superficial abrasion on the right medial upper arm. Right?
Yes.
You not only read that, you deferred to her ability to have a firsthand observation, and you accepted that as true, didn't you?
Yes, but there's no interpretation of that abrasion.
Multiple abrasions from 2 to 3 millimeters and up to 7 centimeters on the posterior right arm and forearm.
Yes.
Did you read that from
I
Dr.
did.
Scotti-Bello?
Yes.
Did you accept her finding and observation?
Yes.
And you would agree she was in a far superior position than you when she made these observations and notes, correct?
They are not inconsistent with what I said.
That's not what I asked, though.
Okay.
Sorry, I didn't mean to be sharp.
Okay.
I apologize. Did you rely on her ability and firsthand observation of those wounds?
Yes.
And did you appreciate or accept the fact she had a superior opportunity to evaluate those wounds firsthand that you did not have the benefit of?
She made no interpretation of those ones.
Did you know that Dr. Scotti-Bello had described them as superficial?
They are.
Did you know that she said there was no depth and no puncture?
Not inconsistent with what I said.
I understand, doctor, but I'm asking you, do you
I know.
know that her position is that there was no puncture and no depth to those wounds?
Objection, Your Honor. Can we have the witness see the report that he keeps referring to?
Can you answer that question without seeing it, or do you need to see it?
Well, I remember it, but there's no inconsistency here. I agree with that.
Would you accept that Dr. Scotti-Bello's opinion is that there was no depth and no puncture to those wounds?
May I see the report?
It might not be in the report. I'm asking about any testimony, anything that she's ever said. Would you agree or accept her position that there is no puncture or depth to those wounds?
Objection, Your Honor. Like all the questions that were about an autopsy. Yeah. Sorry about that.
Okay.
Oh, this feels like waiting for Godot, doesn't it? It just feels like we're waiting. There is nothing. What a cross examine. We're just waiting for nothing, you know? Like maybe we're going to another hung jury again. I know it's only been a little bit. I know it's only been a little bit. I should be saying this after like 3 days. I'm not feeling patient. I need some patience. Anyone else a patient person? I'm usually pretty patient. I'm not feeling patient. I was reading on X. This jury's taking too long to acquit her. So, back to the great cross-examination of Marie Russell. Here we go. The scrapbook dog bite scrapbook expert.
Any punctures?
But you, in the past, have testified very, very differently than that, haven't you?
No.
Now, we've spoken many times. I'm going to go through many of those examples later, but we'll do that a little bit later, Dr. Russell. Over the course of your many testimonies under oath, would it be fair to say that you have changed your opinions?
Did you say you want to hear Marie Russell's song? Okay. No problem. I aim to please.
Bored and retired, threw myself into a high-profile trial, thirsty for attention and admiration. I'm the best expert in the entire nation. Get paid to lie by the hour, making stuff up is my superpower. I see dog bites. I see dog bites. Just pay me and I'll tell you they are dog bites. Limp to the stand, decked out in polyester. Lay my lies on the court and let them fester. Oh, puncture wounds in the shirt. Testified to a great deal, I'm certain. Hell, they'll say anything. It's the prosecution that's got the burden. I'm the best expert that's ever been. Who else can testify to a dog bite by a canine without a chin? Don't need evidence to state my claims. There's a lot of hounds in the world. One's got to be blamed. I'll do anything to get rich and get off killers. Pay me extra, I'll blame gorillas. Expert that's ever been. Who else can testify to a dog bite by a canine without a chin? Don't need evidence to state my claims. There's a lot of hounds in the world. One's got to be blamed. I'll do anything to get rich and get off killers. Pay me extra, I'll blame gorillas.
Hold on one second. I'm just going to switch. I don't know how I pulled out. Jury has been deliberating for 5 hours. Oh, Lord. So all right, let's get back to Marie Russell.
About the superficial abrasions to John O'Keefe's arm many times.
I don't believe that's fair to say.
In the past, when you were describing Mr. O'Keefe's superficial abrasions on his arm, did you give varying and different opinions about the cause of each individual wound, area of wound?
I don't believe so.
When you first gave opinions, that was before the last proceeding. You came in and you were questioned before you testified in that initial proceeding, right? I'm trying to be as specific as I can. You testified last year?
Yes,
And
in
please.
There was a hearing and then there was a proceeding.
I hear the second-degree murder charge. If you get life, it's 30 years in Massachusetts. So very much like what they're trying to do all over the country. Make a life sentence, like make sure that nobody does more than 20 years, like get more European type sentences here in America. So I heard she would do maybe about 15, maybe about half of that. She got the second-degree murder charge. I mean, go back to the beginning of this and listen to Matt Tepanic, or go to Matt Tepanic's channel. He explains the different charges in great detail, and he's a lawyer. I don't want to, but the other one's manslaughter, and or she could get like a simple OUI under the driving under the influence offense, and one of the others, and that could be quite a big sentence, a hefty sentence of maybe 5 to 10 years.
Okay. That prior hearing, can we call the first event the prior hearing and the next one the prior proceeding?
I'm confused.
I don't want to confuse you. I'm just trying to follow the rules. You testified twice last year, didn't you?
3 times.
3 times. Okay. The first time you testified was just before the judge?
Yes.
Okay. When you first testified before the judge, do you remember that you had uncertainty about how each and every one of those wounds was caused?
I don't remember that.
Do you remember when you then testified a couple of days later at the proceeding that some of your opinions changed from the first time you testified?
I don't believe that.
And then when you later met me and we've had a chance to talk over the last 2 events, December and January, would it be fair to say that your opinions regarding the individual areas of wound changed?
I don't believe so.
Okay. At some point before or during our conversations in December and January, you wrote a report, didn't you?
Yes.
When you wrote that report, you hadn't written a report before the first time you came in and testified, had you?
That's correct.
And it was between those hearings in December and in January where you wrote your first report.
Sounds correct.
You dated that report December 9, 2024. Does that ring a bell?
Yes.
When you wrote that report, you did not write that report alone, did you?
I did.
You had some help, didn't you?
Not in the content of the report.
Well, you sent the report back a number of times for review and revisions, didn't you?
In terms of organization.
And some of the language in this report is really not your language. It's the language of somebody who helped you write some of this, isn't it?
You know, if somebody helped me write it, it would have been much better written than that.
Didn't you agree that you had some assistance with the report? Haven't you testified to that before?
And no, and in terms of organization, there was some comments, though, this sentence belongs, with this paragraph or the, whatever. But in terms of content, that was my work.
Well, it was your report, correct?
It's my report.
And when you write a report, it's your words, not somebody else's. Isn't that true?
That's correct.
But nevertheless, you had somebody assisting you. True.
In terms of organization, yes.
Who's helping you with the report?
It was somebody from the law office.
Well, it was this gentleman right here, Attorney Alisi, who just asked you questions. He helped you,
No,
didn't he?
actually it wasn't.
Oh, was it from his law firm then, somebody?
She already testified that Elise helped her. I mean, what a liar. What a disgusting group of people she's got to lie for her.
I believe so, but it was
A liar. Liar, liar, liar. She already said Alessi. Come on.
in terms of organization.
Do you remember who was helping you with your report?
I don't remember her name.
Would you agree that after that report was written, many of your opinions changed?
No.
In your report, you provide your background. Yes?
Yes.
And you've been licensed to practice medicine since 1988
Yes.
as a physician?
Yes.
And you've been licensed to practice medicine as a surgeon?
It's called, in California, it's called physician and surgeon license.
Mm-hmm. Do you have a physician and surgeon's license?
I do.
Okay. Have you ever practiced as a surgeon?
Well, in the emergency department, we do surgery. We have to do some surgery sometimes. We have to open up people's chests and, and compress the heart sometimes when they have gunshot wounds to the chest. I've had to put chest tubes in. I've had to debride dog bite wounds and other wounds. So yes, there is a component of surgery.
If you do stitches, that's considered surgery, isn't it?
Maybe.
Well, medically speaking, stitches is surgery.
I don't know, maybe.
Okay. Do you have a surgeon's license?
I have a physician and surgeon's license in California.
Now, when you first looked at this case and testified, do you remember when you were looking at Mr. O'Keefe's superficial wounds, you said that you thought they appeared to be consistent with an animal attack?
I do remember that.
And when you were describing animal attack, you were a lot less specific than you were today, weren't you?
Yes.
You were less sure about your opinion when you first testified about this case than you provided to this jury today.
I was certain that it was a dog attack. However, as I mentioned before to you, in medicine, we're taught never, nothing is 100%, and therefore never say, anything's 100%. So that's why I gave that generalization. However, I have reviewed the case, but I personally was certain that that was a dog, that those were dog marks. Now, I have reviewed this case over and over and over again. Plus, I've read additional articles more than once, and which substantiate, again, my findings. So, so my degree of certainty perhaps increased.
So when you first testified in this case, back in June of 2022, are you agreeing that your testimony was less certain than today?
I believed that it was a dog attack at that time.
When you testified, you didn't say dog attack, you said animal attack at the beginning, didn't you?
Yes.
And when you were asked about the cause, you said that it could be bite or scratch wounds.
Correct.
So back in June, when you were looking at individual wounds, you, at that time anyways, were unable to differentiate between bite and scratch wounds.
They are very similar.
I understand, but today you seem pretty unequivocal. So I want to go back to the beginning and see the evolution. I'm asking a question.
All right. So the argumentative part is out. Ask the question, Mr. Buell.
I want to go back to identify the evolution of your opinions. So let's start at the beginning.
So question, please.
At the beginning, before your opinion evolved, you started with an opinion that this could have been either bite or scratch wounds, right?
Yes.
And if there was actually a methodology where you could identify superficial abrasions and make a determination whether it was from an animal or a dog, there would be something definitive, specific, where you could identify a scratch from a bite wound, wouldn't there be?
Not unless there was a piece of tooth in the wound or a piece of nail. There would otherwise not be any specificity.
You talked about patterns when you first testified back in June of last year.
Mhm.
And when you talked about the patterns, again, you had some uncertainty whether those patterns were caused by nails, claws, or could have been caused by teeth. Isn't that fair to say originally that was your position?
Yes, there is some overlap in terms of the appearances. They can appear very similar, and they can be arranged very similar in terms of parallel lines.
In fact, when you first testified, you weren't consistently even saying that it was a dog, or as you say today, dog attack. You were saying, in your opinion, that they were the result of animal bites or scratches. That was what you originally opined, isn't it?
We just went through that, yes.
And at some point, you said that it might most likely be a large dog. Do you remember that?
Objection, Your Honor. Can we approach with regard to this line of questioning?
So why don't we break for today? All right, so jurors, we're not going to finish this today.
Oh.
So it seems like it's a good place to break. I do have to give you those same cautions, please.
Okay, you can hear me go. Another time Judge Cannoni ended early. No wonder the jury was like, yeah, we want to go home. Let's see. Let's see. Okay, so here we go. Whoop.
I believe it was that date, yes.
And when you testified back in December of 2024, do you remember I asked you who it was that had assisted you with your report?
I don't remember that specifically.
Well, I'm going to show you a page from the testimony. This is from the hearing. And I asked you, line 21, page 207, did anybody help you write this report? And what did you say?
I wrote the report.
If you could finish, please.
I had some help with some minor edits, rearranging, some paragraphs or whatsoever, but putting things in the right category.
Then I said, okay. And you answered?
No, I wrote the report.
And then finally I asked, who helped you with the report? What did you tell us?
I said, Mr. Lessie.
And Mr. Leslie, is that gentleman the attorney who asked questions on direct examination?
Yes.
Okay. And so did Mr. Leslie help you with your report?
What I recall is we discussed the report, but I recall that it was someone else that actually helped me rearrange the report. That's my memory right now.
Is your memory different now than it was last December?
Well, I don't think so, but you have something in writing.
Do you think you would have testified to that if it was inaccurate?
Mr. Alessi did not help write the report.
So people are guessing that if we don't get a verdict today, that the odds for a hung verdict go up the more. And that's all good for Karen Reed. The more this drags on. So we're hoping for one by 3:30. We still got a couple more hours.
He may have helped organize and make a suggestion about what is training versus what is experience, but he did not help me write the report.
Did you have any help trying to describe methodology?
No.
You had any help talking about differential diagnosis?
No, I'm very familiar with differential diagnosis.
And so after that report was written, is there any reason why some of your opinions have changed?
I don't believe my opinions have changed.
When you testified at the hearing last year, June 21st, 2024, did you express that you couldn't say with 100% certainty what type of animal, in your opinion, caused those wounds?
100% certainty, that is absolutely correct. And I'd like to see that, but yes, I that's my recollection.
If it's your recollection, I'm happy to show you what
Yes,
you
please.
testified to. You want to
Yes,
see it again?
yes.
Okay. And by the way, between last night and today, did you get any advice from anybody suggesting you should ask for a transcript when I ask you a question? Did that advice come your way?
That's my general advice from previous times.
Well, did you have any advice last night about that?
Yes.
Who told you last night that you should always ask for a transcript when I'm asking you questions?
Well, I think it was just Mr. Alessi.
So did you and Mr. Alessi, you know there's a sequestration order, don't you?
Yes.
It's a sequestration order that you're not supposed to discuss the case at all with anybody?
Well, we
during the-
didn't discuss specifics.
Do you know that the sequestration order mandates that you not discuss anything about the case from when you start your testimony until you end your testimony? You know that, right?
I understand that there is a sequestration order.
Do you understand the sequestration order mandates that you're not supposed to speak to people, including the attorneys, about this case overnight? Did you understand that?
There were no specifics discussed.
Or did you understand that you weren't supposed to, is what I'm asking? Did you know that's a violation of the sequestration
No, I did
order
not.
to speak to the attorneys overnight?
I did not know that that particular conversation would be a violation.
So did you meet with Attorney Alessi last night?
No.
How was it that you had a conversation with him?
Actually, it might have been in the vehicle.
You drove together?
Yes.
So did you commute to and from court together with Attorney Alessi?
There's a driver.
Okay, who else is in the car when you left court yesterday?
The driver. No, I wasn't with him yesterday. No, not in the car yesterday. No.
Well, you just said that you spoke to Attorney Alessi yesterday. And I'm trying to figure out, when was it that you were having conversations with Mr. Alessi relative to this sequestration order that you're under?
This morning, riding to court.
Okay, so you and Attorney Alessi drove to court?
With the limo driver, yes.
Well, who was in the limo with you and Attorney Alessi on the way to court today?
That was just us.
Just you two?
Yeah.
What else did you both talk about other than that you should ask for a transcript every time I ask you a question?
That's what we talked about specific to this case.
Was it a long conversation?
No, not at all.
The entire ride here, there must be more you spoke about other than just the sequestration order.
We did. We spoke about Boston, how I love Boston area. We spoke about New York. We spoke about other things. And in fact, I have to say that even on the ride back to the hotel yesterday with others in the car, nobody spoke about the case.
But I'm talking about this morning when you did speak about the case. What else? Not about the Red Sox or the weather. What else did you talk to Attorney Alessi about this morning other than you should ask for a transcript every time I ask you a question?
We talked about what I did last night.
About this case?
No,
I'm sorry, but I'm asking about this case.
That was it.
I want to know what all the discussions were between you and this attorney today or last night about this case.
Just that I should ask for a transcript.
Well, there must have been some concept. There must have been some context. He didn't just turn to you talking about the weather and say, hey, you should ask for a transcript. You must have been talking about something.
He also generally, not today, but generally says, be honest. Always be honest.
Fantastic. But this morning about your testimony, what did he tell you? Did he tell you this morning you should be honest?
Not this morning.
Okay. Does anybody need to remind you to be honest when you testify?
No.
What else did he talk? How did it come up? Hey, by the way, ask transcripts.
I don't even know how it came up. I didn't put much significance to it.
Well, it was just moments ago it happened because you just got to court. You can't remember the context of the sage advice of Attorney Alessi?
No.
You have any memory issues?
Oh, no.
May I approach?
Yes.
Transcript. Since you've asked for the transcript, I have it for you. Dr. Russell, this is June 21st, 2024. I had asked you whether you expressed that you couldn't say with 100% certainty. You agreed with my answer, so there's no need to try to refresh your memory, but I'm going to show it to you because you asked. Take a look at line 16. Is that now consistent with the questions I asked you and the answer that you gave, that you were less than, you couldn't be 100% certain?
That looks consistent.
You want more time with the transcript?
No.
Has anybody else talked to you about your testimony today overnight, Dr. Russell?
No.
When you testified last year, same transcript that we just looked at, do you remember when you gave your opinion to a reasonable degree of medical certainty, you said that you thought the wounds were from an animal, possibly a large dog?
On that same date?
Yes.
May I see the transcript?
Of course. Pursuant to Attorney Alessi's advice, let me approach.
Objection, Your Honor.
I'm going to strike that, disregard that, Joyce.
May I approach?
Yes. What page are you on this to?
23.
Julia, she is such a liar. And then she feigns her feelings are hurt that he said, do you have a memory issue? Because it was just this morning. He's like, I know Brennan's really tough. Yeah, send cross. Ask for a transcript. That'll slow him down. That'll get him off his game. It was something not flattering to Alessi that I didn't put much. No one's asking you what your significance you attached to it. No one's asking you that. She's such a terrible liar. She goes off in just a different direction when she's lying. Gulia says justice for John O'Keefe, praying for a guilty verdict. We all are. Karen Reed, guilty of second-degree murder. Yeah. But if this goes on after 3:30, we're winding down. Yeah. Time is running out on a likely guilty. But it doesn't always go the way these lawyers think it's going to go. We could get any verdict any time of the day. We could get a full acquittal at 3:30 or 4 or whatever. We're going to 4, right? Today we're going to 4. I hope so.
June 21st, 2024, Doctor?
June 21st.
Page 23, line 14. Will you ask the question based on everything we've discussed today? Is it your opinion based on a reasonable degree of medical certainty these injuries were from an animal attack, possibly a large dog? What did you say?
I said yes.
Thank you. Have that back?
Yes, you may.
Okay, thank you. When you gave your opinion, not this year, last year, you agreed when you were assessing the wound, you used the word or adopted the word possibly, didn't you?
Explain the context of it,
Sure.
that sentence?
Sure. Go right ahead.
No, you. I'm sorry.
Okay.
Then, I'm sorry, please
When
rephrase
you-
the question.
When you were asked about your opinion last year, not this year, last year, about whether to a reasonable degree of medical certainty the injuries were from an animal attack, possibly a large dog, you agreed with that characterization. A large animal, possibly a dog, didn't you?
Yes, an animal, possibly a large dog, last year, yes.
When you were on direct examination, there were tons of questions about this word methodology. Remember all those questions you were asked?
In June?
Yesterday.
Yesterday, okay, yes.
Yes. And when you were asked about methodology, was that an attempt to try to explain that you weren't just looking at an abrasion and guessing or eyeballing it? You were trying to suggest some type of scientific or medical process to give some type of certainty to your opinion?
That is the process I used.
When you talked about methodology yesterday, you talked about your experience in methodology with knife wounds and gunshot wounds, correct?
Yes.
But there was no methodology whatsoever regarding looking at a photograph and then identifying whether that is consistent with dog bites, is there?
I disagree.
When you described methodology, you were asked by Attorney Alessi whether or not you've engaged in that methodology regarding dog bites. Did you agree that there is really no methodology regarding dog bites?
I disagree.
When you use the word methodology regarding dog bites, there isn't something specific you're looking at as if you were looking at a fingerprint. There are points of comparison. You don't do that, do you?
There are no specific points that are published by a organization, for instance, on how to determine something is a dog bite. However, I did use different methodologies, including what we talked about, the differential diagnosis, the pattern recognition. Pattern recognition, again, is so important in medicine. It's what pathologists use to diagnose tumors.
There is no standard. There is no recognized standard anywhere for methodology on how to identify a dog bite wound, is there?
There is no published standard from an organization that I am aware of.
Okay, I thought you'd enjoy. I'm nervously going. I don't know. I'm not nervous. I can't say it's nervous. It's just I'm impatient. I'm feeling impatient. I think that's a better word. Hold on one second. Let me make sure I'm sharing this. So I'm seeing what you guys are saying. Okay, good. Okay, here we go. Here's another lawyer saying Karen Reed was cooked. I thought you'd appreciate this.
Her fate is now in the hands of a jury, and I should say again, because there was that first trial that ended in a hung jury. What are you watching for this week?
I'm so excited about this one, Phil, because Karen Reed is guilty, and I think the jury is going to do justice finally because the lawyer, Hank Brennan, did an outstanding job in his closing argument. I watched the entire thing, and he focused on her own words. She did not take the stand, but she blabbed plenty to the press before the trial, and her words are coming back to haunt her. She made damaging admissions. So she's going to be hoisted by her own petard. Plus, Hank Brennan focused on the data. He called it data. I guess he's a Bostonian. Data, whatever. It's the facts. And you can't twist the data. The data is not biased. The data has no axe to grind. The data shows she hit the victim with the car and then ran away. So I think her goose is cooked.
Yeah, well, it's possible. As a Bostonian, I take personal offense to making fun of the Boston accent, even on this Father's Day. Dave Ehrenberg, always good to see you. Thanks so much.
Okay, there's Dave Ehrenberg. I mean, if you see that she's guilty, it's, if you've been bamboozled by Karen Reed's innocence fraud campaign, it's obvious. And you can't believe they haven't acquitted her. So depends what you're paying attention to. If you're paying attention to the propaganda, you're going to think she should be acquitted any minute now. And if you've paid attention to the evidence and the data, then you're going to think that she's guilty.
So there is no source, there is no recognized community, there's no certification, there is no recognized method in identifying a superficial abrasion as a dog bite. Isn't that fair to say?
As in many conditions.
Debbie says juror 6 was in Diddy's trial. Okay, I'm talking about Diddy's trial, not this trial. Diddy's trial was tossed. Why? Do you know why, Debbie? And sometimes they won't say why. Curious. Any leaks? Has it gone to jury in Diddy's trial, or are they still hearing testimony? I'd love to be down there. I'd love to be down in the courtroom in that trial. Yeah, that's why I'm sort of moving from one thing to another. Guilty, 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 AR. Put it out into the ether. I'm keeping an eye. I mean, if you want to, I don't know. I think this is more interesting than looking at a fan, no? I mean, if you want to look at the fan, here it is. I mean, this is what they were looking at. I mean, there hasn't been one question. There hasn't been a peep. We haven't heard one thing from the jury. I can't even imagine. I just know if there's... I was very happy that my jury, the woman folded. I found that very frustrating. She misunderstood a lot of the evidence, which wasn't complicated. You know, I was glad I didn't have to. We had a lawyer on my jury for the one holdout. It was 11-1 first vote. And it still took us 2 hours because people have a lot to get off their chest. People want to talk. I understand it a lot better now, the process. Innocence Fraud Watch, what does she say? The great Innocence Fraud Watch. Let's see. What is she up to? Let's see. Hold on one second. Let me. Okay. So she says, this I went over yesterday. What psychopathic murderer ever referred to Jeffrey Penders? This was interesting. So the first, she called Carrie Roberts at 12:46:16 on January 29th. Then she called Jeffrey Penders, who's a police officer from Sharon, Mass. Their call lasted 7 minutes. He went to Canton High School. Call lasted 7 minutes and 12 seconds. There is a Lieutenant Jeffrey Penders who works for Sharon Police Department. Is this the same Lieutenant Jeffrey Penders? He's a graduate from Canton High School who spent his wedding trip in Aruba, strangely. Was this the same in 2005, not 2021? Was this the same, or 2022? Was this the same Jeffrey Penders who called Karen Reed just over the New Year's 21, 22? Was this the same Jeffrey Penders who called Karen Reed just over 12 hours after she sideswiped? So he called her. And what prompted this call? and he was accused of racism. If that is the same Jeffrey Penders, that's what she's asking. She's asking David Bennick, will you ask Karen Reed's friend Ingrid Miller, also known as Ingrid Curtis, aka Bud, she's programmed into Karen Reed's phone, or was as Bud, what psychopathic murderer Karen Reed said to her on the phone from ambulance on January 29, 2022. Yeah, during closing arguments, he looked at her and you could tell that. So, no, yeah, everybody's just waiting. Everyone's just waiting, guys. There's not a lot going on.
In the medical field, there are no certifications.
So she asked, you could tell Ingrid Curtis, she was trying to look like she was outraged, but she knows. Karen Reed told her she did it. And she knows Karen Reed did it. None of her family, no one, everyone knows she's guilty. The YouTubers, the lawyers, everyone who's joined in, the big wigs, the people, they're just grifting. No one's really fooled by this campaign.
How about published standards? Is there any
That's leading it. That's my feeling.
published standards whatsoever, any, regarding claims that a superficial abrasion is a dog bite? Are there any published standards by any organization?
No, but there would have to be thousands of published standards to identify the causes of the thousands of different types of abrasions. So no, there's no published standards.
No published standards. There is nowhere you can point to where the so-called methodology that you were telling the jury yesterday is a readily accepted standard in the dog bite community. You can't point to anywhere, can you?
There are peer review articles which list recommendations on how to determine something is from some wounds are from a dog. These are peer review articles written by esteemed physicians that have analyzed dog bites and have published these and have published an approach to identifying, particularly a forensic approach to identifying dog bites.
Let me ask you the question again, Dr. Russell. Can you point to one place where there is a readily accepted standard in the dog bite community for identifying dog bites? One article, one journal, one book. Can you point to any?
Well, I'm going to mention the articles I mentioned earlier. The article with the lead author of Dr. Demunick and the article with the lead author of Dr. Pollack. And although they're not standards, they are recommendations.
I'm going to ask you the question one more time before I approach. Can you point to one place, one, where there is a readily accepted standard in the dog bite community for identifying dog bites?
No.
And so with no readily accepted standards in the dog bite community, no defined methodology, when you look at a photo like you do of John O'Keefe's arm, you're just eyeballing it based on your personal experience with dog bites, rather than relying on some type of scientific foundation that has been published and accepted in the community.
Objection, Your Honor.
I'm going to allow that.
Isn't that fair to say, Dr. Russell?
No, absolutely not. There are many, many conditions in medicine where there are no standards developed, and yet doctors make and nurse practitioners and the like make diagnoses all the time on these various medical conditions, and more importantly, they treat them because they require treatment. There are not published standards on every single of the 10,000 or more medical conditions that exist, including dog bites.
I'm not talking about a stuffy nose or a broken leg. We're talking about dog bites here. So let's focus on dog bites if you would, if you can indulge me, doctor. Regarding dog bites, since there is no standard practice, there is no accepted methodology, and since there is no accepted and approved guidelines, you are essentially simply looking at a picture or a photograph and just using your past experience with treating dog bites as the basis for your opinion. Isn't that fair to say?
I don't think so. I'm using my past experience, my strong interest in dog bites over 30 years, and the method and the articles that I read, the numerous articles I read, but the articles that have recommendations. I'm using all of that combined to come up with a methodology for determining that those are the result of a dog.
When you say coming up with a methodology, are you saying that you're creating your own methodology, that you're the person who has the standard and nobody else? Is that your position, Dr. Russell?
No, the phrasing was not good there. I use standard methodology of pattern recognition and differential diagnosis.
There is no standard in the medical community relative to differential diagnosis and pattern recognition as it relates to dog bites, not other areas of medicine, dog bites. There is no accepted methodology, is there?
That's true.
You mentioned that you have this strong interest in dog bites. Let me borrow a phrase. Do you think you had any confirmation bias when you got into this case?
I don't think so.
Well, you definitely want to be in this case. You weren't sought out, you sought the case.
That is incorrect.
And you said you had a strong interest in dogs, and that is one of the reasons you wanted to get involved in this case. Isn't that fair to say?
No, that's actually an unfair statement. I did not want to get involved. I wanted to offer my knowledge and experience to help clarify issues. I did not want to become an expert witness in this case. And I used, again, as I do on just about every medical condition that I look at and every wound that I look at, I do a differential diagnosis. What else could this be? What else could have caused these scratches and abrasions and wounds? What else before I come to my conclusion?
On your ride over here today, were you instructed that when I ask a question, rather than answer it, give a long explanation about something else?
No.
I would like to put up an exhibit of Mr. O'Keefe's arm, and I want to ask you some questions about it. You and I have had many conversations about Mr. O'Keefe's superficial scratches before, haven't we?
Yes.
And would you agree, looking at these, they are superficial abrasions? Do you agree with that characterization?
Yes.
When we last spoke, just for background, to remind ourselves, we broke these into separate parts so we could discuss them by number, just for a sense of clarity. And we discussed this as wound number 1. Do you remember that?
Grouping number 1, yes.
Number 2?
Yes.
Number 3?
Yes.
4?
Yes.
5.
Which did you call
sorry, this
4?
one.
4,
5.
5, 6, maybe.
Okay. So as we go through, I'm going to identify them by number. That wasn't done by anybody else. It was just during our discussion so we can have clarity. Is that fair?
Okay. Sustained.
Is it fair if I refer to this as 1, 2, 3, 4, 5, 6?
I think so.
Okay. When you testified on June 18th of 2024, last year, when you came in, you were asked questions before the actual hearing. You were asked questions about this particular superficial abrasion, weren't you?
I'd have to see the transcript. I believe
course.
so, but I'd have to see the transcript.
Do you remember when you were first giving opinion testimony about this specific abrasion, wound number 1? Do you remember you saying that you thought it was either teeth or nails?
I'd have to see the transcript again.
I will give you the transcript, and as I'm doing that, let me ask you, do you remember your testimony about what you actually said?
Yes, Your Honor. So, do you remember your testimony?
For each specific day, no. I remember generally, but not for each specific day.
If you
I've
have
been
an
here many
opinion,
times.
I'm going to bring your transcript up to remind you, but if you have an opinion, it shouldn't change, right? It should always be the same?
Generally, yes.
Okay. So let me ask you before we talk about what you said at the beginning. What is this from? Teeth or nails?
It could be either, but I think that's from teeth.
So when you say they could be either, if you have a methodology and you have a certain standard where you can identify something based on a standard, there wouldn't be so much uncertainty, would there? You'd be able to look at this, consider the methodology, and either come to an opinion whether it was teeth, nails, or something totally different, right?
You know, Mr. Brennan, perhaps I didn't explain earlier, but the nail of a dog tends to be cone-shaped, conical in shape, and very similar to the nails that the canine teeth of dogs. So the shape and the fact that they come to a point makes some wounds indistinguishable.
Are you saying that nails of a dog are so similar to the teeth that you can't tell the difference between them when you're looking at a wound?
I'm saying that they can cause similar looking abrasions.
Are you able, as the premier expert in the United States on dog bites, able to tell the difference between teeth and claw nails of an animal when you're looking at a wound?
Individually, well, okay, that's a very interesting question. Sometimes it's difficult because they can have similar appearing wounds. So you have to look at the overall pattern in order to make some conclusions.
But when you first started testifying in this case, you never suggested you had to look at everything in totality. You were giving opinions regarding individual wounds. Isn't that fair to say?
No.
It wasn't until I began asking you questions and you had inconsistent answers that you've now changed from, rather than identifying individual wounds, now you're saying I can't identify individual wounds, but I can tell you in totality.
I disagree with that. I believe that in the very first time I testified, I mentioned that the overall pattern was important.
When you first testified, so today, before we get to your testimony, you're saying this could be either teeth or nails, but you think it's probably teeth.
Correct.
How probable? Do you think it's certainly teeth, to a reasonable degree of medical certainty? You're not sure? What is the value of your certainty or lack of certainty about what caused this wound?
Reasonable degree of medical certainty.
What is a reasonable degree of medical certainty? That what?
That those are caused by teeth.
Teeth. Okay. When you first testified, your position was it could have been teeth or nails. That is different than saying, to a reasonable degree of medical certainty, teeth, isn't it?
No, there is a small possibility that they could be caused by nails.
When you first testified, you didn't qualify it as a small possibility, did you?
I perhaps wasn't asked.
Well, you answered. Do you remember when you were asked about it and you answered? You talked about that there was a pattern close to the shoulder with parallel marks. Do you remember?
Do I remember what?
Saying that this is a pattern close to the shoulder, right? That they're superficial. You agree with that still?
Yes.
And did you say they were consistent with teeth and nail marks?
Yes.
Okay. Nails on a dog, oftentimes or most times, are horseshoe shaped, aren't they?
They're generally conical shape.
You don't think that nails on a dog in your studies have a horseshoe shape?
I think it depends on the grooming of the dog and if the nails were cut recently.
Okay, just some updates. The lunch is from 1:30 to 2, so they're not deliberating right now. They're having lunch from 1:30 to 2:30. So we're not going to get a verdict till after 2:30 if we're getting a verdict today. Okay? So hang tight. Enjoy Marie Russell's brutal cross. Enjoy her long explanations. I love that question. Hank Brennan asked her, were you told to give long answers about something else when I ask questions? Funny.
But in general, they come to a point They're at the, at the end of the paw. They come to a point, and by the way, the paws can open and close, so the distance between the nails can vary depending on how that claw impacts the skin. So in many ways, they resemble the overall shape of canine teeth.
And so to get back to my question here, you're saying that this could have been caused by dog nails?
It's possible.
Do you know, or do you think that the teeth in a dog are different shapes and sizes?
Oh, yes. Depending on the tooth, there's different shapes and sizes. Absolutely.
When you testified the first time and you said that you thought it was teeth or nails, do you remember testifying a couple days later in front of a group of people and you again iterated that this could be teeth or claw marks? That was your testimony last year, teeth or claw marks, right?
I'm going to object to the characterization of that prior proceeding.
So just prior proceeding, folks, that's all that we need.
Did you testify at that prior proceeding last summer that this could have been teeth or claw marks?
I would need to see the transcript.
I love when she does that blowing out motion. She's a terrible witness. Anybody needs their head examined. Who's believing this woman? No? But Karen Reed just left the courtroom 4 hours ago. Just left the courthouse, probably went to get drinks. 11, I guess, 4 hours ago. They just left. I guess they'll be called back to the courthouse. So we have that delay too. If we're getting a verdict today, they have to go back to the courthouse.
And approach?
Yes.
When you first testified on June 18th, doctor, you were asked questions trying to identify what you thought that wound was. And this is your June 18th, 2024 testimony. On page 37, line 7, the questions begin, and you were asked what you thought they were. You can read any part you want, but line 7 might be a starting point.
Yes, I said that which are consistent with teeth marks. They also could be possibly consistent with nail marks.
Dr. Russell, I'm just going to ask you to keep your voice up, okay?
Okay. Mm-hmm.
That was your first testimony last year, yes?
Yes.
And then did you testify a couple days later and again repeated the same opinion, teeth or nail marks?
May I see it?
I'm asking if you remember.
Yes, I remember testifying.
Do you remember after you worked on your report and submitted your report?
Yes.
After your consultations, do you remember changing that opinion regarding number one? Do you remember changing that opinion?
No.
Do you remember changing from either teeth or possibly claw marks to being very specific, claiming that it was definitely teeth marks?
No.
Are there different types of teeth in a dog?
Yes.
Okay. The pointy teeth, the big ones, those are called canines?
Correct.
And the smaller ones are incisors?
Correct.
There are 6 incisors in a healthy dog on the top and bottom between the canines?
Correct.
Okay. Did you, when you testified subsequently to the original proceedings, did you change your opinion from teeth or claw marks to specifically teeth and even more specifically canines?
Do you have a transcript?
I do, but I'm going to ask you the question. Do you remember changing your testimony from teeth or nails to being very certain that it was canines, not just teeth, canines that caused that wound?
I became more certain, yes.
You had never said that the canines caused these wounds before you filed the report, ever, did you?
I may not have, that's true.
And so after you did your report, you shifted from teeth and nails to canines. Do you remember that?
I don't think it's a shift.
No one would ever refer to a dog's nails as canines, would they?
No, I don't think so.
That would be inaccurate, wouldn't it?
Yes.
That would be a mistaken use of the word.
I believe so.
When you testified December 2024, you didn't say nails could have caused this wound. You didn't say generally teeth. You said canines.
I believe that, and that's true. I believe that canine teeth caused that wound.
Did you have any new information about photographs that would help you change your opinion from teeth and nails to canines?
Well, I had been challenged. I had testified several times. I reviewed the case several times and challenged. And each time I reviewed the case, I became more certain that these were from canine teeth.
So,
and actually, there's other marks there, but these are from teeth.
You say more certain. You had never said canines before, ever, until that recent hearing. Isn't that true?
I said teeth.
Canines.
It doesn't matter. I said teeth. Canines are some of the teeth.
Upper or lower canines?
Upper.
And if it's upper canines, you testified previously that the point of entry would be here at the bottom and the dog would pull this way. That's what you testified to. Yes?
No, I believe you misunderstood then. The point of entry is up there. The first initial point of contact is there. And the dog pulled this way, or Mr. O'Keefe pulled his arm the opposite way.
Dr. Russell, you don't recall that you said that the bigger circles are the point of entry, the dog pulled this way, and then I asked you, how could a dog pull this way when the arc is like this? The dog's mouth would have to be in backwards. Remember that conversation we had?
Objection, Your Honor.
I'm going to allow.
Do you remember that conversation? You said that the point of entry would be the bigger circle pulled this way, and then I questioned, how could a dog's arc look like this if the teeth went that way?
No, I don't recall that at all.
Remember that conversation
No.
we had? Okay. And so inevitably, when you look at this part of the wound alone, have you expressed an opinion that you're unable on its own to be able to tell whether this was caused by a dog?
Which part of the wound?
Taking any of these alone, let's start with number one. Haven't you expressed an opinion that taking this alone, you would not be able to say that was from a dog bite?
That is correct. In and of themselves, they're not that specific or characteristic. However, as a group, they are highly characteristic of a dog
So if
injury.
Mr. O'Keefe's arm only had this wound and nothing else, by virtue of what you're telling us, you would not be able to offer an opinion that this was consistent with a dog bite.
That very first wound up
Yes.
there, closest, I agree. Yeah.
In fact, you've testified about this very issue before. If this was the only wound on Mr. O'Keefe, number two, you would not be able to say that the injury is consistent with a dog bite.
Correct.
I'm going to go through all of these just so we're clear. Same thing with number 3. You've provided opinions on this before. If you look at this wound alone, in isolation, you would not be able to say that it came from a dog bite.
Correct.
4, pardon me. Yeah, 4, same. Looking at the wound alone, you would not be able to say it came from a dog bite.
Correct.
Same for 5 and same for 6.
Correct.
Now, when you testified before your recent testimony, you never had that qualification. When you came into court, you were saying that when you looked at these wounds individually, you were saying that you could identify it as a dog bite.
I disagree with that characterization.
Number 2, what caused this wound, Dr. Russell?
Number 2, I believe that was dog bite or scratch, but mostly I believe dog bite. And because there's a punctate, little tiny pinpoint almost lesion there and there, which could represent bottom teeth.
Okay, so you're using words like could, and we're talking about a reasonable degree of medical certainty. So when you look at this wound here, you said that you are sure or not sure what caused this wound.
I'm saying that individually, that wound, that's correct. I'm not sure individually what that wound was caused by. However, again, as I mentioned earlier, the overall pattern of wounds is what I am convinced of.
I want to go through each of these wounds separately so we understand what you actually recognize with your methodology and what you don't. So looking at wound number 2, based on whatever methodology you've been using, are there any signs, indicators, objective criteria you can look at and tell us this is or is not a dog bite based on this methodology you have?
There are some characteristics that are suggestive of a dog bite or dog claw, including the fact that there are parallel lesions, and many of these, overall, by the way, parallel lesions are in the same general direction. So there are parallel lesions, and here they're associated with some punctate or point-like other abrasions right here. So they're consistent with being inflicted by a dog.
I appreciate you using some medical terms to describe this, but my question is more pointed. Is there anything about your methodology, something that stands out about these wounds, that you can say to a reasonable degree of medical certainty that these are consistent with a dog either biting or scratching?
These wounds all by themselves, not to a medical degree of certainty, no.
You said on this first wound, you thought this was from the canines. Those are the big upper teeth is what you're claiming, right?
Yes.
And you're saying today anyways, starts here at the bottom and goes up. Is that your position today?
That's not what I said. I said the
Okay.
exact opposite.
So it starts here and comes down.
Correct.
Okay. And these 2 scratches, they're linear, just like these are linear, aren't they?
Yes.
But you have a problem with these because if these are the canines, you see the spacing there?
Uh-huh.
This is nowhere close, is it?
I didn't say that these were caused by canines. And spacing also, there's reasons why the spacing could be different.
Well, we can talk about that in a second. Are you suggesting that these these 2 linear abrasions, just like 1 and 2, are you suggesting the canines caused these?
I don't know what caused those, which teeth caused those, or which nails caused those.
When you testified last year on June 18th, you said that this was either teeth or claws. Can you give us any development of your opinions, whether or not you think that is teeth or claws?
Excuse me? No, well, I couldn't hear because of the fan.
When you testified on June 18th, you said wound number 2, the top 2 linear abrasions, you believe were either teeth or claws. You've shared with us now you have improved your study and have new opinions. Do you have a clearer opinion whether this is teeth or claws?
Objection, Your Honor.
Sustained, ask it differently.
Do you have an opinion whether this is teeth or claws or not something totally different than a dog?
I believe they are teeth or claws caused.
When you testified at trial and in that hearing that they were teeth or claws, you changed that opinion as well at the most recent hearings, didn't you?
No, I'm going to object to the worded use that's been done before.
Mr. Brennan, worded differently.
Sorry?
Worded differently.
Okay. Did you testify at a more recent hearing that teeth made these, not teeth or claws, but teeth?
I may have, and I would like to see that.
May I approach?
Could you just hold 1 second? Could you please turn the fan off? Jurors, is it okay if we turn the fan off so we can hear better? Thank you very much, Officer.
May I approach?
Yes.
From your December hearing, page 100, line 5, when you were asked about that second wound in December, and I asked whether you changed your opinion from teeth or claws to just teeth. Weren't you asked specifically about that on page 100, line 5?
Yes. But may I read it?
Sure, I'll read it with you.
Okay. I said, I'm not sure on the second set. So this is the set just above the elbow.
Mhm. I'm not sure exactly what teeth made these. They could, one of them could, one set of these could be canine, one part of this, and then adjacent incisor tooth. But I'm not sure on the second set, so this is the set just above the elbow.
Yeah, I think the first part of that paragraph is talking about the first set up there close to the shoulder, and then the sentence, but I'm not sure on the second set, so this is the set that's just above the elbow. I said I'm not sure.
And then, sorry.
Oh, go ahead.
Are you done?
Oh. Yeah, actually, I did make another comment. What is it? So, however, what is interesting and certain is that there's an upper set and a lower set. So, this mark was an upper tooth. This is a lower tooth. What I was referring to is this mark here and that mark, and then this mark here and this mark here. So it appears that this is from upper and these are from lower. That's what I was referring to.
And so when you first described this wound as teeth or claws, at the most recent hearing, you had a certain opinion that this was teeth, didn't you?
Yes, I was leaning towards teeth. Correct.
Well, it didn't seem like you were leaning. You said these were from the upper teeth.
Yes.
You said it matter of factly, not with any qualification. Your claim at the last hearing is this was from teeth.
That's what I believed.
And today you're saying you don't know if these were teeth or claws.
Not with 100% certainty.
You didn't qualify 100% certainty. You were asked your opinion, Dr. Russell. You were asked, what do you think? And you didn't say without 100% certainty. Your claim, the first time you testified, teeth or claws. Recently, you said teeth, and now you're saying you're not sure.
No, I'm saying I believe that those marks are from teeth, but I'm not 100% certain.
Suffice to say, looking at wound 2 alone, you cannot say this was caused by a dog.
In and of itself, no.
What tooth do you think caused this wound?
I don't know.
Do you think this in any way could be caused by dog teeth if you're claiming that this is dog teeth?
Excuse me?
Do you think there's any way these two could be caused by dog teeth? If you're saying that these two were caused by dog teeth.
Yes, could be, but I don't know which teeth. And I don't know the extent of the bite, how much impact there was, and how much pressure, how much contact there was between the teeth and the skin.
The canines are the longer teeth in a dog's mouth, aren't they?
They are.
And when a dog bites, it's very common for the canines to puncture, isn't it?
It's common if there's enough force, and it's common that you might have two canines if the strike is perpendicular to the skin. But if you have a tangential strike, a partial strike where only part of the teeth impact, you'll get different configurations.
Look at the spacing, Dr. Russell.
Did you say strike or stripe?
Strike with a K.
Look at the spacing, Dr. Russell.
Mm-hmm.
A dog causing these wounds, the canines are not going to have such a dramatic distance between them because dog canines don't move, do they?
They don't, and I'm not claiming that these two parallel stripes in this case, or abrasions here, I'm not claiming that those two were caused by canines.
You think a dog is going to leave a wound with linear abrasions using its incisors as opposed to its canines? Is that your opinion?
It's possible if that's the only part of the mouth or the jaw that actually touched the skin, if it didn't go back as far as the canines.
Did you ever look at the underside of Mr. O'Keefe's arm?
I did.
Posterior side?
Excuse me. Pictures, yes.
Yeah. And when you looked at the photographs of the posterior side of Mr. O'Keefe's arm, did you find anything conspicuously absent from underneath his arm?
Well, first of all, let me clarify. Part of this is the posterior aspect of the arm. So are you asking me, did I look at the underside of the arm, the fleshy part
That's
of the
exactly
arm?
what I'm asking. It's a question I've asked before. When you look at the other side of Mr. O'Keefe's arm, did you notice anything conspicuously absent?
Yes, there's an absence of wounds.
When a dog bites, I don't care if it's a law enforcement dog or a domestic dog, you know it's like a lever, a dog's mouth, isn't it?
It can be if both jaws strike the skin. However, there are many times when only the upper jaw strikes the skin.
The lower jaw is a lever, locks, and that's part of the clamping and pulling process of a dog, whether it's a law enforcement dog or a domestic dog. You know that, don't you?
I know that they are attached.
Your claim is that there's many, many different dog bites on Mr. O'Keefe's arm. Are you suggesting, to a reasonable degree of medical certainty, that these are a number of different dog strikes and coincidentally every single one of them lacks any wound to the underside of his arm?
Yes.
Your claim is that a dog penetrated the sweater on the top, but the lower jaw did not leave any wounds?
I'm claiming that that's not what I'm claiming. No. As I mentioned earlier, these could be from lower jaw. Those right there.
You're saying could be.
Could be.
That's speculation. We're asking you for your medical opinions. Your medical opinions. Do you have any evidence that the dog's lower jaw, you said maybe upper, maybe, that the lower jaw, even just once in this whole event, penetrated Mr. O'Keefe's skin?
No, nothing penetrated the skin. There was no actual penetration of the skin. These are abrasions. But I believe that these small marks right here, punctate marks, may be the result of lower jaw impact.
Rather than deal in speculation and maybes, can you tell us to a reasonable degree of medical certainty whether or not this was caused by a tooth?
Objection, Your Honor.
We're going to strike the first part. Why don't you ask the other part?
Can you tell us to a reasonable degree of medical certainty whether this superficial abrasion, can you put that back up, please, was caused by a dog?
In and of itself, that part only, no.
Can you tell us anywhere on Mr. O'Keefe's arm to a reasonable degree of medical certainty where the lower jaw impacted Mr. O'Keefe to leave even a scratch?
Not with a reasonable degree of medical certainty on individual wounds.
And not just individual wounds, I'm talking specifically the lower jaw. Can you point to one wound, one abrasion on that arm where you can say to a reasonable degree of medical certainty the lower jaw caused any of those abrasions?
I believe there are several areas where there's impact from the lower jaw. However, I cannot say with reasonable degree of medical certainty that part only.
Let's look at number 3 to move along. When you first talked about these wounds, again, is it fair to say that you described that it could have either been teeth or claw?
I'd have to see it.
Okay, I'll bring it to you. You don't remember that testimony?
I remember, again, I've been here many times, so I want to be.
Well, you have the
specific.
opinion today, and I'm getting the transcript for you, Dr. Russell.
Thank you.
You have the opinion today that that those were either teeth or claws?
Yes.
What's your opinion today?
Well, I think that most likely they are from teeth marks.
Well, rather than most likely, we deal with reasonable degree of medical certainty. So a reasonable degree of medical certainty, can you give us an opinion regarding the cause of those marks?
Objection, Your Honor.
So I'll strike the comment.
Can you tell us to a reasonable degree of medical certainty whether these wounds were caused by teeth or claws?
Individually, no.
Did you ever change your mind about the source of these abrasions?
Can you be more specific?
Did you ever claim that any of these abrasions were from upper or lower teeth?
I don't recall changing my mind.
You don't recall if you've ever said that? Let's separate these bottom wounds. Do you have an opinion to a reasonable degree of medical certainty whether these were caused by teeth or claws?
I have an opinion.
To a reasonable degree of medical certainty?
No.
Do you have an opinion to a reasonable degree of medical certainty whether these were caused by either a dog teeth or dog claws?
I have an opinion.
To a reasonable degree of medical certainty?
Individually, no.
The one near the wrist, you had testified yesterday, there's lines in what you believe to be an arc, correct?
Yes, they have a general overall appearance of an arc.
If there's an arc and there's 2 linear abrasions on the outside borders, wouldn't these necessarily have to be the outside borders from canine teeth?
Not necessarily.
They're longer than the middle ones, aren't they?
The abrasions are, but doesn't mean the teeth are.
If this was an arc, like you claimed, you think different teeth other than the canines could have caused the outside scratches?
It's possible.
And you do note the distance between the top and bottom of those wounds compared to the distance in number 2 and the distance in number 1.
I see the difference, yes.
And you have to concede, Dr. Russell, that the same set of teeth, the same canines, could not reasonably have caused this wound, and this wound, given the distance between the inside and outside.
First of all, I'm not certain. I'm not certain that these are all canines, as I mentioned earlier. Secondly, you have to take into account that skin is elastic. It bends, it depresses. So you could have two prongs, for instance, of a pitchfork, for instance, just as an example, impact the skin in different places, and the measurement between the two can be slightly different depending on the elasticity of the skin and the underlying structures.
This is not a slight difference, Dr. Russell, is it?
Again,
Objection, Your Honor.
So there was a question with that, so I'm going to let that in.
Again, Dr. Russell, the distance here, it's not insignificant, is it?
Mr. Brennan, I already mentioned that I did not think that these were caused by two canine teeth.
And these, the distance between these two, have you measured them?
I approximated them, yes. And
What did you come up with?
visually, and I can see that there's a difference.
What was your measurement for this one?
I think about 4 centimeters, and this was a little bit more.
Did you note that in the report? Did you
No, I
actually
did
measure
not.
them? Did you actually take out a ruler, measure them, and document them as you studied these wounds? Did you go through that process during your methodology?
No, because this is an image, and there's no scale in this image as to how far away different points are. So my own measurement would not be accurate because there's no scale in the picture.
Why did you go through the process of measuring them if you're now saying that it's inaccurate after I asked you if you memorialized it? Why would you even do it if you're now saying it was inaccurate?
It was an approximate measurement in my mind.
In your mind?
Yeah.
Okay, but you never put it on a piece of paper, report, notes?
That's correct.
Why would you even go through the process if you're looking at it and your explanation is it's only a photo, I wouldn't be able to tell? Why would you even try to?
I think probably everybody in this room has already done the same thing.
And if anybody in this room did the same thing, it would be quite obvious, doctor, that the gaps between 1, 2, and 5 are dramatically different from each other, aren't they?
They are. However, I'm not saying the same exact teeth caused those marks.
When you testified yesterday, you used the term differential diagnosis. I want to ask you a lot of questions about differential diagnosis. Do you remember using that term?
Yes.
And that differential diagnosis was really just a way for you to try to get your opinion to the jury that these injuries were not consistent with the car accident. That's what a fancy way of doing it is, right?
No, it was a method I used.
Differential diagnosis, you're claiming that you can say this is not from a car accident or a car collision. That's what you're trying to say, aren't you?
That was the result of my differential diagnosis and my pattern recognition methodologies.
If you're going to exclude a cause of the injury, in this case, a collision, you have to know a little bit about collisions, don't you?
Yes. I don't know how to answer that.
Well, try.
Can you be more specific?
If you're going to say that these superficial abrasions could not have been caused by a car collision, you kind of have to understand a little bit about the mechanics of a car collision, don't you?
Actually, I disagree. However, I've treated thousands of victims of motor vehicle accidents and have seen the wound patterns that they come into the emergency room with. And that forms a basis for me.
Do you really think?
I'm sorry, please.
Did you finish that answer, Doctor?
No.
Did I cut you off?
I believe so.
Oh, I'm sorry. Please continue.
No, and the thousands of victims of motor vehicle accidents, I've looked at their wounds, I've treated their wounds, cleaned their wounds, touched their wounds, and that is what I use as a basis, part of my basis to determine that these were not caused or not consistent with a motor vehicle accident.
When you first gave that opinion that it wasn't consistent with the motor vehicle accident, it's fair to say you didn't have a lot of information at that time when you first came in and said that, correct?
Specific to this case?
Yes. Yes.
I didn't have a lot of information. That's correct.
Okay. And so in order to rule out a collision causing these wounds, let me ask you, are you an accident reconstruction expert?
Reconstruction? No.
Did you ever go to any academy for training to receive any type of degree or certificates in car collisions?
Actually, I did receive a certificate in hit and run accident investigation from the Massachusetts Criminal Justice Training Council when I was a police officer.
Do you agree that what training you did have was rudimentary?
It probably was, yes.
Well, not probably. You've used that word before. Wouldn't you say that any training you have had has been rudimentary?
In terms of accident and
Yes.
investigation, yes.
Have you ever testified as an expert anywhere in accident reconstruction?
No.
Do you know what ACTAR is?
ACTAR?
Yes.
No.
It's a certification group for collision specialists, accident reconstructionists. Is it fair to say that you're not ACTAR qualified?
Objection, Your Honor.
I'm going to sustain the objection.
Are you ACTAR qualified?
No, and I don't know any physicians that are.
Have you ever gone to a scene of a car collision and done an investigation and written a report and reached a conclusion about the cause of the car collision and the injuries that were related to that car collision?
No, that's outside my scope.
It's beyond your expertise.
Beyond the expertise of a physician, yes.
Right. Yet, yesterday, you offered the jury your opinion that these wounds were not consistent with a car collision. Did you offer that opinion yesterday?
Wounds are in my area of expertise. So yes, I am very comfortable talking about wounds from a variety of sources, including motor vehicle accidents.
I'm sorry, I didn't want the siren to interrupt you.
Okay. Yeah, wounds are definitely within my area of expertise.
When you considered your opinion to this jury that this was not caused by a car collision, do you know what type of vehicle is in question?
Yes.
Have you ever studied the vehicle to look at the make, model, the height of different things like the bumper, perhaps the taillight? Have you ever studied that in this case?
I'm aware of some of those factors.
Have
Yes.
you studied that before you made this opinion? Yes. Did you go and actually look at the photos, do any measurements before you came up with this opinion?
Not before I came up with the opinion, no.
Did you ever look at the damage to the rear taillight of the defendant's vehicle and see if it was in similar or the same height of Mr. O'Keefe if he was standing up? Did you ever do that?
I have looked at photographs.
And when you looked at the photos, did you see that a 6'1" man like Mr. O'Keefe, if he stood, his elbow would be the exact height of Miss Reed's broken taillight? Did you notice that?
I noticed that there was a similar, that the height would be similar. The height of the elbow and the taillight, yes.
Did you look at photographs of Miss Reed's broken taillight and see if where the break was corresponded closely or directly to the same height as Mr. O'Keefe's elbow and forearm?
I did.
And did you see that it matched up height-wise perfectly?
Close, yes.
You have really no, respectfully, comprehension about the details of the car collision in this case, do you?
I have some understanding of the allegations of a possible collision.
Do you know how slowly or fastly Miss Reed's Lexus was traveling on January 29, 2022 at about 12:32 a.m., right around the time that you think these wounds happened?
I have some knowledge of the alleged speed at the time of the alleged collision.
Do you have any knowledge about the surroundings, the outside, whether the ground was soft or frozen?
I understand that there was snow on the ground.
How much snow do you understand was on the ground when Mr. O'Keefe's body first landed on that ground?
Several inches.
Where did you get the information that there were several inches of snow on the ground when Mr. O'Keefe landed?
You asked me when?
Where did you get that information from?
A report that I read.
She knows about the alleged accident with the alleged vehicle, with the alleged murderer. Oh, the alleged. You know, that's all the, why do all the expert witnesses call it the alleged? Alleged. How's everyone doing out there? We have 339 people watching on X. Hello, X people. I know you're not commenting in the YouTube feed, but hello. Thanks for watching. You're watching the Roberto Glass True Crime Report. We are on Verdict Watch. This is, what are we into? 7 or 8 hours now. They've just gotten back from lunch at 2:30. And no news. Is no news good news? Let me know. All right, back to Marie Russell. I just wanted to check in with everybody. Check in with the Roberto Glass fam. Because they don't know. Are we headed 7 hours and 39 minutes? Yeah, hit the thumb. Let everybody know we're here. Support the stream. What? They could go on till tomorrow. Yeah, it could go on all week. I don't ever take a break, Wesley. Not with this. I haven't had a break since really the beginning of this trial. So anyway, we're on Verdict Watch. That's what's going on. I haven't heard any news that's worth sharing. All very quiet.
Have you ever seen the videos or the reports that when Mr. O'Keefe was moved from the ground, there was grass and dirt under him?
Yes, I saw a picture.
Not 2 inches of snow. The ground, the cold, hard ground. Did you see anything that said that?
Yes, I saw an area of grass in the picture.
Have you ever looked at Mr. O'Keefe's pants to see if there was any dirt or grass stains on the back of them?
I've seen pictures.
Did you realize when you were forming your opinions about the source or the genesis or the cause of these abrasions, did you look at his pants and study whether or not he landed on snow or landed on the hard ground?
I did not see any evidence of grass on the pants.
Did you ever actually look at the pants?
I don't know if I looked at the pants.
When you say you didn't see any evidence, are you saying you didn't look, or you looked and you didn't see anything?
I looked at pictures of the clothing that was available at the hospital.
Did you look at anything about the pants, photographs, the actual pants themselves? Did you look at them?
I looked at the pictures that were available at the hospital of his clothing that was on the floor.
Were part of the photographs that were available for your review and your conclusions of differential diagnosis, was part of that evidence photographs of the back of his pants?
I don't recall.
If you're going to make an opinion about something outside your expertise, that this was not consistent with a collision, wouldn't you want to see as much information as possible?
So we'll come to sidelines.
A mercy sidebar. Leslie.
I did not need.
Dr. Russell, before you gave your opinion to this jury, suggesting that Mr. O'Keefe's wounds on his arm were not caused by an impact with the motor vehicle, did you go to the scene of 34 Fairview?
Okay, here's some breaking news. Turtle Boy has gotten, and according to the New York Post, Turtle Boy got into an altercation outside the courthouse again. Oh boy.
So I'm in the middle of the broadcast. So yeah. So anyway, yeah, we're out here. She was drunk. She was drunk. How great was that? She was drunk. And then she pivoted. She was drunk. She was drunk. Oh no. Oh,
So, with John DePietro, it looks like this is what it looks like. No one's ever been drunk before. Yeah, no one's ever killed their police officer boyfriend and left him to die before in a blizzard. It's not just that she was drunk, although it's the way that she put her foot 75% down on the gas pedal, reversed into John O'Keefe, 24 miles an hour, and left him to die alone in a blizzard. Then created an innocence fraud campaign where she blamed everyone who helped her. So that's it. That's the news. That's the news. Just trying to give you a little break from Marie Russell. It doesn't look like a real altercation, though. That looks like some fake news by New York Post.
And look around in the corner of the yard.
I did not need to.
Did you?
No.
Did you look at photographs to see if you could identify the land, the dirt, whether it was flat and smooth or whether it was bumpy, whether there was rocks or debris in that area?
Yes.
And you went there and looked at it?
No. You asked me if I looked at photographs.
When you looked at photographs, did they show whether that ground had any bumps or divots or rocks?
It showed that there was a little bit of a hill in that area.
Could you tell from the photos, were they close enough so that you could see what the makeup of the ground was?
No, most of the ground was covered with snow.
Did you know that there were bushes right near the area where Mr. O'Keefe was found? Bushes with branches. Did you know that?
Not very close, no.
Did you see the bushes in the photographs near where Mr. O'Keefe laid?
Right where he laid, no.
How about next to him on the left? Did you see those bushes?
There was some other stuff there in the photograph, but the photographs I looked at were not of excellent quality.
Do you have any understanding or information you can share with us the angle of Mr. O'Keefe's body at the time of any impact with a motor vehicle?
I don't see any medical evidence that there was impact with the vehicle.
Do you know Mr. O'Keefe had other injuries other than just the superficial abrasions on his arm?
Yes, but no significant injuries below the neck.
How about on the head? Was there a significant injury?
Oh, yes.
When you considered excluding car collision as a source of those wounds, did you consider in your history that you've seen, or have you seen, let me strike that, have you seen in your history multiple victims of a car collision where they were hit by the same car?
Probably, but I can't recall a specific case.
Would you agree with me if a car ran into a group of people and caused a number of injuries, those injuries to different people could vary wildly from one to another?
Yes.
Even if the car was going at the same speed and ran into a group of people, those injuries could be totally dissimilar from one another, couldn't they?
Yes.
Some person, unfortunately, could be killed if the car was going fast enough and hit them the right way. Yes?
Yes.
Another person could have a less severe injury, maybe a broken bone.
Yes.
Another person in the same exact collision could have scratches.
Yes.
In fact, there are cases, I'm sure you've studied, where people have been hit by cars, thrown airborne, and had no wounds on them at all. Have you seen that?
Could you repeat that?
Are there instances that you have considered where a
No.
person is hit by an automobile, actually thrown, removed from the ground, thrown in the air, and gets up unscathed with no injury at all?
No significant injuries, correct.
So a car collision can cause wildly different injuries depending on many, many unpredictable factors. Isn't that fair to say?
Yes.
When a vehicle's involved, have you ever been involved in treating patients that receive injuries from broken plastic or broken glass in a car?
Yes, many times.
And when you've seen them, have those injuries differed on a person as far as cuts and abrasions from glass or broken plastic?
Yes.
When you were considering excluding car impact or collision as a source of Mr. O'Keefe's injuries, did you consider whether or not Mr. O'Keefe could have been struck on the side of the car in a clip type event rather than being run over?
Yes, I considered multiple scenarios.
Had you, or do you agree that injuries from a side swipe or from a clip could be much, much different than a full rear or front impact being run over?
They could be.
Did you do any study in this case when you were thinking about excluding the car collision or impact as the source of Mr. O'Keefe's abrasions, about what his body posture was, how he may have hit a motor vehicle? Did you consider that?
I considered several scenarios,
And when you
several different positions.
And when you considered that, what did you conclude as far as Mr. O'Keefe's body movement at the time of any potential impact?
Oh, first of all, I didn't see any medical evidence that there was an impact. There were no significant injuries from the neck down, no fractures, no bruise, no internal injuries, no lacerated organs, no collections of fluid in the lung cavities, the abdominal cavity, no significant injuries from the neck down, and so yes, I used that and tried to put that in a scenario of his various positions. What could he have been? Standing, kneeling, sitting, lying down on the ground. I did all that.
You were a police officer before you went to medical school, weren't you?
Yes.
You had arrived at scenes of many, many car collisions, hadn't you?
Yes.
What is oftentimes left behind after a car collides with an object?
Debris.
Debris field, yes? Did you look at the debris field in this case?
No.
In the cases that you went to wherever you saw car collisions, some of the debris that you would find could be broken glass or broken plastic. Isn't that fair to say?
Yes.
And when you went to those scenes, you would often find broken glass or broken plastic in a debris field near where the victim was found or laying. Isn't that fair to say?
The debris field would be usually near the collision, if there was a collision impact.
And when you were considering excluding car impact or collision in this case, did you take a look at the entire debris field to determine how close or far it was from Mr. O'Keefe's body?
I couldn't tell on
Did you
the
ask any
photographs.
question? I'm sorry, please finish.
I couldn't tell from the photographs.
And before you came to your conclusions, did you ask anybody for any more information so that you could make a fair assessment of that information?
The injuries here were so characteristic that, and they were so parallel to one another that I couldn't even imagine pieces of glass or plastic or even metal lining up to cause those injuries, lining up in a certain fashion to cause those regular striations.
Rather than imagining, did you make any effort to actually seek information so you could identify and evaluate the debris field around Mr. O'Keefe's body that morning?
I did not.
Have you ever, as a police officer looking into car collisions, ever hear the term knocked out of one's shoes?
Not as a police officer.
Have you ever heard of that as a medical expert?
I've heard of it as a civilian. Yes, not as a medical expert.
Can I have Exhibit 74B, please? In your study, before you gave an opinion excluding an impact or a collision as the cause of Mr. O'Keefe's abrasions on his arm, were you aware of this photograph where Mr. O'Keefe's sneaker was found on the side of the road?
I am aware that that there was one shoe off. Correct.
Were you aware that it was wedged right up against the curb? Were you aware of that?
I'm aware. I have been aware of that. Yes.
And when you came to your conclusion that you offered that the injuries are not consistent with a impact or car collision, was this photograph part of your consideration?
No.
Could I have Exhibit 99D, please? In your study to give an ultimate opinion, where you suggest that a car collision or impact was not the source of Mr. O'Keefe's arm injuries, were you aware of this photograph of Mr. O'Keefe's hat found at the bottom of the snow in the corner of that yard?
No.
Do you see underneath that hat there was not 2 inches of snow? It looks like dirt and grass.
Yes.
When you gave the opinion that he was on 2 inches of snow, would it be important to know whether or not he fell directly on the hard ground or on snow?
It could be important. However, it could be if the ground was frozen. If it wasn't frozen, it could matter a little bit.
Exhibit 73, please. When you were reaching your conclusions, you said you considered some of the debris field. Did you see this photograph of a piece of taillight that matches the defendant's taillight of her SUV? Did you consider this piece of evidence that was found in the debris field?
Not specifically.
76A, please. Same question. Did you consider this piece of the debris field when you were coming to your conclusions that you offered us yesterday?
I considered that there would be several pieces of metal, plastic, or glass at the scene.
Did you consider this picture of plastic from the defendant's rear taillight found at that scene? Did you consider that before you gave your opinion to the jury?
No.
You can take that down, please. Would there be any significance in your study in the foundation of your opinion that a collision or impact did not cause Mr. O'Keefe's wounds on his arm? Was it important for you to determine whether or not the taillight to the defendant's Lexus was broken early that morning?
I think there needs to be more to the question.
Okay. When you were considering potential causes of injuries, did you know that the defendant's Lexus rear right taillight was broken and missing pieces?
Yes.
Was it important to time when that taillight was broken?
What do you mean by time?
You understand that Mr. O'Keefe was found on January 29th, 2022, yes?
Yes.
Early morning hours?
Yes.
When you were making your differential diagnosis, was it important for you to learn whether around that time the defendant's taillight was broken?
It was important to know. I still don't understand the question. I'm having a trouble understanding the
It's
question.
my fault. I'll try to ask it a different way. You were considering as much facts and information as you could to give a solid opinion in front of this jury, weren't you?
Yes.
And you ultimately have offered an opinion that the wounds to Mr. O'Keefe's arm are not consistent with an impact or a collision with a vehicle. Yes?
That's correct.
You know the vehicle in question in this case is the defendant's vehicle, her Lexus.
Yes.
And you learned that her right rear taillight was broken and missing pieces, yes?
Yes.
Did you want to know if there was any evidence depicting when that taillight was broken in considering this conclusion?
Yes.
Did you know that there was video from 5:07 a.m. showing that the defendant's taillight was missing pieces?
Objection, Your Honor.
I'm going to allow that.
Not at the time, but I expected that if there were a collision, that there would be pieces of the car, involved. So it didn't really make any difference.
When you were trying to rule out a collision between Mr. O'Keefe and Ms. Reed's vehicle did not cause these injuries, did you want to seek that information about the broken taillight and date and timing?
A broken taillight in and of itself could not cause those injuries. There would have to be multiple projections from the vehicle that were lined up in certain pattern to give those parallel marks all in the same direction. So, that's why a broken taillight could not have done that.
So you, in your investigation, you did not want to know when that taillight was broken?
Oh, I did, but for information only.
Did you review the ring video from 5:07 a.m. at Meadows Ave?
Later on, later on in the, not initially when I had the initial records, but later on I did.
Did you have that information before or after you arrived at your opinion?
Oh, after.
So you had already arrived at your opinion, then you received new information, which was that ring video, correct?
And it confirms, yeah.
And then you received more information. Did you receive photographs from a dash cam during a wellness check showing the defendant's Lexus missing pieces of her right rear taillight at about 8:03 a.m. that morning?
Would that be? I'm not sure which video that is.
Well, it's not a video. If we could put up Exhibit 10. It actually was from a video. Did you look at this picture during your differential diagnosis?
I think I've seen that picture before. The car, the vehicle parked. Yes.
Exhibit 11, please. Did you consider this picture in your differential diagnosis?
I didn't. I don't know that I ever saw this picture.
Seeing this picture, do you see that the right rear taillight is missing pieces?
I can't even see that. Oh, yes, I do see that. But again, these pieces would have to be lined up in a certain configuration in order to cause those wounds.
So seeing this photograph now for the first time, it doesn't in any way shape or change your opinion, does it?
No.
You had, as a police officer, when you're excluding the source, and in this case, you're saying the cause of Mr. O'Keefe's scratches on his arm could not have been from a collision. Do you listen to witness testimony or do you review witness statements?
Objection, Your Honor.
I'm going to allow that. Just, do you do that?
As a police officer, in investigating a car accident, is that what you're asking me?
Yes.
Did I listen? Did I take witness statements?
Yes.
Yes.
And do you value the statements as part of your analysis?
I give varying values depending on what I believe to be the veracity of the witness.
Have you listened to the statements of the defendant herself in this case regarding potential impact?
No. What do you mean?
Well, have you seen any statements made by the defendant to any media about potential impact or collision in this case?
Oh, are you referring to what you've asked me previously about? Did I hit him or something of that? What do you mean specifically?
Have you seen any of the media statements by the defendant, 2020, Nightline, docuseries? Have you seen any of these statements in your analysis of whether or not there was a impact or collision between the defendant and her Lexus and Mr. O'Keefe? Have you seen any of those?
I did see some statements, but that was after I rendered my opinion.
And some of those statements, after you rendered your opinion, did some of those statements come from the defendant herself?
Yes.
And when you listen to those statements, did you hear any of them talk about the idea or issue of collision or impact?
Yes.
And when you listen to those statements after you formed your opinions, did in any way change the analysis of your opinion?
Absolutely not. And I'll tell you why.
Please do.
Because she had, the defendant had undergone a very stressful event, finding her loved one in the snow. And so after a stressful event, many people suffer from what's called an acute grief reaction. It's very common. And they do things that seem to be irrational. They ramble. They act bizarrely. They make statements that are irrational, that don't make sense, and they oftentimes tend to blame themselves for whatever has happened. I've seen this many, many, many times in the emergency department.
Does this happen moments after a stressful event?
Oh, yes.
Does it happen months later when you go on 20/20 or Nightline?
I've never seen that situation.
No. Does it happen a year later when you go and speak to documentarians and be interviewed? Is that the same kind of condition you see a year and a half later?
A grief reaction can last years. It usually is very brief, but it can last years.
Now, when you looked at the clothes in this case, Mr. O'Keefe's clothes, you are aware that those clothes were swabbed for DNA traces, aren't you?
Yes, I'm aware that some of the clothes were swabbed for DNA.
Could we have exhibit 147B, please? On the right arm, there were a number of different tears in that fabric that you looked at, weren't there?
Yes, there were a number of small round holes in that
You're
fabric.
aware, aren't you, that those holes were swabbed for traces of dog DNA?
Objection, Your Honor. I'd like to approach, please.
Okay, come on up.
All right, I'm just checking in with everybody. Is everybody okay? How's the fam? How is everybody? Doing good, Tater? I'm okay. I'm over this. I feel like I'm scared we're going into another mistrial. As I feared. This is a long time to deliberate. I get that there's a lot of evidence, but it's not complicated evidence.
Powerful evidence that the Commonwealth has to undermine this idea that the linear superficial abrasions on John O'Keefe's arm were somehow caused by a dog. They, on their case in chief, tried to create impressions about.
I mean, it's just very frustrating to just keep looking at a fan with like not any noise. They didn't turn on the Zoom meeting, so there's just like nothing. I can't really let you even look at an empty courtroom. But I mean, you guys don't want to look at this instead, do you? I mean, we can talk. I mean, we can hang out. I think we need a little bit of a song, maybe something. Yeah. I mean, this is ridiculous. Without the Innocence Fraud campaign, they would have been out hours ago, I think. This is just, we wouldn't be here. We wouldn't be on trial too. Let's face it. What have we played today? Played that. Maybe this one?
I'm a tiny man, bark as bad as my bite. Got hundreds of ways to fool you. Hold my killer client tight. Cheat to win only increases my popularity. Stalk and shout around the courtroom like a Matlock parody. I'm a lawyer, a criminal lawyer. Think like a criminal, spout legalese. Lying by profession. When in doubt, blame the police. When my con gets exposed, I act deaf and dumb. Blame sudden onset amnesia. Got the press under my thumb. Drinks with my killer client at Smith and Walensky. Check paid for by fans. My elbow on the killer's knee. I'm a lawyer, a criminal lawyer. Think like a criminal, spout legalese. Lying by profession. When in doubt, blame the police. When my con gets exposed, I act deaf and dumb. Blame sudden onset amnesia. Got the press under my thumb. Drinks with my killer client at Smith and Walensky. Check paid for by fans. My elbow on the killer's knee.
Okay. James on X is telling me I was a juror in New York City trial for second-degree assault with a deadly weapon, iPhone recorded midday, downtown, older Asian man brutally beat and kicked by Venezuelan illegal. The deadly weapon shoes. After holding the shoes and video rewatches, we convicted. It took longer than expected. Yeah, it does take longer than you expected. Like I said, I was on a child sexual abuse case. Girl was abused by her relatives, husband, from 4 to 8.5. And we all just wanted to talk. And there was one holdout, one woman holdout. And then, you know, so it does take longer than you expect. You do want to talk because you've been all pent up about everything. And they've seen a lot of witnesses. But this is, come on. Let's get a verdict going. I mean, what we're looking at here, this is what we're looking at. Yeah, we're going to 3:27, so we're getting close to the time that. Yeah, so much for the jury to go over. But come on. I mean, the judge has just made a mockery out of this, getting rid of this expanded buffer zone. She's done everything to help Karen Reed get off. Yeah, I mean, it's not looking good for acquittal either, but it's not looking good for this isn't looking it's not looking good for we all think she's guilty, let's go verdict either. There's obviously some kind of holdouts. Did Karen Reed get a stealth juror in there? That's what we want to know. Oh, look at this. So she's asking that everyone not clap. Wait, you got to see this. Got to see this post. Karen and her team are asking when they enter and exit the courthouse that everyone remain silent. Please stay on the sidewalk and clear the way for pedestrians. No yelling, clapping, and whistling. Sometimes silence is more powerful than words. So when they enter and exit, we will all haul up the American Sign Language, meaning I love you. Oh, my Lord. I love you, murderer. Yay. I hope you will murder my family member. Oh. So sick. We're in such a sick society. I don't know what's gone. I mean, even if you go back to Ted Bundy's trial, those women were like, he's scary, but I'm here, and they had this kind of a odd thing that they're all sexually attracted to him, but they're like, it scares me, but I'm here. And, I have to be here to watch it. This trial, there's something about this case that scares me that I'm drawn to, but this is like full out a hero worship of Karen Reed. It's really unreal. All right, back to the trial. Does anyone have anything anything interesting to say? Should we start asking Chat GPT? No, thanks. Chat GPT can't take in the innocence fraud campaign, and that's key in this. It's a key ingredient. I'm not sure when they're done, Laura. Honestly, I'm confused about their time schedule. I thought they were supposed to stay till 5:30 on Friday. They asked to leave an hour early. I'm not exactly sure. I assume till 9 to 5, but I don't know.
About the cause of the abrasions to Mr. O'Keefe. The defense does not get to pick and choose what words the Commonwealth can or cannot use. They do not get to pick and choose what parts of Dr. Russell's opinions are important and not important.
You want clips? I think I might.
And then she sends this. Hey guys, without me saying too much, it is very unwise to assume that this death was not planned. The defense has more bombshells. So did Natalie write that? I don't know. Teaching John a lesson was the plan at a minute.
That's Turtle Boy gaslighting his audience. Sorry, guys. Sorry about that. I try not to clear my
minimum.
Oh, is that all that is? Hold on. Let me see. Let me see what else I have. There's one. There's one. Let me see what else I have.
My name is Karen Reed. I'm 44 years old. Now I'm being charged with murdering a Boston police officer. I could face life for second degree, life in prison. I still can't believe what's happening to me.
And so, did you drive your car into John?
I did not drive my car into John. Didn't reverse it. Did not hit John with my car. This is my version of testifying. Doing this film is my testimony. This has happened to me. And, you know, I know what happened between John and me. I know the events of that morning. I know what I said. I know what I didn't say. And I haven't been able to say it. It's incredibly frustrating.
So, did you drive your car into John?
I did not drive my car into John. Didn't reverse it. Did not hit John with my car.
Is there any chance this was an accident?
There is zero chance this was an accident. There was zero chance John was hit by a vehicle.
You're tired of it. You've spent so much.
No,
I have to
no, I'm not tired of it. I hate answering it because I feel like I'm being so scrutinized. Like, did she blink 3 times or twice? And did she like smirk or look to the right or down and up and left and whatever? And like, it just feels so fake, even though it's true. I rather like explain everything else and like, I did not hit John with my car. Like, I can't make it sincere enough. I hate saying it.
And then she sends this. Hey guys, without me saying too much, it is very unwise to assume that this death was not planned. The defense has more bombshells. So did Natalie write that? I don't know. teaching John a lesson was the plan at a minimum.
It's impossible for me to have any sympathy for any of these witnesses. Definitionally, is it harassing witnesses? Yes, they're witnesses against me in my prosecution. And is he yelling things at them? And is he going up to their front doors and ringing the bell? Yes. But they shouldn't be witnesses. They should have been suspects. So it's not cut and dry. As you come down Fairview, there's a bit of a decline and it curves to the left. And my eyes are peeled. And I said, he's right there. I jumped out the passenger side and I fell into the street. His eyes were shut and he had spots of blood in different areas on his face. And he was still, not stiff, but still. As soon as we approached the property, he's right there. He's right on the edge of the property. And I said, there he is. And both women said, where? I said, he's right there. Stop the car.
At the time that she's saying this, were you able to see anything outside of the vehicle?
I saw nothing. So I looked over and I didn't see anything. And I looked at Jen and I said, she's crazy. And I unlocked the door and I sat back and watched. And she ran over to a mound of snow.
They pull up to 34 Fairview, and Jen McCabe says that Karen just darted out of the car. Like, before it even stopped, it was like, oh, there's John. You know, somehow in this dark, we're still in the dark, in a blizzard, Karen is able to spot John's body and run to it.
Karen beelined from the car to jump onto what Carrie described as a hump in the snow by the time they got over there. But from the car, Carrie testified, you could not see anything 8 feet off the street. So that was the moment for me. The first question I had was, how did Karen know where the body was?
I ran over to him and John is perfectly still. His mouth is open a little bit. He's got cuts and blood on his face and he's just wearing the thin clothes he had on the night before. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And I just pulled it. And as soon as I pulled it, it just gushed blood down his face. And he had, his eyes were purple, but this eye was split and it was dripping blood from a cut down his face. And I did try to do mouth-to-mouth resuscitation. I don't even know if I was doing it right, but when I pinched his nose and breathed into his mouth, I could hear gurgling. And my first thought was, he left drunk, he fell, and he's asphyxiating on his vomit. I said, Carrie, roll him over. And she said, no, don't roll him over. What she was implying was he could have like a broken neck or something. So we're screaming at each other. And then she says, shut the up, Karen, shut the up. Leave him the way he is.
That Officer John O'Keefe was found in the snow outside the Canton home of another Boston police officer. 5 Investigates has also learned that Officer O'Keefe suffered head trauma. The Norfolk DA's office announced late last night that state police have arrested O'Keefe's girlfriend, 41-year-old Karen Reed of Mansfield. Authorities say Reed drove with O'Keefe to the home on Canton's Fairview Road early on Saturday morning, just after midnight. It's not clear if it's alleged that Reed struck O'Keefe with her car, but she is now charged with manslaughter, motor vehicle homicide, and leaving the scene of a motor vehicle collision caused.
John and I argued the morning of the 28th, Friday morning. Most of our arguments were about his kids and that he thought I spoiled them. And I thought it was a real low blow of him to get on me for that. It pissed me off. And I said, I gotta Get out of here for a minute. So I came down here to my house in Mansfield.
I think that she was very jealous of the kids. I think that's what they fought about. I think they fought about Kaylee. I think that was really the woman she was really jealous of. Because that was he was going to put the kids way before Karen Reed.
Sat in the other room and I worked remote all day. That day, everyone was getting ready for this massive blizzard, but I realized I didn't want to be shut in here with the snow. I'd rather be up there with John and the kids and doing something fun, and we always had fun on the weekends. And then at about 6 p.m., either I called my father or he called me, and he said, "How was your day? What are you up to?" And I told him what happened. And I hated complaining about John to my parents because they liked him a lot. And my father just said gently to me, "Karen, why don't you stay home tonight? It's gonna snow." But I didn't. Dad, if I listened to you, none of this would have happened. I think I left here in Mansfield at 8:30, and I met John at a bar in Canton, CF McCarthy's, at 9. And then we went to the waterfall right next door to McCarthy's. At the waterfall, it was Jen and Matt McCabe. We saw Jen McCabe all the time. She coached John's niece's basketball team, so we saw her 2 or 3 times a week. And then Brian and Nicole Albert and Brian Higgins were there. My attitude always when I was out and about with John was, he's got to blow off steam. It suits us all if John blows off a little steam, because he always has steam. So I said, sure, let's go. This can't last forever, right? So I'm driving, and John got on the phone with Jen, and he's telling me it's 34 Fairview. And we arrive at 34 Fairview. So when John got out of the car, he took my full vodka soda, which is sitting in the cup holder. And he walked up the driveway, and John always kind of skipped and walked at the same time. He was always in a rush. And I saw him reach the breezeway door, and I waited probably a minute, and he doesn't come. And it only took like 2 or 3 minutes for me to be irritated. So I called him. I didn't want to wait for him to respond to a text, and he didn't answer. I said, "You've got to be kidding me. What are you doing? You just went in and I'm sitting here. Either we're welcome or we're not, but it shouldn't take you 5 minutes to determine that." And then about 10 minutes went by, and I left, and I was not happy. Little did I know, John was not getting my phone calls. And then that was it. The last I ever talked to him was when he got out of my car at Brian Albert's house. So I'm driving, and John got on the phone with Jen, and he's telling me it's 34 Fairview. And we arrive at 34 Fairview. So when John got out of the car, he took my full vodka soda, which is sitting in the cup holder. His mother leans over the kitchen island and says to me, "I think he looks like he got hit by a car. He looks like he got hit by a car."
If you do natural math, there's a point in time when Karen Reed comes home and puts her car in the garage in between those 2 time periods, but there's no Ring camera footage of that.
We know the Ring video had to be deleted because at 12:41, I leave a voicemail to John where you can clearly hear me pull into John's garage. You can hear my car sensors beeping as I come close to the sides of the garage door. Beep, 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 beep. And then you hear the car go off, and then you hear the sled ding, ding, ding as I open the door, shut the door. I had high heels on that night. You hear me walk in, go in through the stairs up into the kitchen, shut the door, and you hear me walk into the kitchen. It's like a full minute long. That's at 12:41. But the Ring video of me arriving home is mysteriously missing. The prosecution is accusing me of deleting the Ring, and we're accusing them. Why am I deleting these videos? If anything, I want the video when I arrive home to show that my taillight's intact. I don't know that it would have captured it, but it could have. They wouldn't want that video in because it would show my taillights intact. So who has a greater incentive to delete the video? So who has a greater incentive to delete the video?
Survey said. Oh! Oh, dear. We almost were going to leave you back there. Because if she'd won.
Voicemails left by college professor Karen Reed for her boyfriend appear to show she was in a jealous rage the night he was murdered. Boston cop John O'Keefe was at a party while she waited for him to come home. The voicemails show her mounting fury.
John, I'm here with your kid. Nobody knows what the you want to hurt her.
The 44-year-old murder defendant made 53 calls to O'Keefe's cell phone between 12:37 a.m. and 6:08 a.m. In this voicemail, she accuses him of cheating.
John, I'm going home. I need to go home. You're using me right now. As a girl, you're a loser. Yourself.
A month before he was found dead, witnesses testified that Reed also accused O'Keefe of cheating on her during a New Year's trip to Aruba. Further evidence their relationship was falling apart. Court TV's Matt Johnson is covering the sensational trial.
The voicemails come across very angry, using a lot of crass language, and they might have been very surprising for this jury that was looking up and then taking lots of notes after looking over at the defendant.
We had an argument on New Year's Eve. We were away on vacation, and he became incoherently drunk. And I ended up ringing in the new year with his niece and nephew. John didn't come back to our room till after 3 a.m. So that was rough. I felt very much taken advantage of. He apologized profusely for what happened on New Year's Eve, and he said, if you can't get over it, then you need to spend some time at yours. I can't keep apologizing. I don't want to keep rehashing this.
Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
Okay, Karen Reed in her own words. Karen Reed in her own words. So what are we at now? Hold on one second. Just going to check on the time.
So at 12:35 a.m., the defendant calls John. That phone call is not answered. 12:34:09 a.m., the defendant calls John. It's not answered. 12:34:38 a.m., the defendant calls John. It's not answered. 12:35:09 a.m., the defendant calls John. Not answered. 12:35:35, the defendant calls John. It's not answered. 12:36:09 a.m., the defendant calls John. It's not answered. At 12:36:39 a.m., the defendant's phone auto connects to the Wi-Fi HatsFam 123. At 12:36:40 a.m., the defendant calls John. It's not answered. At 12:37:08 a.m., the defendant calls John, and voicemail number 1 is left. At 12:38:26 a.m., the defendant calls John. It's not answered. 12:39:03 a.m., the defendant calls John. It's not answered. 12:39:37 a.m., the defendant calls John. It's not answered. 12:43 a.m., the defendant calls John. It's not answered. At 12:41:35 a.m., the defendant calls John. Voicemail number 2 is left. Some beeping noises, appears to be a butt dial or accidental call.
Message at 12:41:35.
Are you saying that Karen made a butt dial? I thought butt dials meant you were guilty of murder. What happened, free Karen readers?
The defendant then texts John O'Keefe at 12:55:31 a.m. on the 29th. I'm going home. The defendant texts John O'Keefe, see you later at 12:55:50 a.m. At 12:58:19 a.m., the defendant calls John. It's not answered. 12:58:47 a.m., the defendant calls John. It's not answered. 12:59:24 a.m., the defendant calls John. Voicemail number 3 is left with voice.
John, I'm here with your fucking kids. Nobody knows what the fuck you want, you fucking pervert.
At 1 a.m. and 26 seconds, the defendant calls John. It's not answered. At 1 a.m. 49 seconds, the defendant calls John. Voicemail number 4 is left. It's 1 second called, no sound. The defendant.
The fan is moving. What? They're back? What do you mean they're back? I don't see anything. I don't know. Let me see. Let me go to a different channel. But I don't see anything going on. No, same thing everywhere. Just a fan. Why'd you say that, Tater? I don't know. Looks like no verdict today. I guess. I don't know. We're waiting. Maybe they'll come in and do it at the last minute. It can happen. Everyone is headed back into the courtroom. Perhaps the Karen Reed jury has a question, or they're calling it quits for the day. Okay, that's from Ashley from the 4th grade. She's a free Karen reader. So I don't know if that's fake news or what. I see no motion. I'll keep you posted, guys. Karen Reed headed back into the courtroom. We're at 8 hours and 48 minutes. Yeah, Karen Reed's back to the courthouse. Does that mean anything, or they just came back for the end of the day? No idea. I'll show you what it looks like. Since, I don't know, who wants to look at a fan? Karen Reed going back into the courthouse. What a zoo Judge Cannoni's made of this trial. Absolute kangaroo court. Court TV clock is still running. Mr. Reed is saying no verdict today. We are all delirious. Yeah. How does he know? Do they have a stealth juror? How does he know no verdict? Don't they have to come in and click out? Been on for almost 8 hours today. Thank you, kitties. Thank you for that's nice of you to say. Oy. All right, court reconvenes, I guess, at 4:20. It's got to be tomorrow, right? They're going to come in and say we got to deliberate some more. And we pray for the love of all psychopaths. Get it right. Common sense, right? Seriously. Seriously, seriously. I mean, people are dragging their children there and dressing them in pink. I mean, it's not a good idea. I'm not going to put on any kind of. Let me just make sure I'm sharing this. But this is Aiden's video, Aiden Carney, who really pushed out this innocence fraud. This is the view from the courthouse.
All right, let's do a quick walkthrough of the crowd, see how everyone's doing.
I can't look at this. I mean, a lot of young people. If you dark personalities, good people have gotten duped. Oh my God, supporting a killer. Yeah, Rita Lombardi, I think you're talking about. That's her. That is she. Are people that lonely to support a killer? Are they? Is that how lonely people have gotten? That's pretty sad. Join a bowling group. I don't know. Join something. Join something else. Yeah, I was just watching. I am going to cover the Donna trial. I was just watching she's trying Donna Adelson. I was telling everyone this morning I had a dream about Donna Adelson last night. She entered my dreams. Donna. Oh, it's terrible. Terrible, Donna. This isn't about the case, Donna. Unreal. Anyway, she's trying to get it moved. It didn't work for any of the other defendants in the case who are now convicts. So I don't know what she's thinking. I don't know. Maybe a little music. I don't know. I need a little cheer up. Sorry, guys.
Everyone is waiting for me to arrive at the bar. At home in Mansfield, I'm making up a new co-star. His name is Richie the plumber. No hot water, it's a bummer. It's all a figment of my imagination. Call it a lie, I feign rightful indignation. Call the plumber, I got a rusty pipe. Hot water is not working, I'm starting a fight. Sure it's a lie, but it's a little one. Gotta get my boyfriend under my thumb. John says he and his papa would have fixed it. If only this broken pipe in real life existed. Causing pain and suffering is what I do best. Putting my boyfriend's patience through test after test. Richie, my imaginary plumber, is at Home Depot, hoping that story will get a rise out of my boyfriend and his libido. I'll arrive at the bar showing up late, make him angry right out of the gate. He's slow at feeling lovey-dovey, I'm downright twisted and scummy. I'll down many drinks and run him over after it gets late. Scream and cry, it's you, John, who I hate. Leave him to die in a blizzard, inflicting pain, I'm a wizard. Get Jen to call 911, have the whole town pointing fingers when it's over and done.
Okay, back to the fan.
Give us sort of a walkthrough of what you find interesting about the charges and what you think the biggest challenges are to the prosecution and the idea of, I mean, finding her guilty beyond a reasonable doubt. These terms get thrown around and it's the judge is trying to make it clear what exactly reasonable doubt means.
Lawyers know, and really even lay people, it's a really difficult kind of concept, even in the way the instructions are read. It's not proof beyond all doubt, but you have to have a reasonable moral certainty. And so what does that mean? That's different for every person, right? Every juror. And that's why, all of these individuals come from different backgrounds, different educational experiences, different socioeconomic statuses. They take into account, different factors. And that's really what, the benefit to our jury system is that you have a number of people who, might feel differently. Their gut reaction to the same piece of evidence, you might have different jurors who feel differently. And ultimately, what they're going to do when they go back after they've just received their instructions, and that's on second-degree murder, manslaughter while OUI with the lesser includeds, and leaving the scene of personal injury or serious bodily death, serious personal injury or death, what they will do is sit in the room and go through the elements that are necessary to prove these charges. For second-degree murder, they have to prove that John O'Keefe was killed by Karen Reed and that she intended to act recklessly, which was the reversing of the car, that a reasonable person would know was likely to cause death. In the manslaughter, essentially what they have to prove is that she operated a motor vehicle on a public way, she was intoxicated, she acted recklessly, and then she caused the death of John O'Keefe. And in leaving the scene, they have to prove that essentially she knew that she hit him and chose to leave him there and didn't tell anybody. So what each of the jurors will do is they'll go back into the room and they'll weigh, you go through one by one the elements that need to be met for each charge, and they figure out, have we proved all of them? Has the Commonwealth proved all of them? I think things like operation on a public way, likely intoxication, probably even reckless or negligent are proven. And ultimately, the prong that is the most important in all of these charges is, did she cause the death of John O'Keefe? That's the one that really is the most difficult to prove for the Commonwealth. So we'll see, we'll see what they think.
Yeah, no doubt that in the closing argument today by Hank Brennan, he tried to talk about intent, saying that she was super angry, that this was a relationship that was in tatters. He also pointed out that some of the testimony from John O'Keefe's niece, where she said that there had been arguments at the house where John would just sort of walk to his bedroom and try to get away, and she would come pounding on the door, that on this particular night that she wasn't going to let the argument be, and that she decided to go back to the scene.
Back in session, you may be seated.
All right, jurors, we appreciate how hard you've worked today. It's been a long day. I'm going to send you home. So I do have to give you those cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Be careful with your social media use. And I think what's a good idea to do is when you leave here, just leave the case here. Literally, figuratively, just clear your heads. Beautiful day, get some fresh air, and we'll see you tomorrow. Okay? Thank you.
All rise for the vote, please. Jurors, call me.
Okay, that's it. No verdict today. No verdict today. Magic 8 Ball did us wrong, did us dirty. They said it was likely so. That's it. Yeah, I know. So we may be headed into another. It's looking unlikely for any kind of acquittal. This is bad for an acquittal. It's not great for a guilty on all counts either. We may be going in, as I predicted, into another hung jury. I mean, that's what I kept saying. Are we going to get another hung jury? I don't know who's on this. I hope not. I hope not, but let's hope someone bends. This is a case where you have really strong opinions on either side. The crazy pink people, go away. I mean, Judge Canoni has made this as about as difficult for the Commonwealth as she could. I don't know why the free Karen readers don't love her. They loved her the first time. So they're 8.5 hours in, 9 hours in, something like that. It's a lot of evidence to go over. I don't know I can't even say. You have faith? Good. I love that we have still faith. Amy says we'll see a verdict tomorrow. Okay, I love that positivity. I'm feeling a little run down. I don't know what's going to go on. I don't know if I'll be back. Maybe at 6. All right, have a great day, everybody. I need a break. Okay. Yeah, I am. All right. Have faith, everybody. Keep positive, just to keep yourself sane. It seems so obvious, that's what's so hard about it. It seems so obvious, but like I said, I'm glad I wasn't taking part in my jury in turning one person who misunderstood the evidence seriously. All right. Have a great one, guys. All right. Please support this stream, the channel. Links are in the description of this episode. Hope I put them in. If I didn't, I will in 5 minutes. Have a great night, everybody. I'm going to take a little rest. Okay. Yeah, this is stressful. All right.
I hit my boyfriend with my car. It wasn't an accident. But with lying lawyers, I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system I clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen. Like John, you were my mark. My innocence fraud campaign is my biggest hit yet. Yeah. I hit my boyfriend with my car. It wasn't an accident. But with lying lawyers, I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system I clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen. Like John, you were my mark. My innocence fraud campaign is my biggest hit yet. Making money, truth is my second victim. Carry, Jen. Like John, you were my mark. My innocence fraud campaign is my biggest hit yet.